Good morning, everybody. I made it. I made it in time. Like, we still have 6 minutes, but I didn't know. I did not know. You ever have just like one of those days where nothing is cooperating? Like the coffee pot, the dog, like everything. But here I am, coffee in hand, ready to go. Got our bingo link up. Good morning, Rocket, if you're still there. I see. Morning, Michelle. Michelle, how are you? I gotta put some coffee in the chat. I must admit, my voice is sounding a little even rougher than yesterday. I think by tomorrow, I just won't even have a voice, you know. I don't know. Whenever I stream a couple of days in a row, this is what happened. This is good morning. Very bright and early morning for you, Mandy. Hope your swim was good this morning. You're having a meh morning? I'm having a like, oh my gosh, everything's in my way kind of morning. Coffee. Oh. You're not drinking coffee anymore, are you? All right, let me get this stream up because it's time. Oh, let me look. Which one did I use before? Okay, was it this one? Oh yeah, so we can hear the sound. I'll be a little. How's the sound coming through? Man, it's dipping. It better behave. You were just okay. I was just watching a thing about a VTuber that had a pedo email them, and it gave me nostalgia for when Jason Mathers was still resident. Wow. Oh, it's only 5:56. Oh, maybe you're just getting ready. I don't know why I thought you would be in there all right. But it's early, isn't it? I'm gonna try True Live this morning. Let me get this night live. Their stream's been good. You know, and they're lovely people.
We can do that one. And if it's not good, like first thing. Okay, so today, today's going to be like a very strange day because the defense is supposed to rest, but we know that they're going to first put in the no contact evidence when George had the no contact orders, because they said since the doctor talked about um, since ADA Will J brought up with Dr. Harper using the legal system as retaliation, they want to show that George did it too, back and forth, using the no contact order as some kind of retaliation back and forth. I do remember reading there was an incident where when there was a no contact order, Sarah actually went to the court, to the judge herself, because she wanted it amended. Um, George was actually at her house. She was the one that invited him there. She went to the judge to say that she wanted the no contact order to be amended. Something about just like not bad behavior, like just don't hit me, but she still wants him there. She wanted him to like do like a no bad behavior order, which they don't do. And they talked to her for a little bit, and they got some information from her, and the next day they just dropped all the charges. um I do believe it, this does happen, you know. Wait a minute now, why is that still showing up like that? It should not. Why is the red still? All right, there we go. And nope. Okay, I don't know if I'm going to be able to keep that feed up then. All right, let's go. Okay, so is the sound going in? Hey, Mouse. You're going to be back later, Mindy? You're going to be listening? Okay, have a good one. Good morning, Karen. Yes, you're grabbing cheese, Mouse. You're having some coffee with your cheese. I'll give you some more coffee. There should be plenty in there. Anyway, before you run off, if you're still listening, Mindy, I wanted to tell you the other thing they're going to do is an in-chambers meeting requested by the state to check out what's going on with the defense in regards to payment, because apparently there's some rumors going around that James Owen has made a media deal for after the trial, which would be against the Florida bar law. He can't get into any deal like that if he says he's pro bono until afterwards. It can't be for the services. Okay. Um, so they're going to talk about that, but it's going to be private. We're not going to see it. So I don't know if they're going to keep the feed up and they're just all going to go in the room or what. I doubt very much we're going to hear any of that. But there's stuff back and forth. Apparently it came to light because of the extraordinary travel expenses that are going back and forth, especially with the hurricane. Sarah has been listed as indigent. James Owen filed paperwork to confirm that when he came on, claimed her indigent again, claimed himself pro bono, and the JAC is paying some of the expenses back and forth for these attorneys, just the due process expenses. Okay. But Florida state law does, the bar actually has some regulations against what can and cannot be paid for. We know that James Owens, the defense team has gone out of their way in regards to the clothing that she's wearing for this. I don't know. They're just putting it under review. They don't want a problem. They don't want everything to be turned over. I don't know if somebody contacted them with information or what. It does not say. Okay. And we'll just have to go from there. I will drop a link to the document if I can into the chat in just a few moments, because I don't have Discord up on the PC. I'm gonna have to grab the phone and do some tech magic. You know what that is, right? Rapid Cash. I gotta do some tech magic to go and just find some links and do that. Morning, Charlie. No, she's not. That's the problem, Charlie. If she does get found guilty, she's not allowed to profit. But in order to pay her attorneys, are they allowed to profit from a media deal? I do not know that much about the law, but I did find the statute. I did find, the statute that talks about like the fact that they can't have the media deal. Mm. The fact that this is there's no sound at all. It's not like Law and Crime where I can hear the static from the judge's button, but I don't hear anything from this feed, and that's got me concerned. Because I see the judge. I'm pulling up. All right, before I get to the links, I'm pulling up the other feed. I don't know why. I just got, I'm just panicking myself. I realize there's probably not an issue, but I don't want to miss even a second. Hold on. Don't panic. I did that on purpose. Because there is the white noise on this one. And I don't know. I've become dependent on the white noise, I guess, that I know when the judge is here or not. White noise. Okay. I don't know. I just feel a little bit better for some reason. I just, okay. Let me get that link now that we can hear. As soon as he comes on, I'll put that back on full. All right. So, any of you that are in the library, you may have already seen this morning. But for those that aren't, let me go to the Boone room and get you this lovely stuff we found last night. All right, let's see if this works. Okay, I got that one over there. They're still not talking yet, which is good.
Case number 2020-2603, State of Florida versus Sarah Boone,
And
for the record, we get from the state.
we are on.
State, William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, ma'am. Could you state your name and date of birth for the record for me? Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table, buttressed by her attorneys wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel?
No, sir.
Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated.
Okay.
One is, you can walk in closer than
Right now, their ID is AB as in boy and EC as in.
defense gets identification AB, Judge, which is.
Okay.
For
Here's the document.
June 16th, 2009.
It should be open. And here is the Florida statute if you want to read about that. Hopefully they're both okay.
I'd like to introduce some the evidence, and then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Want to do that now before we bring the jury in?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
So, subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So just be advised, we'll use our time accordingly.
That one was the 6th.
I don't believe so. Give me a moment, I can check. That is an alternate. It's alternate in seat 4.
Thank you.
Defense, do you have any motions?
Just out of abundance of caution, I would renew our motion for judgment of acquittal. Pursuant to defense resting. We'll do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty, and there is sufficient evidence for that to be sent to the jury.
Okay, thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the 2 no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
No, the defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now. Is there anyone else? The email correspondence that I have is Mr. Owens' email, Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay. All right. Very good. All right. Can we go ahead and bring in our panel? State.
Oh,
Defense?
Yes.
All right, let's stand and bring in our panel, please.
I can really hear the steno clicking this morning, like loud. Did you guys hear it? Yeah. Mm. Sounds good, Mouse. I could go for an ice cold, like an iced latte at lunchtime today. Like I'm gonna need it. I'm gonna have a busy day today. Anyway, the links, I think the links are good in the chat. One is the Florida statute, the Florida bar statute in regards to private deals and stuff like that. And the other one is the actual motion that the state filed to have a, what they call in camera, but it will be in judge's chambers. There will be no camera. We will not get to see. In camera meaning like, let's just take everything out and look at it. It's an odd term, but that's how they're using it. But it doesn't mean we can see anything.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury.
Yes, I do.
I thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning. And then we'll go from there. Okay. All right. Thank you very much. Mr. Owens, you may proceed, sir.
Look, at this time, I would move to introduce defense identification exhibit AB and evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
So at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
The first is defense Defense Exhibit 19, let's just review it, pass it down. Next document is Defense Exhibit 20.
Okay, good morning, Sue.
Thank you, members of the jury. Yes, sir. Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you. Defense, or state, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
State of Dr. Tanya Warner.
This is the rebuttal witness, the psychologist.
You swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. I do.
Doctor, good morning. Could you state and spell your name for the record for us?
My name is Tanya, T-O-N-I-A, Warner, W-E-R-N-E-R.
All right, thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
And when did you begin your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
In 1996 in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have,
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit into any of the categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them, another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought. Is it fair to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different, and so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access to funds, so they can control them in any number of ways.
Is this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having this syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And can this element of control come from controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
Did the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yeah.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transitioned from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right, is it all right if I refer to my notes just to make?
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there. And completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother, and according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store and continued to drink. And then they were inside the house, and then he, I guess, tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing, and she zipped the suitcase up, and they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her, and she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
If it refreshes your memory, just
Yes.
put them down and then tell us what you remember.
She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out, and her son's baseball bat was sitting there, and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to you a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
It can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking, it is important as an evaluator to get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about
People could approach the bench.
Yes.
Okay. All right. I would imagine that the defense does not want a lot in there about the alcohol abuse and how much actually she had been drinking. I like this witness though. She's very clear. Her voice is very clear and picking up on the mic like really well. She has a different approach to explaining it. Julie Harper was excellent explaining everything yesterday. Tanya Warner seems to have a little more direct experience in regards to working with the actual legal system, with BSS defense, and with the information. She did counter with one thing that Julie Harper had said there was no standard, and yet Tanya Warner says there is like an acting standard between the professionals in regards to BSS. And I wonder if they're going to explore that a little more later, because they didn't say what that standard was. So far, I don't see a difference of an opinion, except for just actually focusing more that the same thing, if Sarah would qualify as this diagnosis of BSS, then perhaps George could too. Again, reiterating to the jury that it could go both ways. Yeah, no PTSD. I mean, yes, and that is in direct contrast to what Dr. Julie Warner said. Okay, so it's going to be, a lot of times we've said from the start, this comes down when it comes to this defense. It's going to be a battle between the experts, state and defense. They're going to have, obviously they're coming from different angles on it. And we'll see. For Julie Harper from yesterday, remember she saw Sarah more than once. I think, what was it, 8 times? Did they say 8? I had thought it was only 5 or 6, but now I do believe yesterday I heard 8. And I'm wondering if, the Dr. Warner had already said that in using diagnosis, PTSD would be the closest thing to BSS. And if they don't see the PTSD, how would there actually be BSS? My brain just immediately went there, but I'm not a medical expert or a legal expert. I'm hearing it the same, the same with you guys. In my opinion, Dr. Harper was a neutral witness. You know what? After the cross from Mr. J, I would agree with you, Charlie. I would, because they were able to elicit more information out of her that actually made that whole testimony more neutral to both, and he really represented George there very well in regards to this could be him too. All of these things that you're saying, they apply to the victim, to the deceased. A personal opinion matters, Mousy, especially personal experience. Remember, we have many people go come to the chat here, and especially in regards to this case, that it's very difficult because they are previous domestic abuse survivors. They are survivors of domestic abuse, or they are advocates, or they work in the system some way. And everybody comes at it from like their own personal experience, what they've been exposed to, and their opinion on the matter. And, all of it valued. And here, of course, everyone's voice to be heard. She's very professional, very patient. I wish, they did bring her water. I was going to say somebody needs to bring her some water. Well, there's going to be a lot of heated here. They're going to get into deep water. When they've got conflicting information, remember, it's a matter of control of the information. When you get into, a courtroom, and you've got the state and you've got the defense, and they're both at all times trying to control the flow of information to the jury to paint their side in the best light possible, to the points that they're trying to make in the actual paint the picture that they want the jury to see. And it's all about the control of information. So that's what the objections, the sidebars, the I don't want you to enter that, you can't do that, back and forth. What did you guys think about the no contact orders entered in there? It was very important to the defense yesterday to get that in. Julie Harper had opened up the door during, actually Julie Harper and Mr. J had opened up the door to that, based on the fact that Mr. J had asked her if using the legal system against one's partner could be abusive, was a form of abuse. And she said yes. And so they want to show, yeah, George is abusive too. We've got no contact orders here that he violated or that were installed at his request. Mr. J had brought it up because Sarah had called the cops on George numerous times, but had always went and bailed him out, brought him back. And in this instance with the no contact order, there was a no contact order put in place after one of their incidents. Well, then she asked him to come back to the house. And then they had to go to court, and she had to explain the scenario, and she asked the judge to amend the no contact order in her preference, but they can't do that. It's all or nothing. And then the very next day, the state dropped the charges against George. I think we're going to have a lot of sidebar today. We're supposed to have jury instructions later on after rebuttal. I do not know what other witnesses the state is bringing forward today. I know this was the primary witness in rebuttal. Remember, rebuttal is only any window that was opened or anything that they want to contest in the testimonies of the defense after the defense had put up their case. But it has to be about something that was brought forward. They can't just like, bring them back and do a fishing expedition or free nilly, anything new out there. It's actually rebuttal, meaning it goes again, to either impeach a witness, to get more information on a witness, to explore a topic that was brought up, or something that was alluded to during the testimony of any of them, or to actually go against something that they presented, like bringing this witness forward to actually counter Julie Harper. And I don't want to say counter, they're in the same field. They're going to be talking pretty much the same about it, but they're going to have different opinions and perhaps a little bit different take on it. So it's not really a counter. It's more like additional information with a slightly different view, Yeah, I think Julie Harper had said yesterday it's very difficult to get all of the information from actual survivors of abuse. They're not willing really to talk about it. They'll do everything they can to actually avoid. Sarah does not talk about the alcohol. She does not. She's very uncomfortable, you can see, whenever the alcohol comes up. It took a long time in the investigative interview at the Orange County Sheriff's Office for her to even state how intoxicated that she was. She actually denied drinking. I wasn't drunk. I don't like to lose. I don't know. She denied it a lot.
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next.
Okay.
So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
Okay, I wonder if he's going to stay on mic once the jury leaves. That will change what we do here. If they go silent again, we'll just think of other things to talk about together, huh? We'll have more coffee and a little chit chat.
Y'all can be seated. Thank you. Mr. Owens, if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every opinion she was going to express. It started on page 37. Line 24, as it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. Mm-hmm. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes, think about it, and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnosis after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on page line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens. I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay. The witness starts on
I
line
love this
15.
judge.
So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission. But she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to dispose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she Page 43, line A, she said she said she has narcissistic personality disorder traits. Or I asked that question, no? That's how she answered. She goes through a little bit of that. And then she, paraphrasing, she talks about the grandiose component of criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer, right up to her, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
Excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
all right, page 46,
Oh,
line 1, question, okay? Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19, no. I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question, is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question, okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47.
There it is.
Yes.
he's upset they weren't notified when she formulated her opinion
That's
solidly
specific to
about the
post-traumatic stress
PTSD.
disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection?
I love when
What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection? I understand the backdrop.
Judge has no patience when he needs to tell a lawyer how to lawyer.
Other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then My position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the evaluation.
Okay. Unfortunately, that was not the answer that came from the witness. The answer was a definitive no.
Attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not apply.
That's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
Can I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Yes. Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
Oh, that takes a lot of nerve, doesn't it, people?
What is the legal opinion?
Discovery violation?
The
Wow.
post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did.
That's not-
That's what experts do.
I would like to have known that, and that was going to be her opinion before today.
If you read the deposition, that was the
That's
great
not a
risk
change
of
in
it.
testimony. That's-
Where is that a change in the deposition?
That's right.
I asked,
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
give me a minute, I'll read through it and find where I asked her.
This is.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing.
Exactly.
So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20. Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12. Question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely. Of course.
Wow. You can unmute if you'd like, Granny, while they're quiet. I don't know about you, but this is rough for me. This defense really tears me up, this guy. I need a new bingo square. Attorney throws a hissy. I didn't read the full deposition. I had no idea. They're unprepared again.
Court's going to step off for a moment while Madam Court Reporter is able to provide that reading.
Oh, he's leaving the bench. Okay. Oh my. I'm going to pull this up like that. If you're there, Granny, feel free to unmute at any time. And thank you for joining us. Oh my. I'm just going to put that there. Guys, I don't want to be too hard on the defense, because I realize I've been really bad, But what? Okay. All right, Godless Granny. Can you believe what you just saw? Oh, why can I not hear you? Oh, there you are. Are you there? I think she's working on something. But guys, you guys were here before. This is not the first time the defense has been unprepared. But that was a major hissy fit. Because I think it's damaging. I think he realizes how damaging this line of information to the jury is going to be and he seems really upset about it. From what they read, it sounded like she didn't have a solid opinion about PTSD at the time of the deposition. And apparently he thought that if she came forward with one, he would be notified. Well, the state is saying he wasn't even going to go into it anyway. It doesn't matter. And he didn't think the testimony was changed because it wasn't going to be prominent. However, when asked the question, she gave a different answer than what he had expected, based on their previous conversations. So, wow, right? I mean, it gets to be just between the two attorneys. I mean, he feels blindsided. You obviously see how upset he is. He feels blindsided. But I don't think that was anything intentional. This expert witness is allowed to come forward with what her actual opinion is. And it's not uncommon that, at least from what I've seen in trials, that the attorney may be leading one way and the expert witness, of course, with their experience and all, is thinking that it's going another way. But they are on the same page. They've had conversations. They know what the end result is going to be. The point being, it's going to be damaging to the defense and to Sarah Boone, because another expert is going to come forward and say, nah, I don't think she has it. Nope. She was cognitive enough and she got upset, but no triggering thing. And oops, Granny disappeared. If you can hear me, Granny, if you're watching, I could hear you typing, but you weren't responding to talking, so I don't know, headphones or mic, what was going on. Liam says, but he had such a great route to success all mapped out. I get it, and I don't want to make too much fun. It's got to be terribly strenuous for them right now, because there's been a lot. Rebuttal is when their perfect defense, you lay out your perfect defense, you think everything's going great, and then here comes the other guy who gets to start picking it apart with other stuff. And of course, it's going to be contrary to what you laid out there. I just feel it is an overwhelming stress factor right now for this defense team, and that, of course, they're going to go after every little thing they can. All right. But when he actually said discovery violation, I wanted to fall off my chair. Seriously, all of the discovery violations. Is this not the same attorneys who just had thousands of pages of discovery not qualified because they wouldn't drill it down? They didn't do the work that was necessary on it, and they couldn't use it. Is this not the same defense team that lost 3 or 4 or 5 of their proposed witnesses off of their list? Let me see.
Hello. I can hear you now.
Oh, hey. Oh, good. I'm glad you resolved that. I can't wait. I'm going to be quiet, which is very rare. But please, do you have an opinion about what you just heard and saw?
Yeah, he's incompetent.
Oh, thank you. Because I've been bashing them for being sloppy and just so disorganized, and a judge going out of his way to tell them how to lawyer over and over again. I mean, you can see how frustrated our very people.
I haven't seen anything this bad, other than new attorneys, and you certainly don't put a new attorney on a case like this. I don't.
And he's not.
I don't know why
he's got
he wasn't prepared for this. And what's more, as soon as he started, into this, his assistant should have been looking through the transcript and finding him exactly what he needed. I mean, it's not entirely his fault. It's also his staff too.
He has 2 paralegals sitting behind him, and it's a team of 3 attorneys. And they know that they're going to be rebutting with this exact witness. Why didn't to me, I'm not a lawyer, you are, but doesn't it seem reasonable that somebody went over the deposition before the testimony?
Yeah,
look for the loophole.
And 87 pages. 87 pages is a short deposition.
And can I ask you, is that not normal because you're going to do cross to the
Yeah.
rebuttal?
Yeah.
You would. Okay. So the other day, Granny, this is just how this team is. It's not just the one lawyer. It's all of them. The other one, Henderson, gets up to try to impeach the main detective in the case.
Mm-hmm.
He wants her to talk about specific items on the property list.
Mm-hmm.
He wants to do a gotcha, right? He wants to catch her on something. She goes, okay, can I see the list to refresh my memory? He goes, huh? He didn't have it at the podium. Nobody had it.
Oh, brother.
They didn't go to the desk. Paralegals didn't offer it. He was like,
Oh,
the. Okay, all he brought up there was his legal pad with his notes. If that's how you prepare to impeach somebody, good luck. And then the next thing I know, they're going to try again, but all the witnesses they were going to use to impeach her all of a sudden were dropped from the list. They're not coming back. Like, no, we're not doing it, because I was just sitting here like, I'm not a lawyer, but I'm like, this is so sloppy. Like, I'm embarrassed. This is actually disrespectful to the system as far as I'm concerned. I felt so bad for the judge.
I will say that anyone watching this trial isn't going to hire them for an attorney.
No, and I think this is their big PR moment. They're supposedly pro bono. But
Oh,
another
really?
thing, yes, they actually filed. Here's the thing. First, he goes on one of the big ones, I think it was Court TV, and said that, well, Sarah's not paying me, but she's going to pay eventually. Like, we have an arrangement. And I'm like, oh, okay, it must be some back end deal for the media or whatever. Like, this is his PR moment. Not that unusual, right? But then he files with the court that she's indigent and he is strictly pro bono. He put it in writing. You know how you file with the court that I am taking the case pro bono?
Right.
Changes the whole scenario. All right. Cannot at that point, from what I understand from Florida statute, which I did look up today, again with the board, the licensing in Florida, he cannot have a media deal pro bono before the case. Like, maybe after he can make arrangements, but he cannot get into a deal with Sarah Boone in regards to media rights before. Like, that's totally no. But this team is so shady. Let me just tell you, the history here with these people is dark. Very, very dark. I have to do a whole nother stream on them after. Like, I don't want to disparage them, but this is not the first time they got caught like with some really shenanigans. There's going to be an in-chambers meeting between everybody. The state filed that they want to know how everything's getting paid and what's going on, that they think there's something here because of all the extraordinary travel expenses that are being paid by the state still. The you know how you can do costs when she's indigent, even if you're not paying the attorney, and it seems like there's a lot of stuff coming through. The state says something's up. They want a question on it, so they're going to be asking them about that. You know, whether or not there's a media deal. He changed his tune after he filed the paperwork with the court to represent her. He then went on another interview and said that he was doing it pro bono. You know. So I don't know. I don't know if they have a deal or not. But if anybody gave information to anybody in the court in regards to that deal, there could be trouble, right? There could be trouble for him.
Yeah. I don't know much about that. Obviously that's an ethics question. And I should know that. I mean, I certainly studied ethics, but that was a long time ago.
Yeah. Oh.
I remember when I studied for the bar ethics exam, there's actually only 10 major rules. So I made up a mnemonic device for the 10 rules. And then as soon as they passed out the test in our scrap paper, I wrote out the 10 rules on my scrap paper before I even opened the exam so I wouldn't confuse any of them. And when I do something like that, you know, at the end of the exam, I'm not going to remember that stuff anymore.
Wow. I just, when I looked at this, I did look up, like, you know, I'm not a lawyer, but I can Google. I know how to look for statutes, whatever. It's against, I did look at the Florida statute on that, and I think I had posted it in the chat that they cannot have media deals ahead of time. But I also looked on the definition of pro bono based on the board for your licensing in Florida, where this case is and where he's licensed, that pro bono, they actually respect pro bono work to be done and what it actually entails, and that it cannot be any infringement of the statement of pro bono. It does not qualify as pro bono if there's any type of deal like that in place. Media, even pro quo, what is it, quid pro quo, when you do like a trade thing, like I'll do this for you if you do that for me. Nothing like that can exist. It's not true pro bono. And they actually laid it out. They actually laid out how many hours they expect them to do a year and or contribute to the pro bono, like some kind of fund that they have for people that need assistance or whatever. And so each lawyer, if you can't do whatever what they expect you to do as far as pro bono for the year, you would actually just make a small contribution. I think it was like $200 and some dollars or something like that, to this fund, and that's what they expect from them. So there's a requirement, just like there is in every professional, profession. They have these certain things with licensing that they expect you to do, continuing education units, blah, blah, blah,
Right.
all of this. Right. But it was pretty clear and easy to understand. And I just don't but this guy violates, he was well into defending her when it became noted that he was unsatisfactory on the licensing board because he forgot to pay his dues for the year. So he had to pay the reinstatement fee and a late fee. How
Wow.
you got the biggest case going?
Yeah.
And you don't
on the
send
other
in the
hand,
$295?
yeah. On the other hand, I wouldn't expect the attorney to handle that himself. I would expect a legal secretary to do that.
Yeah, what legal secretary? He seems to be a one-man show. Everybody that's working on the case is coming from other places. He has nobody in there with him.
Okay, so he's a solo
Okay.
practitioner.
I think he's a solo practitioner. I don't even know if he's got a Gal Friday or a paralegal because he's been caught. One of the other things that was pretty embarrassing in court is he did a motion in the middle of the night, like a gotcha for everybody. And when the judge says, "Where's the certificate of filing? When did you file this?" If he had no date, nobody could provide the date, and they didn't do a certificate
Oh
of service.
gosh. I wonder
Yeah,
if
sloppy.
she realizes what an incompetent counsel she got. Of course, then again, she's got a really good case for appeal.
Actually, she doesn't, because every single day the judge asks her, "Are you happy with your attorneys? Are you on board with this defense?" Because he knew BSS was very risky for her. And
Okay.
every single day he asks her the 10
This
questions.
judge is
Every day. He does not want an appeal, this judge. I think the only reason he actually went forward with BSS, knowing it was going to be problematic, was to prevent an absolute appellate issue immediately. Boom. Nope, give her the best chance possible. He wants her to have a fair trial. And, having the three attorneys, they really are, in their defense, they really are doing everything they can. But I don't think this hissy fit is going to help at all. No, because they've done nothing but really annoy the judge the last couple of days. It's getting to be too much.
If I were him, I would at this point be looking to hire someone as co-counsel, and I wouldn't care what it would cost me.
Well, he did. He brought in one of them, Henderson, has been a friend since high school. This guy did a little bit as the district attorney. He hired this Henderson as an assistant district attorney. There's a whole big scandal involved with that. It's years ago, in the late night. Oh, they're back. They're going to be back. Can you stay a little bit? Because this should be good.
Yeah.
This should be really good.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens, Ms. Boone.
Kevin back on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
Yes.
Okay, you may proceed.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship the facts of this case and the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning, before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
And that doesn't sound different to me.
Nope.
Right?
Yep. You're right.
Basically, this defense is being caught with their pants down, not prepared, and they want to blame everybody else for it.
Yep.
And they don't want her to testify because the jury is going to hear stuff they don't want them to hear, that she may be lying about the whole thing. That's my take on it. I mean, I can understand them being upset. You don't want somebody that credentialed to get up there and call your client a liar.
Page 46, line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? Line 19, the answer no. I didn't say one way or the other. I would have to look back through my notes for that.
She's not exactly saying that now
Question
either. She's saying
21.
it wouldn't matter
Is that
based on
something
the
that you
incident.
may,
It doesn't
in the future,
pertain.
give an opinion
That's what
about
she's
after
saying.
some time reflecting and reviewing your notes? 24, I may. 25, okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Exactly.
She led me to believe
Exactly.
that she was trying to decide.
No,
whether or
that's
not
your interpretation,
Sarah Boone
bozo.
post-traumatic stress.
That is not what she
Proper,
said.
They're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion And I, again, like that, we read back what the initial question was, what the response was, because it did, I know I objected, I can't even remember it now, but I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was, it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the
I love this
proffer
judge.
was. Madam Court Reporter, if you could be so kind.
He's so good.
Yes, ma'am.
By Mr. J, question. You've been present for all this hearing, yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial.
No.
You see, he misunderstood what's going on here. He's just upset that it's not going their way. He's actually putting more on it than there is, right? She didn't say.
Yeah, well, he didn't get the information into the proffer that he needed. I don't know if it exists, but he didn't get it in there, and now he's scrambling because he doesn't have the evidence he needs.
Exactly. And he's not going to be able to counter this very well at all. I see your point there. So again, unprepared defense and it's somebody else's fault, right?
Yep.
This judge, he's a saint. I don't know how, I mean.
Oh, I agree. I don't know how he puts up with this.
And this is not the first time he's done an objection and he gets up and he starts talking to the jury instead of doing a one-word objection. Yes, in testimony. He's like, wait a minute, that's not this, whatever, instead of just going hearsay or relevance or whatever. And the judge is constantly lawyering 101 with him, like state your legal objection or sit down. You know what I mean? Like, you just don't do that. The judge always takes these on sidebar. He doesn't let this mess in front of the jury. This guy is like, he'd rather the jury see it.
I'm wondering if the judge knows this guy and knows that he's.
Oh, the way they've been going. I mean, he's given him a lot of leniency. He's given him time.
He has. And I'm thinking that the judge is well aware that he's not competent and needs to give him a hand. I don't know.
Actually, I think it's in deference to getting Sarah Boone rather. Oh gosh, I said Brown. Sarah Boone, a competent trial. Like, get her the trial and defense she needs. He's actually been almost hand-holding them, like actually like telling them you need, like I don't know how many motions they threw at him with no case law after the judge specifically asked for case law. Like, what do you need case law to back up your opinion here? I have got nothing to go on. Still, no, they don't comply. Extended datelines, told them exactly what he needs, and they don't do it. It's crazy. I've been so frustrated with him. I've been a little harsh because they really annoyed me from the start. But
I can imagine.
Please, go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder. At the
There
time
you go.
that I evaluated her at the jail.
that's the same thing she said
Can
in
you
the
read that for me one
deposition,
more time, please?
Yep.
only with different
Both
words.
the question and the
Am
answer.
I hearing it
Question,
wrong?
what was your opinion?
I don't think
Answer,
so.
my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
This is so embarrassing for them.
Question,
Mhm.
and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her
No, she
deposition,
Oh,
didn't.
brother.
which
She
subject to
did
the
not.
incident we had, I should have noticed.
He just read it back.
Number two,
Mm-hmm.
with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And
You
I asked
did.
throughout.
Yep.
She said she wasn't given enough information to make that determination, and it wouldn't change her opinion anyway.
Or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So
No.
it's an evidentiary issue. I've
No,
got
it's not.
a right
No.
to be prepared for the trial.
Should have read the transcript.
To know what the witnesses are going to opine. And this is a discovery violation based on two things.
He's trying to get this
One,
tossed,
her
isn't
initial
he?
answer
Mhm.
to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery
The proffer
violation.
is a
I
new
ask that the
opinion?
Witness be stricken.
That's not
Proper is
possible.
not.
Any
Proper is it corrected? That's how you elicit opinion? How you find out what they're gonna.
Stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not, I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be, Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case.
Mm-hmm.
What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That
That's
is
what
not a
she said.
discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition, in response to a question that starts.
And what she said today.
Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all the.
I specifically asked you, Mr. Owens, to point out for me I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
Well, the ones that I expressed.
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had, that she, in the pages that I had talked about previously here today, in the pages that I referred to about our agreement, that she was going to let me know if there were any opinions
She hasn't changed her opinion.
that she
It's the
had, in
same.
addition to the opinions that she gave in the transcript.
I don't think he understands
Any other argument, Mr.
what
Jacks?
she said.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243.
They're going to have a hearing.
At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing.
Trial, by the way.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay.
Your misunderstanding is not his problem.
All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
My God, does he have to handhold him?
Mm-hmm. Gosh, and he can't even answer that question. He doesn't even know what he wants.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out.
No, you're not.
Through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay, all right. Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
See what he
And are
does,
you on
Kraynick?
board with the strategy
There's gonna
not
be no
to seek to
appeal
strike that opinion?
Yes.
Thank you. With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes,
But you're not ready, and this is what you wanted.
with regard to the
Good
proffered
luck.
opinions. And I believe that will provide a cure
Here we go.
for the discovery violation under the Richardson violation,
I love
based on your
I love
request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time. You may proceed.
Dr. Warren,
Yes, sir.
good morning.
Mark?
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussion?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct, that my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct, that was my opinion, correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I
She
took your
did.
deposition?
I
She
did.
didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion
Do you
prior to the
remember
deposition, correct?
She had the opinion at the
State attorney
deposition, and
discussed
he
that
didn't
the
ask.
way
It's not a new
out.
opinion,
Doesn't matter
dude.
that.
Right.
After the
Oh my God.
deposition.
This is funny, isn't it?
Yeah.
I'm glad. I'm
Okay.
glad you're on board with me because
All right,
I've been
and I
feeling
asked you,
guilty about how
Were there
annoyed
any
this
other
man makes
opinions
me.
that you may express at trial after you had
I was
discussed that
on
with the state
jury.
attorney
I
prior
would
to
have
the
a hard
deposition?
time keeping a straight face.
Is that correct?
Thankfully, they're not hearing this, right?
And so
Like,
you
they're
were
out.
aware
that's
that I
right.
wanted,
That's
I
right.
didn't want to
Jury's
be
not
ambushed
in
at
there.
trial. I wanted to know any and
That would be
all
so embarrassing.
opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions.
Let me
I
tell
don't
you how to
know
do your
what
job,
all
dude, just
information
like
you
the
want me
judges
to
do.
provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
Exactly.
Well,
That's
yeah,
what
that's how a
depositions
deposition works.
I'm happy to answer any questions that I'm asked.
Oh my God, I
I
can
don't know
fall
what
off my chair.
questions you want me to answer.
But you know that this was a central issue in the case.
No, you knew it was
Did you
a
not?
central issue in the case.
Yeah.
It's not
Your
her
opinion,
job.
your
Oh my
opinion
God.
Yes.
is relating to a central issue in this case.
Oh my.
Correct.
Oh
You're
my.
aware Sarah Boone's on trial for murder.
That's
And
And
you
you're-
had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
Her
That's all.
job is to answer the question.
Yep.
not to tell you
Mr.
what
J,
you need to
anything
know,
else?
dude.
I'm just making sure he doesn't want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about,
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and/or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware, you know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly. And then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her
The
opinion.
question?
It just puts me in a very difficult situation, but
And it's
if
not the
if I'm ordered
judge's
to continue the
problem.
deposition, I will.
Yep.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Thank you,
Dr.
Judge.
Lynch, you realize you're in a courtroom
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition or you have not disclosed here today?
Barry's
Under oath.
finally asked a good
I'm
question.
happy to answer any questions that I'm asked.
And that is the
Are you
legal answer she's
refusing
supposed to
answer
give.
my question about any other opinions that
No,
you
she
intend
is
to
only
express
required to
here
answer
today
what
as it
is
relates to
asked of
Sarah
her.
Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness.
Thank you, Mr.
About
J.
any and all opinions she may or may not have. 99 out of 100 attorneys would come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert is always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify.
Can I
She's had
object?
conversations with the state
Relevance?
attorney. She's knows
Relevance,
what she's
Mr.
going to
Owens?
be asked in forms of
What are you
opinions
doing?
that
Hear
she's
that.
going to express. That's why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here?
No.
In the middle of a trial,
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and
I
its
think,
relationship to the facts
man,
of the case as the defendant
What's
represented
with
them.
him today?
And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
all right, can I continue with my deposition?
Yes, sir.
Dr. Werner,
I wonder if he's
do you
drunk.
recall
What is
expressing
this?
that you wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
She's still
What
saying she
additional
doesn't.
information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Yeah, just like you're doing, dude.
Were there any other personality disorders, isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So
Wow.
narcissism, you did not
Traits.
find.
She found traits.
Found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir,
did
I said
not say
narcissistic
that.
traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You
got a
express an
language
opinion
issue.
that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
And it wasn't before either.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards a adjustment disorder secondary to her legal situation.
I'm leaning toward hiring a bad attorney disorder.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
Yeah, I feel you. I feel you. This must be hard for you because you're a lawyer. Like, you know how bad this is. Wait.
Yep.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do
I
you have
love the way
anything
she
to
says
dispute that?
As
No.
reported by her.
I've fallen into that trap a couple times as Kaja. Someone will tell me something and I'll report it as fact and find out later that they were lying to me. You need to say this person reported this. What gets difficult is when someone tells me what someone else said and I've got to report that so-and-so reported that so-and-so reported that so-and-so reported this.
Exactly. It
In
can't
your
be
opinion, does
corroborated.
she suffer from any
it's
form of
risky.
psychosis?
Definitely risky. Their whole defense is risky because it's all based on what Sarah says.
Mhm.
That's the problem.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
This was all stated in the deposition prior.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based on the
Draconian.
questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25.
Damn.
So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the
Kevin
record
Beck,
or?
he's the third
Okay, go
chair.
ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying again since they've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal and possibly through these witnesses? They're under subpoena, and I'm sorry, Ms. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal. But
It doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule sequestration is still in full force and effect. Detectives Lowen and Capsule, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
I am so impressed with how this man dots the I's and crosses the T. He's going to be really hard to overturn anything that he did. He does the case law. He looks at why. He gives them all the information. I mean, if they try to appeal anything, it's just going to get tossed. I mean, it's insane. This was so embarrassing for them. It's just nothing. Do you feel that he got any additional information out of that deposition that they just
No,
did?
not at all. Not at all.
It is exactly what he read as the problem, word for word, almost. She said almost the same thing. I don't think he understands what she's saying.
I had a deposition that went somewhat similarly, where I was being asked about some insurance, and I knew that the attorney was asking me the wrong question, but I wasn't going to fix the question for him. He kept asking me.
Job. Yeah.
Well, no, it's not. Yeah. I was being questioned as the representative of the insurance company, and the lawyer was trying to get into the record that there are no limits on workers' compensation insurance. But what he kept asking me was how much was the policy limit for employers' liability insurance. And I had the policy in front of me, of course, because I knew I was testifying about the policy. So I said $100,000.
Yes, Your Honor.
And
That's to recognize
he didn't know what to do with that
Okay,
because he was
Reseated.
expecting me to say there was no limit.
Members of the jury, thank you again
But
for
he
your
was
patience.
asking the
We had
wrong
some issues
question.
I had to address with counsel outside of your presence, and we're going
Those are
to
two
continue
separate-
the
Those are two separate coverages.
state's rebuttal case this morning. Again, if you could, please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
So the state
Oh,
wants
brother.
to correct the record. Okay.
Oh, okay. Okay. No, I misunderstood for a moment.
Because he's saying it's non-responsive, meaning like the last question that she answered, she wants it off the record so they can't do anything. If he
Right.
does this, if they allow this, that means Owens can't get up and ridicule her in front of the jury about it.
Mhm.
You know what I mean? In other words, I know what you're doing. We're not going to allow it. This is my playback. Like, nice try. Like,
Mhm.
yeah, this is, they're so shady. I really think their behavior is so disrespectful to the system. That's my issue. They're
Yeah.
so sloppy and so shady about this stuff. The fact that he could actually call somebody out for a discovery violation when the day before trial he drops 500, no, 2 days before trial,
The objection's
550
overruled.
pages of non-relevant medical records.
Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asset answer.
Overruled.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we push it back?
Yes.
I'm going to object, Judge, because this witness just said something I don't want the jury to hear because it makes perfect sense. It's what everybody's thinking. But, okay.
Rodent, no last name, has a very insightful comment there.
Oh, let's pull it up. Is this the one?
Yeah, that's the one. Defense is struggling with what he can do and what Boone wants him to do. And
Exactly.
that's difficult.
Yeah, because this particular witness is going to say she has alcoholism and that she had problems before she met George. And yes, she qualifies for BSS. However, it's not relevant. She was not presenting symptoms or reacting that way at the time of the incident.
At the time. Yep.
Mm-hmm. And that's what I'm hearing. Is that what you're hearing? I mean, that's what
Yeah. And I totally get it, because someone who is in a relationship where they are being abused doesn't always fear the abuser.
Right.
There are times where the relationship is going well.
And in this particular case, there have been incidences shown to us to where Sarah has total control of the situation over the abuser. They abuse each other back and forth, and she has a lot of control in this relationship. And I think that's where the defense is getting uncomfortable, because that in this testimony, that's going to become prevalent. That she was in control at the time. Because you also have the fact that if there was imminent threat and she did what she did, how did the imminent threat get resolved? She went upstairs and went to sleep.
Yeah.
How did it just vanish? How did it just vanish? Like that. She was so like she could just go upstairs and go to sleep. It doesn't make any sense to the average person, let alone an expert with a lot more knowledge than we have. It's the whole case, the whole defense of BSS has been so risky. And this judge knows that, and he's trying to balance it the best he can. He really does want to get, he wanted to get this to trial. He took over in January. He had to put up with her shenanigans for a while. I mean, she greeted him with a 58-page letter. Godless Granny, like it was like the cream of the crop of all her letters, like 58 pages of all her complaints. And he has done everything he can to make sure she gets fair get a fair trial. But at the same time, balancing the needs of the state. 4.5 years later, 8 paid state attorneys that did not fit her criteria for some reason, and she wouldn't work with. They're putting out a lot of money. He's under obligation to get this to trial. He's doing the best he can, and he's been doing a bang up job of keeping them all on schedule. And they've been trying to get this tossed from the beginning. They wanted more time, even though he took the case in full knowledge that when the judge made Sarah Boone pro se, he said in there, even if you obtain another lawyer, it is not going to change the dates set for trial and the last conference date. And so, Owen, knowing that, he met with Sarah Boone 4 times. The records are all public. I could pull up that order, that 17-page order. Don't tell me an attorney can't. And he comes in there and says, well, I just took the case and we need more time. And he's like, apparently you need to read the 17-page order because no. No. This judge is, and he's very polite about it. He's a saint. He's a saint. If there are saints, he's one. He's a saint. He's a legal saint. Yeah.
Do you know how many more witnesses the prosecution has?
I do not. Because of the, here's the thing, because of the battered spouse syndrome specifications in Florida, Sarah Boone,
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same
man.
instruction. Please don't conduct any independent investigation or research
I feel bad
on
for
the
the
person,
jury.
places, thing, or charge involved, and don't have any conversations amongst yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
You walk out.
Yeah, that's a
You wait.
judicial student
come
up there.
back in.
He's getting a good. Yeah.
But you
This
come
is gonna
back
be
in,
crazy.
they ask one question, you sit there for 5 minutes, and then they ask you to leave again. I mean,
Exactly.
from a juror's point of view, this is really frustrating.
And I
Y'all
wonder
can see it,
who they're
thank
going to blame for that. You know, who do they think is responsible, the defense or the state? Like this can
I have no
actually
idea.
prejudice their decision. Wow. Oh boy, this is not good. I don't know what they just said, but he looks rather annoyed right now. Boy. Anyway, what I was saying before is that the state didn't actually present everything that they had because they could not go into prior acts. They could not talk about characterization. They could not talk about anything that would allude to Sarah being able to bring it all in because she was going for battered spouse syndrome as the defense, and she needed to take the stand and testify to the overt act that qualified first before any relationship information came in, any of the medical history, police records, all of that. So the state had to do their whole case without any of that. Then the defense, Sarah took the stand. BSS was established to come in. Then it all came in. They did do their cross on it. But now with the rebuttal, I'm not sure what new stuff they're going to be putting in because there are plenty of police reports where Sarah was the aggressor. There's body cam footage of her telling different stories to the judge. Like, there's a lot of credibility issues that they could present, but I don't know what they're going to do. The defense has tried to impeach the lead detective twice now, unsuccessfully, in front of the jury. And that was the detective they were talking about that was in the galley. She's still subpoenaed. But I just heard the state say they didn't intend to call her or her partner. So I have no idea what else they're going to present.
Okay.
Like, I knew this witness, but the witness lists are sealed. I didn't get to see them at all. They've talked about them in open court, you know.
Yes, ma'am. Just go from, read it from the question, answer, question, objection. Let's just have we can buttress it. Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection asked and answered. The court overruled The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
What's the problem there?
Any other argument, Mr. Owens?
No clue.
She didn't
That it
mention
makes it
BSS.
possible to the jury.
She didn't mention PTSD.
That's a decision, whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury.
No,
This expert
she's
can
allowed
express
to give an
opinions on
expert.
science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm gonna make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
That's actually a decent argument.
Response.
That is a decent argument. But didn't
It's
his
not
defense attorney do the same
an
thing?
objectionable
I mean,
opinion.
his
It's not
his expert
an opinion
witness.
on the ultimate issue. It's an opinion upon the applicability of a particular set
But
of evidence.
the response is
that,
just that the judge's
testimony that the
instructions
defense
will fix it.
offered,
Mm-hmm.
called
That's what's
battered
going to
spouse
happen.
syndrome to kind
Exactly.
of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Ms. Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you
That's
can
the
know that
problem
the
is
defendant was sane at the
that they'll
time,
have to
despite
choose
his
which
mental illness,
which
because
expert is
he
more
ran from
credible
police, he-
because they're
Mhm.
giving different
he
opinions.
concealed evidence,
And that
so
happens
on
in
and
every
so forth.
trial, doesn't
And
it?
therefore,
Yep.
because of those facts, insanity
As long as you
doesn't
can
apply.
afford to get the
Defense expert may come
expert.
in and say,
Mm-hmm.
well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony, and it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony, Judge.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims, Dr. Harper came in and said BSS does apply. That's true.
Right?
But he just got through saying and trying to get the witness to say BSS it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about battered spouse syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
Yeah.
It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. The
Alleged.
issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force,
To a man
based on
in
her
a suitcase
beliefs
with no weapons
and
and no
impressions
ability
at
to
the
get
time,
out.
whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the
jury instructions under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion. See section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such.
You can't keep
Those
it from the
reasons, your
jury.
objection is overruled.
You can't have it both ways, Mr. Owens.
And I have no further questions of the witness.
Okay, thank you.
I'm sorry.
He's going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
Brother.
It was asked and answered.
Overruled. There's a pending objection. Allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour.
Your problem, sir.
We're going to begin your cross-examination after we're done with the state advises the jury in open court that there are no more questions. Let's go ahead and bring back in our panel.
In other words, your problem, dude. Sit down. Sit down, Mr. Owens. Thank you. Can you believe this? The
No.
audacity of this man?
Yeah.
That's a professional. That is a professional.
I have been astounded in the last
Yeah,
couple
right?
of weeks
It's like
by some people that are so much smarter than I am that I'm going, gosh, I could never have figured that out. And then I come here and see this, and it's just the opposite.
no, this is totally this man. I mean, it is. Oh my God. You're right. He is not playing. I think he was offended by that hissy fit.
We have a local judge that I find equally impressive. You know, I go in there with stuff and I'm not telling her everything because I can't always. And I'm just flabbergasted that she can read between the lines and see exactly what I'm saying. And
State to recognize our jury.
she comes up with
Fact to
decisions that
recognize
I
our jury.
never would have
You
come
may
up
be
with
seated.
to
Thank you.
solve problems. She's really something.
The jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Has the ME already been on the stand?
Question by Mr. J. All right.
Yes, the
Irrespective of
autopsy.
Whether anybody
Yeah.
has any opinion about
Yes.
whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek, they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Here we go. This ought to be fireworks.
Mhm.
Dr. Warner, good morning.
They should have put one of the other attorneys up there. Owen is too flustered right now.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
it was an interview, yes.
Excuse me?
Yeah,
Okay, go ahead.
it was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes.
Agree.
And did you listen to Sarah Boone's testimony in the trial of this
Did you
case?
understand?
You agree you have a right to do that?
Yes.
And you elected not to listen to her testimony before expressing opinions here today?
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Objection, may you approach?
Yes.
Wow. Like, I don't know if he's doing himself any favors here.
No, he's not.
He's, I wonder how the jury, I really wish we could see the jury's faces, but I understand like why they don't let us, but wow. I really, like, they've got to be annoyed by this by now. Like, this is insane.
Well, I also think he shot himself in the foot by even bringing this, these objections, bringing them up, because now the testimony's been read to the jury 2 or 3 times.
And it hit home.
Yeah.
It hit home that you need to focus on the fact that she was not agitated. They had fun. These are her words. For 4.5 years, she said the same thing. It was fun. We played hide and seek. Everything was fine. But then he said something to me and I got pissed. What did he say? I don't remember. That's her testimony. What did he say that got you upset? I don't remember.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the document,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
Is he going to say that she didn't know about this testimony because it just happened yesterday? So he's going to try to impeach her that she's using this information for her opinion, but she didn't know about it until yesterday. So, like, of course, same thing with your expert witness, dude. Like, what? Where's he going with this?
I'm not sure. I thought he was going to try to show that she wasn't properly prepared, that she didn't take this seriously enough.
I guess he wasn't listening to her credentials. This woman is asked by the state everywhere to do mental competency.
I mean this specific case, because in trial, when the jury was still there, he was trying to ask her, this is a murder case, why didn't you do this? Why didn't you do that? And I think he's trying to show that she didn't do enough to formulate her opinion.
Oh, this is the Sarah, nobody's listening to me angle. This is definitely Sarah. Sarah didn't like that this woman didn't agree with her and actually listened to what she was saying and used her own words against her. Almost every witness like this, you can, like, Sarah has strong opinion like about this, and she goes back and forth. I mean, she just dragged like a 90-year-old woman on the stand to say that she saw her with a black eye once. Like, it's really embarrassing, actually. And tried to say like how it happened. The woman doesn't know how it happened. She's 90 years old. She only says hi to her from her porch. It was yeah. Sarah definitely doesn't like anybody not agreeing with her perception of who she is. She doesn't like to talk about the alcoholism. This woman's going to call her an alcoholic. Like, she's going to say that she doesn't believe her. And it's an issue. And I know that's an issue for the defense. They don't want that out there. Absolutely. It looks bad for them. But what he's doing is actually, like you said, putting a spotlight on it, focusing on it. And it's making it worse for them. And it's looking like he's flustered and a little incompetent, or maybe he's hoping that the jury will see that it's a big issue, that he's upset about it because he's defending Sarah's right. You know what I mean? Like, maybe he's hoping it'll have a different perception by the jury on his actions. But to me, it's like a big hissy fit. Because she doesn't agree with his expert. She's the state's expert. She's not supposed to agree with the defense's expert. Like, she's supposed to be giving an opposite opinion. That's what the game is. My expert against your expert. Pro versus con. You say this, then I say that. And it's up to the jury to decide who's more credible. He's really trying to make her look not credible. Yesterday's witness actually came out neutral in the end. Everything that the state brought forward in cross alluded to the fact that the victim, the deceased, could also have battered spouse syndrome. It all qualified for him too. And and that was actually a good points on the state. So I think that that's what they're coming back from. Julie Harper being, yes, she's very pro Sarah. She knows Sarah has a lot of issues going on. She does believe that she could have felt threatened. She believes any victim could have any trigger and feel threatened in any situation. So it wasn't really Sarah specific. It was, she truly believes this, this is her with her advocacy and with her experience and with her education. She was very much a victim advocate that way, where every victim is different. All the triggers are different. The disorders come, on top of each other. She was laying out a layered plan. Like, this could have stemmed all the way back from things that happened. She could have PSD. She had alcoholism and depression well before she even met this man, the deceased George. But that all of this contribute to that. Yes, she does have battered spouse syndrome. And yes, she would not act. The point being, battered spouse syndrome, she would not act like a reasonable person would act in the situation. She may act unreasonably. She may see threat where a normal person, the average person, would not see threat. She'd be triggered by things that would not bother anyone else. And then, and that's all valid, and I don't think that was contested. But this particular witness is saying that doesn't matter because she didn't get triggered, because here's why she didn't get triggered. her own words, what she told me proves she was not triggered. That's what this witness is coming forward. And I think that is what's turning the defense upside down, because that actually changes everything. Somebody's finally saying what we all see out here. You know what I mean? It's like that has not come into evidence before. There was no way to express it until today.
What did the autopsy show was the cause of death?
A positional asphyxiation.
Okay.
Like he could not breathe, lack of oxygen. He died of asphyxiation,
Okay.
and it was positional and environmental contributed because of how the suitcase is, the lack of oxygen, him breathing into it, more CO2, like the whole thing. It was both positional and environmental because of the confined space. But also on the autopsy, she's now admitting that she hit him with the bat, but she's saying she only poked him. There were deep contusions as if he was whacked.
Yeah,
Like,
that's
on
why I was
his
wondering if possibly he
head, on
died
his-
from
yeah.
blunt trauma.
Yeah. No, it was definitely from the lack of oxygen, and
Okay.
also the video. And I'm sure you've seen the. Have you seen the video that she took
No,
of her
I have
very
not.
drunk and very malicious? You need to see that. She was very maliciously taunting him in the suitcase. He's begging for his life.
She took
And she's
video
like,
of
"That-
her killing him?
Yes. No, not of her killing him, of her taunting him. Then there's the 9 minutes, and in that 9 minutes between this 1 2-minute video and this other 22-second video, there's 9 minutes where she is testifying that that's when she was triggered because he said something to her. So it was no longer her in control taunting him. She was threatened that he was going to get out of the suitcase and retaliate on her because she said all along he could get out, which that's a whole nother thing.
But it would
this
be her
9
own
minutes.
actions that caused her own trigger.
Exactly. She started whacking him with the bat because she thought he was going to get out of the suitcase. Okay. And she felt like he was going to beat her and her life would be over. That's her testimony. She was triggered by something he said. She can't tell you what he said. There's no recording. She could record what she said to him and him begging, but there's no recording of what he did. No aggravated. And the thing is, he's in the suitcase. He can barely breathe. He's begging for his life. Why does she's trying to say he got very aggressive and violent and she knew she was going to be killed? But you don't hear that in the 2 minutes. Okay. Yes, he could have probably got upset because she wasn't listening, but he could barely get out what he was saying before. How could he get so mad and scream and yell like she's saying that he did, that triggered her, and yet she can't recall what the words were, any of them, what he said or what he did to do it, but that's what she's saying. Then she hit him with the bat. She's saying she only poked him by pushing the bat forward at his hands. There are contusions on his hands for that action. But then she says that's what she did throughout the whole suitcase. But the injuries actually indicate deep bruising, long, deep bruising. That is not the end of a bat. That's not the circular end of a bat poking. You know what I mean? Like, unless they're all lined up precisely. Do you know what I mean? And the medical examiner did say that. The poking could have done it if they were all precisely lined up and you took the time to make sure they were all overlapping. Do you know what I mean? Like you just, it wouldn't be as random. She's saying she randomly poked. It would take precision to make the kind of injuries that he had or how the bruising was. Now, the bruising could also be, the neighbor said there was a loud noise. There is the possibility that the suitcase was not downstairs. It was upstairs and that she tossed him down the stairs. Because
Objections overruled.
marks
You may
on his
proceed.
head.
Thank you, Judge.
Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes,
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And
But
at
they
that
shared
time,
the
you
phone.
said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got it.
I do.
Page 14. My question is at line 3.
This
Your answer begins at line 5.
That's a valid point. They both use the phone. She says she doesn't know who sent the text because they both use the phone.
Correct.
I
You
don't-
agree that any,
Let him finish. Let him finish.
well, I'm going on, I'm going to ask another question about the text messages, Judge.
You just said line 5, approach.
Okay, I hope the jury's looking at her face. She's, yes. Because this man, I know what he's trying to do, but he has to be a little more careful about how he's doing it. Wow.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone? Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14, my question is at line 21. Your answer is at line 25.
Correct. And I said no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no?
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
I can
talk.
read my
First, you said no.
As I said, it made me aware that they had a
Ma'am,
volatile
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you
Oh, he
if
is
there was
looking
anything in
really
the text
bad, yeah.
messages that caused you to pause and it would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
That's a poorly
at the
phrased-
same time,
She's looking at the jury
Dr.
like,
Warner?
do you see what he's
Dr.
doing
Warner?
here? He
at the
wants me
same
to
time,
say
you
what he
expressed
wants me
that
to
they had
say,
a
and I'm not
volatile
doing it.
relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay.
But part of your answer was that they had a volatile relationship.
Correct?
And this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. You need to approach.
Okay. Wow. Does he not realize how bad that looks to the jury? Like, oh my gosh. This is too much, people. Like, I thought he was terrible before, but oh my goodness. I really feel for this witness. Like I'm sure she's
Yeah.
had worse. Like she's actually feeling very confident right now that he's making a, may I say, ass out of himself in front of the jury and everybody
I'm just
else.
hoping they're going to let her go at
To
lunch.
Can you imagine though? Like he's saying, did you say no? Yes, that's not my complete answer. Read the complete. He only wants her to say what he wants
Yes
her
or
to
no.
say. He's not.
Yeah.
Yeah. And she's not going to be impeached on it. She's like, nope, she's not having it. Yeah, I think he did, Liam, slip off the edge into Boonville. Like he's suffering right now from the same delusion. I think that they're winning. This, I don't know. I want to look at Twitter and see how they're saying, the people in the courtroom, that she how this is coming off with the jury's faces. Like I gotta find out. Like this.
The answer to Jester's question is sometimes. There are definitely some attorneys that are much more hostile than others. And it can be a very effective technique. There's an attorney in town here that I don't like testifying with because I know how hostile he is. Even when I know I'm in the right, I'm still uncomfortable with him asking me questions. So yeah, it can be effective.
We did see on the third chair, Kevin Beck, the first time that he went to a witness, he was absolutely aggressive and hostile. It was rude, like just right off the bat. And that I agree, that is a technique that some of them use, like as they're going to get the best defense for their client that they can, and they're not having any of this, really, but like a TV moment almost,
Yeah.
but this TV moment is missing. Like this is not going, like he does look aggressive, but not aggressive in defense. It looks more like he's throwing a hissy fit because things aren't going his way. Like I wonder if the jury's picking up on that. And it's like he just does not want this woman's opinion in front of the jury.
Yeah, and he's just prolonging it. What he should be doing is getting through this testimony as quickly as possible and getting her off the stand.
Right. Exactly. He's not going to be able to get her to say what he wants her to say. So all he can do is counter it. But this manipulation of the testimony is a bit much. I wonder if the jury's going to be tolerating this. I don't think I think it's going to make a problem.
I like Rodent No Last Name's comment. I wish sentencing included being an asshole in court enhancement. Except the problem is it's the attorney that's being an asshole, so you can't really punish the client for it.
Can you imagine? Oh my goodness. Poor Sarah would be in trouble right now because all three of her attorneys have done some really crazy stuff here. You're right, Rocket, on the bingo card. Like it's not anyone. We'll just change that to attorney because I think it's going to keep coming up between all of them. I can't believe. I really feel for this witness though. I mean, she did read everything. She is prepared, and she makes a valid point. They shared the phone. I don't know if you knew that, Godless Granny. She did not allow. She didn't let him get his own cell phone. He made all the calls through her phone in text messages to his family through her phone. This is what I meant by coercive control, how it went both ways. If she actually controlled that scenario completely, who he communicated with and how. And so he needed to use her phone all the time to test. So when there were certain text messages that were like, don't worry, I'll take care of it. I'll be getting rid of him. It said him. She's not going to testify that Sarah actually made that.
All right, members of the jury,
text.
It is 11:55. At this point in time, we're going to go ahead and take our lunch break.
That's too bad.
I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again, bless you, that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we're going to be in recess till 1:30, and we'll pick up at that point in time. Thank you so much for your service.
Wow. I'm gonna bring us up. I'm gonna have to drop them quick
Y'all may be
because
seated.
it looks
State
like
anything
he's
else?
gonna actually do
Defense?
something with him.
All right, we'll see you at 1:30. Thank you very much. Court's in recess.
Okay, so he is actually gonna do recess. Oh, can you stay a bit, Kel?
For a bit, sure.
Okay. So I want to know. I don't know how much you know about the case so far.
I knew nothing about this case until I came this morning, and while we were listening to court, I pulled up a Newsweek article and read it.
Mm-hmm. And was that about what's been going on lately?
No, it's the case in general.
Okay. Do you have any questions? Can I give you any more information? Because I want to know what you think about what you saw today. Well, you could just talk about what you saw today because this.
Well, what I saw today was complete incompetence. I think this one is going to be a slam dunk for the prosecution, and I don't think Sarah has a clue how badly her attorney is doing.
I don't think so either because what people are saying is that Sarah's the one actually directing the defense. The reason she went through so many attorneys is because this is the defense she wanted, and they were actually going against the advice, and they were telling it there's too risky and there's too many holes, and this is why, and she didn't want to hear it. This is the defense she wanted, so in essence, she's directing the defense. She's getting exactly what she wanted. From this defense. Hold on, I have to mute for 1 second. Can you tell them exactly what you're seeing that he's doing, that he's is showing the incompetence? Could you do that for me for a second?
Sure. The defense attorney just is completely unprepared, and as Claire and I were mentioning during the break earlier, an 87-page deposition is not a long deposition. It's a short deposition. And to not know what you want to put into evidence is ridiculous. And even if he was surprised by what she said and he was, completely taken off guard, he's got a couple of paralegals there. As soon as he realizes there's something wrong, he should have been turning around to the paralegals, telling them exactly what to find in the deposition. And the first paralegal would cover the first 40 pages, and the second would cover the second 40 pages. And they should be able to find it in 10 minutes. Because a deposition, the way it's written, it's double spaced. And every line, there's not that much information on a page. You can read a page of deposition testimony in less than a minute because the way they space it out, there's not that much on a page.
Exactly. and prep work the day before, it sounded like he wasn't even aware of all of it. I think he just felt like he heard something he wasn't prepared for, but it was not really different. I didn't see that it was different from what she said before. She basically said it's irrelevant. BSS, PTSD, it's irrelevant because there was, based on what she's telling me, she didn't really feel imminent threat based on what she's telling me. And she said that over and over again, based on the information Sarah herself is putting forward.
Mhm.
And I think it just hit home to him that she basically just said, you've wasted all this time on BSS and it's not relevant to your case because that's not what happened here.
Yeah. Yeah.
I mean, this is the first time someone has publicly said what is everywhere in the media and with all of us. The controversy of this case is the fact that what Sarah says happened, Sarah herself contradicts back and forth. In someone is finally, with like degrees behind them and with some weight in the matter, actually putting into evidence, yo, jury, look at this. Sarah's own words contest this defense.
Roden, no last name, has another brilliant comment. It's a
This
little,
one?
yeah, it's slightly crude, but this should be called the masturbation defense because she's fucking herself.
Exactly. And all the attorneys are helping her, like, unfortunately.
I wouldn't say that because her attorney has an obligation to do what she asks. And if they can't do what she asks, then they have to ask the judge to excuse him from the case. So her attorney's hands are tied. The prosecution, it's his job to shut down any defense that she offers. So I wouldn't say that he's helping her do it. I would say that he's doing what he has to do.
Exactly. I kind of see that. I definitely see that. So what did you think of how the judge handled the whole thing?
Oh, he's brilliant. He's absolutely brilliant.
He really knows how to zip it up. He tries to keep, and he was actually trying to be kind to Mr. Owens and saying, yo, like, give me your legal objection. Like, I'll go forward with this. I see your issue. But you need to actually put it on record in the right way. Like, we need to move forward. Like, he knew that. I think he knew from what Mr. Owens was saying that he was going to do a Richardson hearing right away. I think he knew, because he is so precise in making sure that this case gets tied up, like completely tied up with a bow at the end.
I also think that the prosecuting attorney is really astute as well. Because there's a lot of things that he could be objecting to, and I think he isn't, because he recognizes that the judge is trying to prevent a mistrial and is trying to prevent an appeal. And so he's keeping any objections to himself that will prevent the judge from doing that. And so I think both of them are quite astute.
Yeah, I think you're spot on with that. I have seen the state actually back down from an objection, like the ones about that we had last night in regards to entering these no contact orders. They were hearsay. They require certain things to do. Somebody has to come in and certify them, whatever, on the court. And rather than waste everybody's time, he actually backed down from it. He said, if they want it, let them put it in it. He'll just contra it anyway. He was trying to defer to the judge. I think there's a lot of respect there. I think he sees the judge is really going to be right in the middle of it and make sure that the best case comes forward. And I don't, the state's taken a lot of abuse from the defense, and the judge has given the defense a lot of leeway on timelines and kind of understanding that they're coming in from behind the eight ball. It's a very difficult case in regards to the defense that they want to use. It required a lot of work on their end, because the interesting thing is that in 2021, when they were ready for trial, her attorney was Maurice Padillo, and he had been with her for more than a year and a half. He was ready. At first, they were going to do BSS, but there's a 30-day requirement. And what's odd is I think the information that was disclosed, because the defense's expert actually was called in as the expert at that time. and did her first interviews with Sarah Boone back in 2020 and 2021. And Maurice Padillo decided not to file to use battered spouse syndrome 30 days before trial. And then 2 weeks before the trial date, asked to be excused from the case for irreconcilable differences, in that he was not able to comply with what Sarah Boone wanted. I think she threw a hissy fit that he wasn't going to go forward. I think that I do believe that Julie Harper's assessment of Sarah Boone at the time did not fit what it was too risky going forward with, and her own words could be used against her. And I think that Sarah didn't listen to this attorney in regards to that. And they separated ways then, and then the ball started with all the other attorneys. But I find it curious that he had the same information and chose not to go forward with it.
In response to what Rodent said here, an attorney is under no obligation to refuse a defense they will know will lose. They can argue with their client about its chances, but if it's what they want, they don't have to quit. Yeah, they don't have to quit, but their only options are 1, quit, or 2, put on the defense that your client is asking you to. And if you know it's a bad defense, you know your client's going to get screwed using it. I really think your best option is to quit, because if you don't, you look like a fool, and you give your client an objection for, now the word has slipped my mind, inappropriate counsel, ineffective counsel. That's the word I was looking for.
Right, ineffective.
Yeah. And so, yeah, as an attorney, I just wouldn't take it. I would ask to be taken off the case.
In hindsight, they have. Several of the attorneys not only listed irreconcilable differences, but said that they were putting in a compromised integrity position that would compromise their legal ethics. I think they know that some of the things that Sarah was saying weren't true, like she wasn't being forthcoming, or there was no collaboration, or they found evidence to go against it in it. And when they're not going to go forward with it. Not only do they think it's not in her best interest, that she doesn't want to take their advice, but now she's asking them to compromise their professional.
And she finally found an attorney that was foolish enough to take it.
Well, I don't know. He just believes in her innocence. I want to believe that he really believes she is the victim here. I do. Because I don't want to believe, I mean, I have my opinions. I've looked into his history in stuff, and I'm actually sorry I did, because it has jaded my opinion of him, and I'm trying to be as unbiased. But his own actions in this case have actually caused a lot of my groaning and moaning. I don't like you've heard me talk before like this with these cases. When lawyers have bad respect in the courtroom or bad legal manners, it just tears me up, because I love it's my passion. I love reading this stuff. I love seeing it when it's working well oiled, to see a judge like this, see state's attorneys acting appropriately, even though they're there to prosecute and prove you wrong. They're giving due deference to the defendant and being respectful, and, compromising when they need to, and etc. What I see from these attorneys is everything I hate about how they do it. The grandstanding, the throwing hissy fits, they're just not doing the work. It's like they don't.
Hey, everybody. Thank you so much for watching our Sarah Boone trial coverage. Now, guess what? This isn't Sarah Boone's first time interacting with the court system. In fact, she had been charged previously with domestic violence against the same man she's now on trial for killing. And how do I know this? Well, because we put Sarah Boone's name and location into the Truth Finder search bar, and we were able to find out all sorts of information. When we scrolled down to her criminal history, we found minor things like a speeding ticket, but also the much more severe charge for murder
he
that
has
she's now
done
facing
before.
in an
It
Orlando
was over and
courtroom
above.
right now. And even if you don't work in true crime, you can
Yes,
find out all kinds of
I
information
turned it
on
off.
Truth Finder,
Hopefully
like
you don't
which
hear it
sex
anymore,
offenders
guys.
may
Like
live in your area.
Jesse
Even
Weber
use
got
Truth
me
Finder
again.
to see what's available about yourself online. Here's the main idea. It can be hard to know who to trust.
Channel
And
comment
knowledge
is
today
playing.
is
Wait a
power.
minute. I
So
have
right
it
now,
off. You
you
can
can
still
get
hear it?
50%
Or
off of
you
your
guys
first
are a
month of
few
confidential
behind?
background reports. Just go to
How could you still hear it? I muted it.
truthfinder.com/LC Live and access information on almost anyone.
Nope. I'm not. Okay. No, you guys
It's gone
can't still.
now. It's gone now.
Wait,
But it
like
was still there for a while.
Yeah, I heard him come up and then I muted it and it just like I don't know why it took so long on the YouTube end to mute because I literally muted the tab completely through the stream. Sorry guys, Jesse got us again. And I love Jesse Weber from Law and Crime, but like he's just been really missing my stream. So I do apologize for everybody with headphones on for that. Well, yeah, you sure did pick a good day, Granny. To walk. Fireworks, that was
Yeah.
Can you imagine the headline? Sarah Boone attorney meltdown, like day 4, the child. Like, it was a true hissy fit. Like seriously, I felt for the judge. At first, I couldn't understand what he was objecting to. He was not clear about any of it, except for like it just sounded like he misinterpreted what she was saying. As if she was supposed to by osmosis give him word for word everything she was going to say on the. It was a good point of hers, which was like, I told you I would answer if you asked. You never asked. You did not ask.
Yeah. Mm-hmm.
And she said that in front of the jury, didn't she?
I don't remember.
Because if that was in front of the jury, that was bad. I don't remember either, actually, if they were in or out of the room because it was so long.
Mm-hmm.
I'm sorry, Jean. YouTube is actually, when you're monetized now, there's minimal settings. Like, I can't even get some of them off, Jean. I have it on the minimal, but YouTube puts them on now. And I heard they're doing it to non-monetized channels also. There's not anything I can do. Sorry.
Who's J.L. Warren?
J.L. Warren?
Mm-hmm.
The guy that does the horror channel, and he also is an atheist in our community.
Oh, okay. No, I'm not familiar with. Well, Rodent says we should get Granny on an interview with J.L. Warren.
Oh, yeah. Well, I can introduce you. I did an interview with him. He's wonderful. He does horror shows and things like that, but he's also in the atheist community. He's Bridge the Divide. His channel is Bridge the Divide. Have you heard that? I'll send you the links. But yeah, I did an interview with him. He used to do the challenge with Charlie and I and Culture Cats. And he's been around, but he does like a weekly horror thing that is really, really, really cool. But he also, on his channel, Bridge the Divide, does some great content in interviews in the community. He's on the same page with you in regards to equal rights in the atheist community representation and being fair and having people open. But he's also, you think I can talk? Man, that interview, Goddess Granny, that is the only person that's come up and out-talked me. And yeah, that was something that I did enjoy working with him. He's wonderful. He just got really, really busy. His channel was blowing up, and has these opportunities in movie producing and in horrors. He's a great trivia guy. You'd like him. I'll send you the links and send a note out to him. I think you guys would be great together.
The one person that I think that can really talk is Richard Carrier, Dr. Richard Carrier. I've had him on 3 times.
Yes.
And when I have him on, I usually only have 2 questions for him, and he'll fill the whole hour. That's all I need.
Wow. That's good. Liam or Jean, could you drop JL's 2 channels for me? The Bridge the Divide plus the horror one. Are they 2 separate? I do believe they're separate.
I'll find it.
Yeah. Oh no, somebody in the chat. I think Beck was asking for it too. It's a week in horror. and Bridge the Divide. Those are the names of his 2 channels, you know. And he's got a great voice. He's a wonderful guest, Granny. It's
Okay.
I think you guys would hit it off. But damn, this is definitely, and lunch is so long. Yesterday we had a 2-hour lunch. Yeah, sorry, Jen, I forgot. Maybe Liam can grab them. If not, they're back. I will send them to you, and I will post them in the link after. But if I start searching now, I know that the feed will go weak.
One reason they may have the long lunch is because of what's available to the jury. I've done jury duty, and the court lets you out for lunch, and you've got to walk someplace, and you've got to order, and you've got to eat, and you've got to get back, and that can take a while, especially if there's if it's going to be a distance to get anywhere where you can get something.
Well, yesterday it was because they broke early, so they made it 2 hours. It's normally like an hour and a half. And he does do like sometimes a morning break and an afternoon break. He didn't do a morning break this morning because the jury got plenty of break because they kept getting kicked out of the room. But when there's long testimony, he makes sure that he does the break and everything. He's an excellent. I can't say enough praise. I can't put enough praise on this man, this judge, Michael Kraynick. He absolutely took a case that was absolutely running too long with a lot of problems with a very difficult defendant. And he's actually done everything he can to make sure she gets a fair trial, to make sure it comes to trial, to make sure they stay on track. He's bent over backwards. When she was pro se, he did everything he could to get her everything that she needed.
Any judge will do that.
No, but he went above and beyond. I'm telling you, like above and beyond. I mean, this actual defense actually had the nerve to make a motion for Sarah to get snacks and to interfere with the prison in regards to her shower time. I'm not kidding. With everything going on with their defense, that's what they wasted their time on. So you see who's running the show? This is it. They've got all of this stuff trying to get discovery done. 3 or 4 days before the trial, they dumped 550 pages of medical records of the deceased. It doesn't have anything to really do with anything, to prove that he had been in a fight with his brother and needed reconstructive surgery. That is actually inadvertently proves that he's violent because he had this fight, but he wasn't violent with her in regards to that, and it was an older record. And then the defense was ordered by the judge after the complaint from the state, because they were out of the discovery period and they were out of the last filings date, and it was a couple of days before. And so the state complained and said, if you're at least going to dump it, then show me what you're going to use in it, whittle it down to the pages that I need, so you're not wasting everybody's time. And the judge ordered them to do that. And it wasn't until the day of trial that it ended up getting tossed. They ended up saying, oh, we're just going to talk to Sarah about it. We don't intend to use it.
Oh, wow.
Oh, yeah. And they did another with 138 pages of photographs. They were asked to whittle that down, and they didn't. And then they had on there just the day before trial, they're going over new motions, and they bring up the discovery list. There were 5 items on the discovery list that of the defense's discovery list that they gave to the state that they didn't even have possession of and had never turned in. Kind of like what ifs that all got tossed. Yeah, the same thing with depositions in regards to witnesses. They all got removed from the list. It was kind of embarrassing. It was just so much work that wasn't done. And I get that they're behind the 8 ball, but there's 3 attorneys there from 3 different private offices with the availabilities of their secretaries and paralegals. There is no delegation of duties. There is no organization. There is no, when they took this case, I know that they're there because it's that 15 minutes of fame thing and it's going to do good for them, but it's not going to do good for them if they don't actually represent themselves well. And they have represented themselves to be sloppy and unprepared, and repeatedly, not just today. Like today was worse. Like his hissy fit is the worst that I've seen. He does ramble, but he has been called to task at least 5 other times for making objections without them being a legal objection, for just talking out loud to the jury and making his point, and not actually making a legal objection that the judge is trying to come. He has been asked for case law repeatedly. He's been asked, what is your point, and prove it to me legally. Like, I don't want to listen to this narrative. He just likes to just say, judge, this is my issue, and make it better. Like, I'm upset about this. And you can, and it's like, I know I'm paraphrasing here, but it's like, judge, I'm upset. And the judge is like, well, what are you upset at? I am too upset to actually formulate the words or point you to anything. Like, but I'm upset and you need to do something about this. Well, I realize, sir, it's not going well for you, but if you don't give me case law, if you don't refer to what you're talking about, I can't help you. It's not my job. Like, go away. Like, you know, it's like, just like it's not the witness's job to think about what you're going to ask them ahead of, like, sometime in the future, and then remind you that you didn't ask the question because you might need it later. Like, that's not the expert witness's job. You know, her responsibility is to answer your questions. If you don't ask the question, it's not her fault.
Yeah.
They don't.
She knows her stuff, though.
She does. Did you see that face she was making? She was like, boy, I keep like, boy, dude, are you stepping in it? Like, she's like, she looked at that jury like, can you believe this? Yep, just another day in court with an incompetent attorney.
Yep. Well, one thing I said when I was in law school was anyone could get through law school. It does not take intelligence. It takes perseverance. And so if you're willing to put in the work and you stick with it, and anyone can do it.
Yeah, I think I'm guilty of referring to them as the show up degree. I actually accused them. I said, well, here's the proof, people. There are such things as legal show up degrees. He just attended class and here he is. Because what is that? Like, what is that? And I guess depends on the kind of case.
He had to do more than just show up, because he had to pass the bar exam, and that is no slouch.
Yes.
You've got to study for the bar exam.
I could tell you another little embarrassing story if you want to hear it about what they did in this case. He wanted to bring in a crime scene investigator, and it was a guy who had been a medical examiner in Florida and in another state. And he wanted to have him recreate the crime scene and actually redo the autopsy. And I'm not going to mention the name because I don't want to be disparaging. But however, come to find that this man no longer had a medical license. He was fired from his jobs as medical examiner in both states for not filing reports and doing other things, and that he had been guilty of doing private autopsies on the side, which is not illegal and perfectly okay. But what he did was take the money for those autopsies and never provide a report, or anything. And then he actually forgot to pay his dues on a storage unit, and when it got turned over to the storage company and they actually auctioned it off, when the person who auctioned it opened it up, they found all the body parts in jars.
Oh my gosh.
Oh yes.
Oh my.
Oh yes. And he actually submitted this friend of his. Like, all of these attorneys are all friends of his from way back, like college days. They've been hanging out ever since. Okay. Shady likes shade. Let me just tell you that, because he's trying to bring him in as the expert witness, and it's going to go through JAC. Now, you know, JAC has some. They're not going to pay for somebody that's not licensed in the state. This man has no medical license, and they want him to recreate the crime scene and speak on the autopsy as an expert. Okay, because he's been a medical examiner, which he was fired from, which he now lost his law license in both states because of this issue with the other things, like body parts that don't belong to you, that you kept from family, without permission in a storage unit. They were in bags and cups and jars. It was horrible. Okay. and all that's out there. And all of his, he files a formal motion to bring him on as an expert.
And then Jure has a hilarious comment there.
Yep. Private autopsies aren't illegal. Jeffrey Dahmer, I was just doing private office. Yeah, but you actually have to be registered as like a doctor. Like you have to have a license to practice to do it and to do the service. Sure. So I guess, yeah, Jeffrey Dahmer, if he had just gone to medical school, he would probably be okay. No, that is
I was just doing an autopsy, officer. Oops, I didn't realize he was still alive when I started the autopsy.
Yeah. I'm just saying, like, this was actually crazy. And then all of a sudden, when they submitted for JAC, like, to actually pay for this guy as an expert witness, it vanished. They withdrew it because, you know, JAC probably called them up and goes, you know, he doesn't have a license, right? Like, there's no way this is not getting through. We're not paying for this. Do you want me to formally send in the rejection, or do you want to withdraw? Because if that formal rejection had come in with the reasons on it, oh man, that would have looked terrible. But they withdrew it. But it was all over the media. Like, that was like lit. It was all over the media. And some of the other things too. Like, there's a lot about this defense team. I mean, we all speculated because somebody answered the ad in the first place and stepped up. We knew whoever did to do pro bono work for Sarah Boone would have an agenda of some sort, you know, to be part of a very public case, to publicize their private practice. And that's all fair and good. Like, and I don't see any problem with any of that, you know, because they do have to give up their time. They're not going to get paid for it, you know, but they have to go in there with their eyes wide open. Like, I just don't know. I think he thought this was going to be a cakewalk, and it's definitely not. It's definitely not. But he knew what he was getting into. He met with her 4 times before he took the case, which the judge brought to his attention when he cried about, you know, deadlines. You know, I do love this judge, man. I do. So compared to what you've seen in your experience as an attorney, you got any stories worse than this, or is this like what you got?
Not from real cases. I've seen. Well, let me change that. Not from cases that I've personally witnessed. I've certainly read stories about cases that were just as bad, but I've never seen anything this bad.
Yeah, this tops the cake. This really is like too much for me. I mean, I've had to mute because, like, they literally hear me groan and they start laughing in the chat. Like, they'll do something, and I'm just like, oh my God, I just can't. I stopped muting because, like, I need to get it out. After like the first couple of times in hearings, like, I felt like I was going to explode afterwards. It's not good for my blood pressure or my stress level. Like, I need to orate it. It needs to pop out, you know, or I'm going to have issues. I chose my own mental health over, you know, trying to be as unbiased as possible. It's clear I'm biased now. I don't even try to hide it anymore. It's clear I do not actually. Hold on 1 second. I have to answer that. I'm sorry, but there's something going on in real life. I have to deal.
Take care of. Okay. All right. Let's see. Do we have? I saw a comment there. Oh, Rodin said, "Is that like being an unlicensed gynecologist?" Yep. That's what it's like. All right. Anyone in the chat have any questions or comments about what we've seen today? Or any other trials that you're interested in? I don't watch a whole lot of criminal trials. When I'm in court myself, I'm always in family court, and the trials that I'm privy to usually are confidential, and so I can't actually discuss what goes on in the cases, but I can talk about what the attorneys do, and I can talk about what the judge does, because that's not confidential. Just the actual rulings and the people involved in the cases. But yeah, I don't have a whole lot of dealings with criminal. And when I worked as an attorney, I worked as an insurance attorney. So I was in I was always in civil litigation, never in criminal.
Okay, so no murderers, no like real huge, but civil could be just as like weird though, right? I mean,
Oh
stuff
yeah,
happens
it can
in
be.
civil. Yeah.
The
And
case stayed with me completely. I mean, that I will never forget is a work comp case for a woman who had a psychiatric permanent total disability. I worked for an insurance company that insured churches, and she was a pastor, and she and her friend went to a warehouse to pray about whether they should purchase the warehouse for the church. So it definitely was, something that was work related. And while they were checking out this warehouse, some guy came, hit her in the back of the head with a 2x4, and raped her friend. And after that, she has never worked since. She stays home. She is a total recluse, and she just does not have any contact with humans other than her husband. She really is truly permanently and totally disabled on a psychiatric disability.
I'm assuming there was a criminal case prior.
Oh yeah.
Yeah, and so now they're doing a civil just to take care of her.
Well, I was the work comp attorney. I was handling her work comp claim. We insured her church, and so we were paying for her work comp benefits.
Wow.
And yeah, we're not going to get anything from the guy that actually committed the crime.
Damn. Okay, this is a good one. Answer. I can answer this for you. Have we already discussed if her strategy is to go for incompetent counsel? It's going to be very difficult to do because every single day, sometimes twice a day, and whenever an extraordinary event like something being omitted or added in late to testimony or evidence happens, the judge specifically addresses Sarah Boone and asks her if she's happy with her counsel, if she's on board with the defense, and if she has anything that she, wants to bring forward. He addresses her immediately. He is definitely working into anti-appellate mode. He does not, judges don't like to be overturned, correct? Anyway, by their peers. But he is really dotting the I's, crossing the T. Now, whether or not, that's a question for Granny, whether or not what just happened today with the actions of her attorney are going to go over and above what the judges do.
I don't think so. And I don't think so for the exact reason that you said. I think the judge has been very clear that this is exactly what she wants, and she's happy with her counsel. Could she?
And in all fairness,
she still could make the argument. I mean, she still could file the appeal, but the judge is making it extremely difficult for it to get accepted. Liam has a question here. It says, is there a particular reason why the defense could be justified in not liking that the expert has changed, updated their opinion since the deposition, or is it just saltiness? No, there could be a very good reason for that, because if the expert witness gave one opinion in the deposition and a different opinion at trial, that is definitely cause for an objection to the opinion. Unless there is some new evidence that has caused her to change her opinion. And the attorney is correct on the legality of it, that if she's given one opinion at deposition and has changed her mind since then, that the defense has no opportunity to prepare for that. And of course, the remedy is exactly what the judge did, is letting him do a new deposition to find out what changes in her opinion. But she actually didn't really change her opinion at all.
No, here's what it appeared to me, and please interject, Granny, if I get off track here, because like I'm not a lawyer, but what I saw was that the state themselves, this is their witness, understood her to give certain testimony, and she wasn't going to go, like, nobody had asked her about certain things, but it appeared that the defense, that something came up that they were not prepared for, because it never occurred to them, and they never asked her if PTSD or BSS was relevant to what she was charged with. And this this actual expert witness is saying she's there to testify about BSSS and the mental disorders and all of this. But what she's saying is that based on what Sarah is telling her happened, none of that is relevant.
Yep.
It doesn't apply. And they were not prepared for an answer like that, because that changes the whole thing. Okay, that changes everything. Now, even the state didn't know she was going to say that because nobody asked her.
Right.
Okay?
And the state probably did know she was going to say that, because they probably did ask her, but not in deposition.
Right. And they probably knew that she was going to say she doesn't have PTSD, but they weren't going to ask her because they know she didn't say it prior. No, and they were going to let her talk about the BSS. He actually said that. The state attorney, Mr. J, actually said that. Your Honor, we talked about this. Like, we know what she was going to say, but we had no idea that that was going to be the answer that came out. I understand why the defense is upset. They were not prepared, but it's not the state's job, the judge's job, or the witness's job, okay, to think of all the things that are going to affect the defense's case.
Right.
You know, in my opinion, it's the defense's job.
It's the defense attorney's job to ask the correct questions. And if you don't ask the correct questions, you don't get the correct answers.
And then he actually is so incompetent, in my opinion. He actually put that forward to her, and she said, "That's not you didn't ask me, sir. You didn't ask me. If you had asked me, I would have told you. It's not relevant. It's not relevant to my opinion. My opinion on whether she has PTSD or BSS doesn't even matter if she has it or not, based on what she told me happened. For her own words, and they were not ready. It never occurred to them that somebody would just say, you could say she has BSS till the cows come home. It doesn't change what happened. And it's not relevant because she was not having that kind of an episode at the time. It's like trying to claim a moment of passion crime, while you were calm. Basically, that's what she's saying. It's not relevant because she has nothing going on at that time that would have done it. And I don't think they were ready for the jury to hear that or to put that in the mix. You know what I mean? To put that into their mind as to that's a possibility that perhaps this whole defense is to help her get away with something that she actually did. Her absolute disregard for life, which is what she's accused of. That's why it's murder too. We know that her action didn't cause his death. Her hitting him with the bat did not cause his death. Okay. She did help him get into the suitcase, so she did restrain him. It was not against his will, but when he asked to get out, she didn't let him out. And then when he begged her to let him out because he couldn't breathe, she had indifference. She had reckless indifference to life. And that's murder too, right? That is what she's being accused of. There's no way around it. She's guilty of that. She's admitted to doing all of that. It's just whether she's going to get an acquittal because she's got some reason, some extraordinary reason for why she did that.
Yeah.
But he's still dead. And that has to be answered to. So it's kind of like, they want to say self-defense, but there's no knife, there's no gun, there's nobody, but it's her perception of the threat that she would die. And they're not seeing, this witness is actually saying, I don't see her as perceiving to be an imminent threat.
Right.
And they weren't ready for that. And this is the hissy fit. This is the hissy fit. They were totally not ready for it. But it's not anybody else's job but theirs to actually try to know exactly what this is going to say and what is going to come out and what you're going to have to fight against. They're in charge of asking the questions and gathering the information. She did not have to call them up in the middle of the night because she had a thought. No. And they never asked. Does she, I think the judge was brilliant in how he handled it. I feel bad that he had to. He did everything, and he's quick, right?
Mm-hmm.
Damn, does he have some good clerks. They had those cases up for him on that computer like that, so that he could go like, and it was annotated, so, right? He was reading it annotated, that they went right to the section, highlighted the lines for him, told him what was pertinent. They were also brilliant. I want to give them a shout out. His team is excellent. Judge Kraynick's team, top notch. He is always totally prepared and well informed on the fly. He didn't read that case law off the top of his head from memory. You know this, right? You know that they were like, boom, boom, boom. There it is.
Yep.
Brilliant.
And that the defense attorney couldn't do that speaks to the competence of the defense attorney.
The defense attorney couldn't even come up with a legal objection.
Yeah.
Not one.
Mm-hmm.
What would be the legal objection to contrary testimony to a deposition?
It would depend entirely on the facts, but
how about statements not in fact? Facts not
evidence. No, this is where you're offering the facts into evidence.
Yeah, but the evidence already is the deposition from before. So, she's saying something different.
Is not part of the evidence. The deposition is just used to impeach the witness. It's the testimony of the expert right here and now that is the evidence, and so the objection you're thinking of assumes facts, not in evidence. And so if the expert is giving an opinion based on facts that have not been offered, yeah, you could make that objection, but I don't see that would apply here.
It would at least been an attempt to do what the judge asked.
Mm-hmm.
I was like,
yeah, actually, it would have been a good attempt. It would have been a good attempt.
Yeah.
But then all she has to do is testify as to what she based her assumptions on, which she did after the jury came back. She testified to all of what the defendant said and what the defendant did, and that all of her assumptions were based on that. So yeah, she did put into evidence what her assumptions were based on.
Mm-hmm. Oh, Aunt Jer, I know you just joined, like you said, but boy, it was like it was a mess.
Mm-hmm. It was a mess.
It was a legal rodeo that turned into a clown show in seconds. Like it was bad. It was pretty bad. But it did show what this defense has been like, how they react to stuff and everything. But it does highlight the competence of the judge, in how he handles stuff, and it was quite brilliant. I recommend you go back and look, either my feed or any of the legal feeds. Go watch that. It's definitely worth the time. Liam says here, let's see. So even if she has some kind of PTSD, Sarah's testimony to the psychologist didn't show any instigating events which could provide a reaction based on that diagnosis. Exactly, which is why she's saying she could not give any information. She says she did not have enough information to make a diagnosis of PTSD based on Sarah's own words in answers to the questions that she made to her.
Right. Mm-hmm.
That is what she actually said. Different words, but that's what she said. And she did say that again. Well, she did add to it and say it's not relevant anyway, because based on what she said about the incident, it does not relate. And that's the part I think that sent him off the edge, made him jump off the ravine there, because they weren't ready. They weren't ready for that. And I don't think the state was either. I think it's a feather in their cap for sure. They couldn't ask for anything better than the jury to actually say, all of this is not relevant because the facts of the case, it didn't happen. Whether she felt there was imminent threat or not, it wasn't there. And her reactions were not of someone under imminent threat. That's what they're saying. Based on all of the stuff that happened before, they don't see any threat. And I think they were worried because that actual imminent threat of the fingers in what he said is what they used as the overt act to get the BSS defense approved to go forward. You have to state it. And from what I understand, it's a very low bar. You just have to feel that there's a threat and you just have to prove it why you felt it. Well, this expert witness is challenging that by saying everything that happened prior to that proves that her statement is basically false in how she was actually feeling at the time, because her own words and reactions are proving the opposite. That could be a big problem for the state. Maybe they're worried. Maybe the defense was worried that their whole lots of stuff would get stricken. Like, I don't know. Like, I don't think you can go back and take all the testimonies away in regards to battered. This is only an expert's opinion, right?
Yeah, it is. But expert opinions go a long ways. Juries give a lot of deference to expert opinions.
Right. And they're just going to weigh up the previous expert testimony and her testimony and decide which one they find more credible or which they believe, which scenario they believe, right? So
yeah,
I'm not sure. I'm not sure he did himself any favors today.
No, he didn't. There's no question he didn't. And tomorrow, kiddo is right. You know, Sarah smiling about this is just like, she totally doesn't get it.
She loves the fact that they go so hard for her, that they are defending her like this, that they like, she thinks she's right. She wants, like, she is living, like, this is her best moment. She's got all of these people, like, on her side. All she wanted was her voice out, somebody to listen to her and to think what she was saying was, that's what it is. She got to testify. She had her moments. She's been smart. Like, when one of the worst things that I saw happen so far in this trial was the defense were sitting, you know how they sit. They've got Owens on one side of her and Mr. Henderson on the other and Sarah there. And the CSI who collected all the evidence was opening the box for the suitcase. And we had Mr. Cacciatore, who's the DA, the district attorney for the state, the head guy for the state there. And you had the witness at the time was, I forget her last name. I think it's Barden or something like that, but she was the crime scene investigator that collected everything. And she was helping him, she was going to open up the box that the suitcase was in and they were going to take it out. And as she's going through it, the motions of opening it, she's standing there at the podium with the state attorney, and Sarah Boone starts laughing with her attorney, chuckling and telling jokes. This is the suitcase that her boyfriend that she was with for years died in. She's on trial for murder. They're going to show where he died. You should see the looks on the judge, the attorney, and the witness all looked over at that table, and the look of disgust on all their faces was like, I have a picture of it. I captured it from the stream. I couldn't believe it. I was like dumbfounded, like absolutely dumb. That's how serious. Like I at that point I was worried about competency of the defendant, whether she was competent to stand trial, like whether she actually knows what's going on. But she does answer all the questions. The judge is going out of his way to make sure that she understands what's going on every step of the way. And because I'm wondering if maybe he thought there was some competency issues there too, based on that behavior. Because man, and you know what? The jury saw that. The jury saw that.
Yeah.
Like, I was just like, you're not helping yourself.
There's no question
like
she does not belong in society. The only question is whether she belongs in jail or in a mental hospital. But she hasn't even raised mental defect as a defense. No.
Although BSS, would you not say that is part of it? Like, you're saying there was a stressor and you acted like other people would not. Yeah.
But that's not the same as insanity. She could have raised an insanity defense.
Well, there's all kinds. There's temporary insanity at the moment,
Right.
like
Right.
but this one, based on the abuse, this is all based on intimate partner abuse,
Right.
being in an abusive relationship, and it's really hot in legal right now. I don't know if you know, like from state to state, this kind of defense. Florida is one of the ones where it's a little more messy. They've got really strict requirements. They're really finding their way with it. The pro and cons, state and defense. Nobody actually knows, even judicially, where everything sits with it. Legislation is still being crafted, and case law is still being developed. This case will be used in multiple cases from now on by both the state and defense to prove issues, because it's a mess. It's absolutely a mess. And I think, having it as part of an acquittal process, I'm uncomfortable with. I think it should be actually part of a sentencing mitigation, for a reason, because we're talking murder here. And we're talking, not with anybody's hands on you, not with anybody actually holding you down and doing anything. This defense is used when a woman, after years of abuse, walks up to a sleeping man and shoots him to death. Okay, that's the prominent case law on it and why the statutes are there. Does it actually fit here? Yes, because he was confined. He was in a suitcase, and there was no actual physical way for him to harm her at the time. Well, she felt the threat. She remembered everything he's ever done to her. So she beat him, she beat him with a bat, and she left him there to die. She chose not to help him. I guess it relates, but to me, I still have issues with it. I don't. All of the acts of abuse have been two ways. And I think that's the issue the defense has been fighting against. That a lot of the testimony proves that Sarah also was an aggressor. And one issue I have, I'm not sure if Brian Boone, her ex-husband, is coming back today, because there is body cam interview with detectives where Brian Boone put on record, not actually in evidence yet because they haven't played it for the jury. The jury hasn't seen this. But he actually said that during their marriage, when she started drinking, she gets aggressive. And he has had to physically restrain her from hitting him and fighting at him and scratching at him. And that he never hit her, but he has had to physically restrain her multiple times, that she is an aggressive, abusive drunk. And, two things can be true at the same time. You can be abused and be an abuser.
Yeah. It's been a lot of fun, but I need to get going. Thanks for having me on.
Thank you so much. Come back anytime.
Okay.
Definitely. Okay. Thanks, Granny. Thank you.
Bye.
Oh, guys. Well, you guys, this has been crazy, like really crazy today. We got another half hour. How do you guys feel about taking a break, putting some music on? I did think that Kelly was coming, but I don't see her. If she does show, Kelly from Justice for Kelly, not Kelly from Godless Granny. But if she does show, I will turn the music off. But are you guys okay with a little music for a bit, and then we can grab some more coffee and maybe a little bite to eat? It was so great having Godless Granny here. I thank you so much for coming up. It's so great to have an actual, to have your perspective, because I know you've been there, right? And I'm sorry you had to see them at their worst, but I'm actually kind of glad you did, because wow, that was a lot. That was absolutely a lot. Are you so? Yeah, thank you, Karen. Yeah. It does. You know what, Liam? I kind of agree. It does smack more of vengeance than defense to me. It really does. You know what I'm going to do, guys? I'm not going to leave for the whole half hour, but I'm going to take 5 to 10, 10 minutes. Okay, maybe 15. I'm going to put music on to loop. I'm going to put the feed of the courtroom back on so we don't miss anything in case they come. But if you'll be patient with me, Lou, coffee, and a snack. I got to make arrangements for the desk. Okay. But I will be back very, very shortly. I thank you all for your patience. And boy, today is quite the day for all of this stuff. Let me find you something to listen to a little bit. Let's see. How about one of our favorites? Chris Zabrisky's Undercover Vampire. Let's listen to a little bit of that. And I will be back in a few minutes. And back. Thank you so much for your patience. Okay, I think I'll do this one. Hi, guys. Thanks for your patience while I went and did what I needed to do. Which I hope you all took a little bit of a stretch. I'm gonna go through and look some questions. There was one here I see from Aunt Jer. Thank you, Liam, for answering. There is a timestamp, Aunt Jer, for the actual when she testified on one of the prior days. I believe the actual stream is marked that she will testify, so that you can find it. And I did do timestamps there. There is a playlist listed in the description here that'll lead you to those videos. I don't have a separate one of just her testimony. I mean, Sarah Boone's testimony. But it is clearly indicated there. So hopefully you can find it. If not, let me know and I will link you. I will go back later and get it for you and link it for you. And thank you, Liam, for answering that. Glad the timestamps are all come in handy, and I'm very glad that you know all about them and we're able to give the information. I really appreciate it. Okay, let's see what else. Chill if you're still here. I hope you have a good nap. Good question there. I wonder this too, Liam. I wonder if Owens will realize that he needs to give up trying to convince the jury and just try to convince Sarah that he is doing the best to convince the jury. True. I have a little something to add to that I just read on Twitter, and I actually concurred because I know I can be very biased. I do make fun of these attorneys because they really do annoy me. I do, it's how I feel about the legal system in general that gives me this bias. I don't like unprofessionalism. I do realize, though, we'll hold for a minute. For the crazy stuff that you guys were talking about that happened earlier today, so I need to go back to the beginning to watch that. Was it all day or during a specific person's testimony? Actually, the stuff that happened today is only relative to today's stream. So just go back to the beginning of this stream when they start with the testimony of the witness Tanya Warner. Today, we are not actually timestamped, but I can tell you that it is, she started at 30 minutes, 43 seconds into today's stream is when Tanya Warner, Dr. Tanya Warner, starts to testify for the state as their expert witness in rebuttal to the testimony prior of, everything that happened prior and the defense's own expert witness in psychology, which was Dr. Julie Harper, sorry. Hopefully that helps, Andrew. 30 minutes in today is when they start. And apparently he didn't like something that she said they went into the depositions, but the legal fireworks that happened back there is all on display from that moment on. And then you can see everything that happened. There was a Richardson hearing. The whole thing went forward. Well, here's what I wanted to say about that. I just read a comment from the lawyer, Trey Law, Pete. He said he's pretty clear about one thing, and I happen to agree with him. Regardless of how we feel about Sarah Boone or any of the attorneys here, what we just witnessed today was the justice system when people are passionate in defending their side. Mr. Owens, as much as we don't like how he did it, he was absolutely putting his passion for the defense of his client right out there. He was fighting tooth and nail to get something out of the eyes of the jury that could be prejudicial to his client. Okay, that's clear. Regardless of how I feel about how he did it or that I think he's throwing a hissy fit, let's just, for prosperity, say that was his motivation. Because it should be. Okay. And then the state who actually came forward and say, listen, we see what happened here. It wasn't our intent. There's nothing that we did to violate anything, but if anything needs to be done, let's go through the legal proceedings on how to handle it. And then what we witnessed was Judge Michael Kraynick solving this issue legally and appropriately with the tools that are available in the court system itself and the procedures that are in place to resolve an issue like this. And it was, the way he handled it was, I would say, almost perfection. Like it could be used to teach other judicial students in wanting to be a judge on how this gets done. And I'm glad his students were there to see it. And I'm glad we are all able to see it. But we can't negate the passion that one has, whether you're on the state or the defense as an attorney, for making your case and doing what you need to do with passion to fight for what you believe is right. So I will give a nod to Mr. Owen in that direction, and take a step back and say, I don't like how you do it, but I do appreciate that you're doing what you're doing to fight for justice for your client. Because if you think something was wrong here, if you think that there's been a misstep, then of course you should raise an objection and fight tooth and nail to get what is right for your client. But I mean, I do reserve the right to sit here and grumble and complain about it and make a little snarky comment here and there. But in the end, it's a legal system that I admire so much and have great respect for. And I have to say, as much as this looked like a three-ring circus, it's actually a perfect example of how our system works in resolving problems in its own itself, within itself, about problems it creates itself in the legal system, But, so should I just that's me taking an almost step back and saying, okay, I get why you did what you did. I don't like how you did it, but I have to actually applaud that you did it. Okay, Tanya Warner, 30 minutes. Yep, thank you. Yeah, I'm glad you heard me, Enter. I want you to get it because I really am thinking that this is actually, a great example of, Judge Kraynick's brilliance. Hands down. He comes out as the shining star of everything in this scenario. Of everything. The ringmaster kept the lions from eating the acrobat. Well said, Liam. Exactly. Owens does not listen and does not think quickly on the fly. It is exasperating. Yes, I really think he misheard what was said, and he was misreading and misstating what I think he was so upset, he knew what he just heard was going to really damage his case, and he wasn't prepared for it. And he was objecting because he thinks it's the opposite of what he heard in the depositions, but it's not. He never asked the question. So she's not giving a different opinion. She's now actually expanding by being asked, which is her right and which is the state's right. But I don't think anybody was ready for what she was going to say, because basically what she said is, BSS, PTSD, none of it matters because she wasn't triggered at the time of the incident. Boom, blows everything up. So obviously there's going to be a tangle. There's going to be a tangle in regards to that. He also gives the impression that if he had all 4 years to prepare, he still would not be prepared. I think that's his style. He's a rambler. How many times have we heard Judge Kraynick ask him for the actual legal objection to not talk from the desk or while he's walking in front of the jury? That sidebar is sidebar. You come up, you either make a legal objection, which is like a 1 or 2 word objection, to what's going on, let the judge rule on it, or you come up to sidebar. He does not do stuff in front of the jury. The judge is very much against that. It's prejudicial. And he really, it's bad manners, as far as I'm concerned, on Owens's part, to not actually understand the judge rules this courtroom in the behavior in it. And if he tells you that's the way it's going to be, you really should comply. It's his house. It's just bad manners to do otherwise, Well, anyway. So, do you guys think we're going to make it through the rest of the day? Earlier today, I gave you information on the fact that the state The state is actually asking for an in-chambers conference, which is going to happen, I think, today, because they have questions on how costs are being paid to the attorneys, and then whether or not there are any private deals going on in regards to a media deal, which would be against Florida state statute prior to any determination of this case in a pro bono case. Okay. I like this. This is what I always say about Kraynick dots the I's and crosses the T's, and June said that Owens crossed the I's and dotted the T's instead. Yeah, it did look bad. And I'm wondering how that's going to pertain to the jury, on whether it's going to look bad or whether they're going to like go along with the passion that he's fighting for his client and doing everything he can. And something serious happened here, because they could interpret it that way, that there was a serious violation that just happened, and like, you know, they were witness to it. And here's, you know, the hero Owens fighting for Sarah Boone because this is the right thing to do. It could be interpreted that way. I wish I could have seen their faces. But I did see the witness actually make faces at the jury as to, can you believe this? Like, she had to correct him how many times that's not my complete answer. Yes, she said the word no, but she doesn't mean no in its entirety. And him just pressing that made him look belligerent. It really did. It made him look like a bully. It was aggressive. And she wasn't saying, it was obvious that he wanted her to say certain things, and she wasn't going to say it. And, you know, she's not there to say what he wants. She's there for her opinion. Her answer's her answer. You know? But, wow. I tell you, Juju, did you fall over? I mean, you're okay, right? Like, because I almost fell out of my chair. Like, I don't know how many times. I couldn't believe what I was seeing. I mean, I knew things could get crazy, but I wasn't expecting that. But Judge Kraynick was brilliant in how he handled it. Yes, her expert opinion. But now it's going to be up to the jury to decide and weigh out the experts' opinions on both sides. And I think there's things they can take from both of them that benefit this case. You know, and hopefully they will. But it depends on if they're just like tired of the rodeo, like if they're tired of the shenanigans, you know. I also wanted to comment on the state's attorneys being so honest and respectful of the process, letting Judge Kraynick, having faith in Judge Kraynick to handle it appropriately to prevent a mistrial. There is a lot of faith there. He did back down. He's like, I don't like the accusations, but I did not. I've talked to her, and it's not something she's ever said before. So there is no like purposeness here. But then they had the Richardson hearing immediately, which is appropriate. And we had a Richardson hearing prior, you know, in regards to the 550 documents and the pages of medical documentation and 138 JPEGs that they dropped with no explanation or no usage or no like what they're going to be doing with it, back and forth on that and whether they've complied. And that was on the defense. And I don't know if this filing in regards to wanting to go over there, if the defense and their team actually have a media deal or not. I wonder if that weighs in, but that filing was done like on the 21st. I do know that Owens often says he's not aware of what's been filed. He doesn't look, or nobody gives it to him or whatever until a day or two. But I would think with the trial going on, he would have known, you know. I get alerts. I mean, you know, but you know, he's busy. They do have a lot of irons in the fire, and they do have a lot of work. that they're doing. But like, come on, like Granny said, there's 3 of them and 2 paralegals. Like, why isn't anybody doing what they need to do? And it does look like they were not prepared for this testimony, yet they had an 87-page deposition that they could have went through. I mean, Owens has been an attorney for a long time. I just think his style is totally different than what happens in Judge Kraynick's courtrooms. Judge Kraynick is on the ball, and he has a fantastic team, like I was saying before, behind him. They had case law pulled up for him, annotated. They knew exactly what they were doing. He knows what to ask for. He gets it right away. And he expects answers. If he can do it sitting on a bench, he expects these attorneys to be able to do it in a day or 2 at least. But if he asks you straight out, what's your legal objection, and you still start going on with rambling stories and not being able to tell, it just doesn't go over very well. And I think he was actually being patient. He saw that there was an issue there to address, but I actually saw him have to craft the whole thing and explain everything. Which is his job as the judge, and I'm glad he's so good at it. I just really expected Mr. Owens to come forward. And then I guess he thought it would be a delay, like that they wouldn't have to do a deposition right away or the Richardson hearing, but it was all handled immediately. And he was given the opportunity to pursue anything he wanted with this witness without the jury there for them to hear, so that he could find out what she was going to say. So it did resolve the issue, but I'm not so sure it was like what he was looking for. Yeah, Liam, I don't know. I just remember them being there when the judge was asking for certification dates and filing dates and all of this other stuff, and nobody made a move to assist Mr. Owens. This particular judge was given this case based on when the other judge was being moved to a different area that he's being transferred. So this judge took over. It actually got assigned to him. It's usually a random rotation. There's like a head judge that does like all the scheduling, and then when they have availabilities and they go into a pool, and it just gets randomly assigned. Same thing happened. Brian Koberger over in Ada County. Judge Hippler got that one. They're randomly assigned, like they're up in order. So it's not like they get to go over, oh, this judge would be very good with this one, or, this is a difficult client, so we should give them this judge. No, but it does actually benefit because Judge Kraynick's temperament and the way he handles things was totally what this case needed to be moved forward in regards to Sarah Boone. Because he is very patient, but he's also very firm in how he dealt with her from the start, telling her this is the way he is, taking the time to educate her on the whole situation, making sure she understands. And that's the difference. He goes well out of his way to make sure you understand the issues and that your rights are protected. He actually did more for protecting her rights in this case than anybody I saw so far, including her defense attorneys. Because I think he does have her best interest at heart, not like trying to get her guilty or not guilty on the charges, but just the fair process, the judicial process of having your right to a fair and equitable trial. With, he's really done everything above and beyond that he can, what he feels within the scope of his responsibility. I bet you Judge Kraynick is the type of person that if you told him what a great job he did, he would be like, this is my job, these are my responsibilities, like it's no big deal. Like he would just poo-poo it, like, I'm not so great, this is what we need to be doing, all of us, judges in general. He's just fantastic. I think Chair, like, he is my favorite right now. I don't know if it's because I've had so much exposure to him right now, and I'm dealing, we're watching everything that he does. I am following quite a few other cases, and he knocks my socks off with his professionalism, his mannerisms, his caring nature, his patience, and his absolute love and respect for law in the system the way it is. Like, it just oozes out of him. My kind of judge, my kind of guy, my kind of person, my kind of human. Like, he's just all that. Yeah. And when Juju and he hook up, like, she's gonna invite me to dinner. Like, we're gonna have a great conversation. I jest, Juju. I have to pick on you a little bit because we both just love this judge so much. What level of court are we at here? We are in the hold on. I can get you an official answer for that one. I had it listed here, and it's just, he's in the 9th Judicial Circuit Court of Florida in criminal, okay, out of Orange County, okay. And I can get you something here. Here you go. Trellis Law has a little bit on him here. Okay. But he's really a great judge. He's been in Florida most of the time, almost his whole. He's it's not only just Orange County, it's Osceola County too. This 9th district covers. He was actually appointed by Governor DeSantis way back in 2019, when there was a vacancy created by a retiring judge at the time. He was moved up to the 9th district. Well, I mean, he actually was a private practicing attorney prior to his judgeship. And he's been in Florida his whole life and career. So he's local boy. Oh, Jennifer Giroux was amazing also, Liam. Oh, but another one of my favorites was actually, we all know Judge Newman, right? I just loved his gentle nature. He did know his law, like he did, and he took his time, and he just cared for those jurors, and he cared for everybody, and like the stretches, and he was like pleasant and amiable, but he was also no nonsense. Like, he was also very no nonsense about the law. He wasn't going to have anything happening in his courtroom. That was a tough trial too. That was the Murdaugh trial, Judge, for the murder case. But he also had all of the financial cases too. He had all of the Murdaugh cases in South Carolina, which was a hot mess. I mean, I actually was okay with Judge Boyce too in the Daybell trial. I think he handled some difficult issues there legally, or with the death penalty and things that were going on. And I had some respect for him too. Not like Judge Kraynick though. Like, Judge Kraynick is just like he runs circles around most of them. He's just so quick, and at the same time so kind. He's so well informed, and he makes sure that his rulings are proved by case law over and over. To make her pro se, it was 17 pages, and it was riddled with case law in every event, in every opportunity that she was given to actually have the public defender and what had happened with it. Every time she was advised that there's not a revolving door of public defenders, there will come a time where we're going to run out of giving you somebody, that you have to work with your attorneys. Yeah. Well, this judge is actually protecting the jury too. He's quite annoyed that he has to keep sending the jury out. In what he does try to respect their time and their consideration. He's always very respectful and in regards to them having to wait. Like today was ridiculous. Like we didn't have a morning break because they were on break like most of the time, like the whole time. They should have been coming back at 1:30, right? If like we went out at 12. Ooh, I'm gonna go to Twitter and see what's going on. Just double check the feed. I am all up to date on it. Let's see if anybody's in. You know, Jules is not in the classroom. Did I say classroom again? I did that last week too. I meant courtroom. Yes, I definitely meant the courtroom. She had been in the courtroom all week. I don't know if she's there this morning. I saw a post that maybe I haven't been seeing many of the tweets. But then again, I don't know. I'm not seeing anything. Well, then again, when I'm here, I don't watch any of the other feeds. I'm like looking at the socials. You know, basically all I'm seeing on, the socials over and over again is that everybody seems to believe that even if Sarah Boone is stating she was in fear for her life, she's also testifying that she left enough room for him to get out. The contradictions in those two statements need to be hammered home, and it's what I see repeatedly over and over and over again on the socials, that people are so aghast, like we are, in regards to that her own words. For anybody who wants to go over Tanya Warner rather's statement, here is a Twitter feed with a link to a video that gives the full 20 minutes and 35 seconds of what was going on. Apparently, there's a lot of talk also on the socials in regards to how nasty Owens appeared in front of the jury at the time, and that it wasn't a good look. They're saying that, he definitely, there were some looks. The jury was making some looks. There's also posting that James Owen has been going around to many of the people that are at the court posting and whatever, saying it's 100% false that he has any rights to any stories of Sarah Boone before or after in lieu of payment. It is just not true. And so that's going to be part of another closed hearing. We're not going to be party to that. I don't know if that's happening today. That could be happening right now, and it could be part of the delay. Well, he was talking to podcasters in, the media in general, and saying it's absolutely 100% false in regards to the actual defense team having any kind of agreement. But I wonder, like, is he going to be able to sell his part of the story anyway? Like, can he do that? I'll have to research that. I can't see how they could control that. Oh, we're back.
We are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Dave Castro on behalf of the state. William J. for the state.
Defense.
James Owens for this bill.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. All right. Are we prepared to bring back in our jury at this time, state?
Yes, Your Honor.
Defense.
No, sir.
Yes, sir.
I want to make another motion. Judge, I had a chance to read this transcript, and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October 4th, 2024 deposition of Dr. Tanya Werner.
Okay. Yes, sir. I have it in front of me.
May I sit?
Yes, sir.
I'm referring to page 38 at the very bottom, line 21. Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you were aware yesterday, so I had to prepare for those and go through that. So I had not had time to process through all of my notes prior to this deposition today. Page 39.
Why is that?
Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge set for October 7th for jury selection. Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know. Maybe we could discontinue your deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and then you have other opinions that are not going to be covered. Then at 13, Mr. J says, what is your position? And at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental report, or if there becomes a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once the jury is sworn and jeopardy attaches. Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J. Line 9, Mr. J. I think you need to plow ahead. This is our time where the court reporter is prepared to give us a transcript by the end of the weekend. And if something needs to be amended, then she can A, issue a report, and then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I moved for a total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues. Anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
The judge, we go on, and I see what she's doing, that she's saying, hey, I got jammed up. I had a deposition yesterday. I didn't really have time between the evaluation and the deposition 2 days later. She had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So
That's respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment.
Yes, he did identify them. He covered the whole issue. There is a lack of understanding on
Mr.
page
Owens'
59,
part here
line
on
22,
what
is actually being stated.
Question is asked. Okay. And do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question. Well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which were in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about Jorge Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished?
Because the court ordered you to take her deposition. because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know if he was going to ambush me at trial. I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related to battered spouse, post-traumatic stress, and whether or not there was an imminent threat at the time of this event.
And the court's addressed that. The court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing, analyzed the 3 factors as required by Florida law with regard to those, and gave you the opportunity as a cure. Now, with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she had, based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Judge, this deposition did not end on page 40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42, where it's acting like it's concluding and, is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his two fingers out and I hit them with a bat. So there was rule of completeness. But for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any of all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd, 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel? Okay.
Judge, I've got Earhart's Florida Evidence 2023 edition, volume 1, Charles W. Earhart.
Let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that in redirect. Is that clear?
Clear to state.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements, and you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed.
Like, sit down and shut up, Mr. Owens. How clear could he be?
Absolutely allow you to go into those things.
Does he actually have to say the words?
I appreciate that, Judge.
No, you don't. Okay, I've lost my mind, people. My apologies. I've lost my mind.
I'm taking care of it, counselor. Give me a moment.
He literally just said, case closed. I've ruled, stop it. And this man is still going.
Yes, sir.
Judge, I'm referring to Earhart's treatise, section 9.73, opinion on the ultimate issue. I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectable because it includes an ultimate issue to be decided by the trier of fact. And in that section 703.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony of expert or lay witnesses and is not bound by their conclusions. Merely because a witness expresses an opinion to an ultimate issue
Exactly,
does not
Chester.
compel the jury to find that the facts to be true. The jury will be given the
This
opinion.
attorney needs to be
The
sanctioned.
jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing
She did not give
their
an
conclusions when the
additional
opinion only
opinion.
tells the jury how to decide the case.
You didn't ask the question, dude.
Witnesses will be prevented from expressing
You
their
can't
conclusions
blame
when the opinion
her.
only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness
It
cannot
does help
express
the
his or her
jury.
opinion as to the guilt or innocence of a criminal defendant.
She didn't say anything about her being guilty or innocent. She said it didn't matter if she was diagnosed with PTSD or BSS. based on her
703.1C.
own statements.
When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is
The judge
generally
doesn't agree
inadmissible.
you that she
The
just.
danger
she
is that the
stated no
witness
fact.
will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, an expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at counsel's table.
I know, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible factual conclusion, or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with the trial judge. For example, the admission of expert testimony that certain investments, it goes on. However, the witness expresses an opinion about the intent of the accused. The opinion, this is important, one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, counselor,
If I could finish.
respectfully, counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to
Oh,
testify
I
that the
have
quantity of
not
cocaine
heard that
possessed by
tone
appellant
before.
indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble. Officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 2nd 1376 for Gamble and Fluellen 703 2nd 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with based on what the defendant had said to this expert. She was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
No,
If you're
you
just going to be
cannot.
reading from the treatise, I've already read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And
He
I was
is.
about to finish
Yeah.
this text, this section. When this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Warner, and I wrote it down. She said based on what Sarah Boone told her, she was not facing imminent risk of harm.
That's right. He's allowed to say that.
Invades the province and function of the trial judge to determine the applicable law and
Not
to instruct
for an
the jury
expert
otherwise,
witness
which we haven't
in
even done yet.
psychology.
You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record. The court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains.
Thank you.
Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address,
Sit
Mr.
down
Owens?
and shut up, Mr. Owens.
No.
State?
You gave it your best
Nothing.
shot.
Thank you,
Now
Judge.
stop.
Okay, let's bring back in our panel.
Wow. I have never heard that tone that we heard before with Judge Kraynick. That was his last nerve. Please, everybody, just great love for this judge. I can't believe he has to do that. I understand Owens has a bone to pick here. What that expert witness said to that jury changes things. I understand where he's coming from, but there was no foul play. He's calling for sanctions on it. He's calling gross prosecutorial misconduct. That was rude. He's lucky he's not sanctioned right now.
You can just stay where you are, counsel. Let's wait for them to come in.
And get a gag. Get a gag. Somebody put a sock in it. It didn't go his way. That man does not like the word no. Oh, he will, Liam. He will. He will actually try to get this in front of the jury. Yeah. I can't even. I'm gonna have to mute. I understand his passion. I do. But arguing with a judge that way, the disrespect. The judge had to tell him 3 times. He's already ordered on it. The entitlement. What does that
State,
remind
you
you?
recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. Thank you. All can be seated. Members of the jury, welcome back. Juror number 2, back row. He's already ready. I see those hands are raised. You know what's coming. Y'all complied with the court's instructions, right? Thank you. Record reflect all hands have been raised. Mr. Owens, you may continue your cross-examination, sir.
Dr. Warner, I don't want to rehash it, but just for the jury's sake, would it be fair to say that the text messages that you were forwarded by the state attorney for you to review, you did not deem to be relevant to your evaluation?
Right. They demonstrate.
Ma'am, it's a yes or no question.
Yes.
Now, from what I understand, when the state attorney sent you the information, they did not send you any videotapes.
Correct.
So you have not reviewed any videotapes in this matter.
Correct.
The suitcase videotapes, either one of those you have not reviewed.
I have not seen them. Correct.
Okay. Or any body cam videotapes you have not reviewed.
They're described in the police report.
My question is, have you viewed any of the body cam videotapes relating to this incident?
I have not seen them. Correct.
Prior incidences between the two of them, have you reviewed any videotapes, body cam videotapes of any prior incidents?
I have not.
Have you reviewed the audio tapes related to some of the questioning of Sarah Boone?
I have not.
Have you reviewed the autopsy report?
It's described in the incident report, but I did not see the actual autopsy report.
Now, you're aware that we have called two experts, Dr. Michael Brannon and Dr. Julie Harper. Is that correct?
Yes.
And you're aware that they are forensic psychologists.
That's correct.
And you are a forensic psychiatrist.
That's correct.
So they didn't go to medical school and you did.
That's correct.
And they don't understand medical issues, so to speak.
I don't have an understanding of what they understand medically.
Do you recall telling me that they don't understand medical issues, so to speak?
They haven't been to medical school, but I wouldn't understand their medical knowledge.
If you would look on page 22 of your deposition.
Objection collateral.
Approach.
Okay. Listen, this is bad. I hope on redirect the state gets to actually say, why do you find the cell phone records not relevant? because again, he's not letting her say, because they both use the phone, I don't know who sent the message, which is what she was trying to say, and he keeps cutting her off. He wants her only to say what he, like, this is,
Objections overruled.
Dr. Warner, have you had a chance to review your deposition on page 22, starting at line 7?
Yes.
Could you read down through line 11, your answer?
Yes, I'm talking about psychologists in general, not with regard specifically to your experts, which is what you were just asking me about.
Okay, but you would agree, your opinion is psychologists typically do therapy, but they don't prescribe medication or understand medical issues, so to speak.
Correct.
yes, and that is the definition between the two.
But I wasn't specifically talking about your experts, which you were just asking me about your experts specifically. And I said I didn't understand.
Can't be impeached when, you know, you're
That's
trying
what you
to
said
twist
under
it.
oth October 4th of this year.
And that is
Sustained.
the actual definition of the difference between psychology and psychiatry.
Now, is it fair to say that the majority of your work is in the field of competency to proceed and guardianship evaluations?
Actually, the majority of my work is in patient care. I work 7 days a week on the crisis stabilization unit, actually treating patients.
You work 7 days a week.
Yes, sir.
So as a forensic psychiatrist doing forensic work, the majority of your work in that area is in the field of competency to proceed and guardianship evaluation.
As a forensic psychiatrist, correct. As a psychiatrist, I work 7 days a week on the crisis stabilization unit.
And where is that unit?
It's located in Lake City, Florida.
So you work there 7 days a week.
Yes, sir.
And then you also do this forensic psychiatrist work doing competencies to proceed and guardianship evaluations.
That's part of the what comes under the umbrella of my forensic work. Yes.
That's the majority of your forensic work.
Yes, that's the majority of that's the most common cases that we're asked to.
And then next in line would be sanity at the time of the crime.
Yes.
So you would make a determination and submit a report to the court as to whether or not a defendant, an accused, is legally sane or not at the time of the offense.
Yes, that's correct.
He's not helping himself here. He's proving her valid opinion that if she says there was no imminent harm for her being under the, like, she's got
Is
a
it
lot
fair
of
to say that
experience.
you also testify weekly as a treating physician through Baker Act Court?
Yes, that's correct. Every Thursday, we have Baker Act hearings with regards to our individuals who are being held in our crisis stabilization unit.
Is that in Gainesville or Lake City?
No, sir, that's in Lake City.
Now, Lake City from here is north of Gainesville?
Yes, sir. It's approximately 40 minutes north of Gainesville.
Now, I believe you said you've testified in battering spouse situations in court approximately 5 to 10 times?
Yes.
Is that correct?
Yes.
And you often refer to that as intimate violence cases?
Yes.
He's assisting her credibility here.
Now, my understanding that after you had a chance to evaluate my client, Sarah Boone, and I believe you evaluated her 2 days before the deposition, so it would have been October the 2nd of 2024.
Correct.
As to your diagnosis as it relates to her, Do you believe that she suffers from a generalized anxiety disorder?
No, sir.
Now, you're aware that she was previously diagnosed prior to you evaluating her. She was previously diagnosed with a generalized anxiety disorder.
She told me that she had previously been diagnosed. I did not see any medical records with that diagnosis in it, but she told me that she had previously been diagnosed with that.
Did you attempt to secure any other records to us?
Sustained.
Did you diagnose her with an adjustment disorder?
I did diagnose her with an adjustment disorder.
Do you believe that if she was diagnosed with a generalized anxiety disorder, it's really not that, it should be an adjustment disorder?
A lot of the symptoms overlap for the two diagnoses, and we see that quite often, that the different diagnosticians or physicians come up with different diagnoses based on a conglomerate of symptoms. So it's not uncommon for the two diagnoses to overlap based on the symptoms.
Do you agree back on October the 4th, 2024, when I took your deposition, that you could not make up your mind at that time whether she suffered from generalized anxiety disorder or an adjustment disorder?
I had not made a clinical decision at that time. I hadn't reviewed all of my documents at that time.
When did you make a clinical decision that she suffered from adjustment disorder as opposed to generalized anxiety disorder?
It was probably within the next week when I was reviewing all of the, going through all of the documents in her interview more thoroughly.
Dr. Warner, did you agree you did not notify me?
Judge, may we approach?
Yes.
Wow. Wow. I do believe that that was not, I'm thinking inappropriate. I'm not a lawyer. I mean, I'm not like, but to me, after all of this, after everything that just happened, he is still trying his case, but now he's doing it in front of the jury. I don't know about you guys, but I think that's sanctionable. He was instructed by the judge that his order was already on file. The judge took the time to explain to him under what precedent, what case law, and look, there are no words. Well, there's words. I just don't think they're appropriate for YouTube. This was distasteful. That's mild, Charlie, to what is going through my mind right now. And if Sarah Boone, I kind of feel bad for her right now because I don't think she has a clue at how damaging that looks. And the jury, granted, I know the jury could go either way. They could think that he's really being a champion for her and that there's a serious issue here. But what he must have just done is stepped in deep doo-doo in sanctionable material right here. As a court violation, a direct order from a judge. Like, come on. People end up in jail for that. And he was stomping his feet about prosecutorial misconduct. And he does this? You know that what she's going to say next, right? She's going to say, you didn't ask me the question. I have no moral obligation to call you about anything. If you don't answer me the question, it's not my job to tell you what you should be asking me.
Objection is sustained.
Dr. Warner, you agree that when I took your deposition on October the 4th, you had questions, in all honesty, about whether or not you felt like Sarah Boone suffered from a generalized anxiety disorder versus an adjustment disorder.
I was leaning towards adjustment disorder secondary to her being in the correctional setting, and I think I said that in my deposition. I didn't know that I had enough information from her because I only had information from her. I didn't have anything in the medical records to support generalized anxiety disorder. So I wanted to review that.
I'm just learning it now as you testified here today.
Sustained.
Is this the first time you've let the parties know that this is your opinion?
That I believe that she has generalized anxiety disorder?
No.
Or that I believe that she has
Adjustment
disorder, yes.
Now, from your evaluation, you determined that she had a personality trait,
That's correct.
and you felt like that she had a grandiosity issue,
Yes, she has a narcissistic personality disorder trait.
a trait, one trait.
Correct.
Do you agree a lot of people have one trait?
Yes.
Okay, a lot of people have a grandiosity trait
Yeah, that's correct.
that are not narcissists.
But I never said that she was a narcissist.
She didn't. No one has. All they keep saying is trait. No one called her a narcissist. Oh, except for me. Like, jokingly, and maybe some other people on social media. Mandy, all I can say is it gets worse. It just keeps going.
Is it your opinion that Sarah Boone has alcohol use disorder?
Yes, that's correct.
And are you forming that opinion based on Sarah Boone's admission to you that she was an alcoholic?
I'm going to refer to my notes. She has a history of being diagnosed with that. She also acknowledged to me that her use had been problematic.
So you formed the opinion that she suffered from alcohol use disorder based on the history that she presented to you at this evaluation?
It was based on the totality of the information that I was provided. So the medical records demonstrating that she had been diagnosed with it in the past. Her ex-husband in his interview in the police report described her as an alcoholic, and in her description of herself having a problem with alcohol.
Do you acquire a tolerance over time if you drink on the regular?
That's one of their criteria.
Do people also have a genetic tolerance for alcohol?
They may.
Now, as it relates to battered spouse syndrome, would you agree that that is a recognized syndrome in the psychiatric community?
Yes.
And you have heard no criticisms of that syndrome?
No.
And you would agree that's a subset of post-traumatic stress disorder?
Yes.
And you would agree that Lenore Walker first developed the theory of post-traumatic stress syndrome?
Yes.
Now, I think at the time of this deposition, you were not sure you knew Lenore Walker.
I don't recall that.
All right, look at page 54.
Approach.
Wow, he's actually going to try to educate the expert in her own field. Look at her face. Like she's just like, wow. Like this is one she'll be talking about for a long time. This is a lunch story that's never ending. I'm glad she's got some humor about it. In my opinion, she's being absolutely attacked and undermined here. She's being accused of saying things she didn't say. She's having her words twisted and manipulated. I know that these are tactics that attorneys use in general to get out the information that they want in front of the jury. But I don't think this is I think this is something else. Something has absolutely lit a fire in James Owens. And I want, you know what? Maybe I'm just paranoid and I'll take it on the chin and you all can call me out for it if you want. But I am watching a man overreact to almost everything. And I'm curious as to what he's really worried about here. What is he really worried about? What is really going on? This looks a little bit more than absolute defense of Sarah here. I want to know the rest of the story. There's more here than what we're seeing. Actually, Rocket Couch, at this point, I think that Owens has done everybody's bingo card. Anybody who's working a bingo card, just send them in full, all clapped off. Because, like, oh, I mean, he's hit them all. I'm not sure, Rodin. Like, I actually don't think she has a good grasp of what is going on here. If she is happy about it because they're defending her so zealously, like, I can understand that. You know, it's all about Team Sarah. And it should be. They should be defending her zealously. But to actually, he's literally misrepresenting things that people said and things that he has read. He reads it out, and everybody understands
Objection
the
is
words
sustained.
except for him.
Dr. Warner, do you recognize Lenore E.A. Walker's book, The Battered Woman Syndrome?
Jester, I'm going to give you a chance to remove that before I have to, please. Let's not go there.
Because I have not read everything. I haven't read it. And
Okay.
So I can't say that I agree with everything in it.
Thank you. But I do understand your sentiment. I do. I appreciate the cooperation, though.
Is it clear to you that Sarah Boone was involved in a violent relationship with Jorge Torres?
Yes.
Mm-hmm.
Do you agree that there was a violent cycle that occurred during that 3.5-year relationship that Sarah Boone had with Jorge Torres?
It's been described that way, yes.
Would you describe it that way?
It's been described that way to me, yes.
Do you have an opinion?
Sustained.
Do you have an opinion that that was a violent cycle between Sarah Boone and Jorge Torres?
It's been described that way, yes.
Do you agree that Jorge Torres was the abuser and Sarah Boone was the victim in that?
It was a volatile relationship. In the police report, her ex-husband actually describes her as being the aggressor.
Wow! Yes! You got what you wanted, right, Mr. Owens? Because you really wanted the jury to hear that one, didn't you? Oh, I feel so much better. Buy that woman a whiskey.
Have you ever seen this photograph?
I have not.
Do you see the injuries on Sarah Boone?
I do.
I'll show you the defense identification H. You see this photograph?
I do.
Have you ever seen it before?
I have not.
Do you agree that's Sarah Boone?
I do.
Are you aware that Jorge Torres
Sustained.
I'm going to show you defense identification G. Have you ever seen this photograph?
I have not.
Wow.
Read anything about Jorge Torres using a curtain rod as a weapon against Sarah Boone?
I don't recall that specifically.
Identification F. Have you ever seen this photograph?
No.
Defense identification E. Have you ever seen this photograph?
No.
Oh my goodness.
Identification D. Have you ever seen this photograph?
No.
Have you ever seen a videotape relating to this?
Exactly, Jester.
Identification A. Have you ever seen this photograph?
No.
Right, Mindy? Oh my God. Wait till you get to the boom. Woman, you need to call me. I need an intervention.
Now, I believe at the time of the deposition, you had spent I think on October the 2nd of 2024, you had spent 2.5 hours evaluating Sarah Boone, and about half of that time was giving her a test.
Yeah. The mental status examination takes approximately 5 minutes.
Okay. Did you go through her entire history of abuse over the 3.5-year period within the 2 hours and 20 minutes that you had?
No.
Now, I understand that you indicated you may take a couple more hours to go through your file and your notes and to come up with your conclusions. Did you do that?
Yes.
Have you spent any more time on the case other than that 2 hours?
I re-reviewed the documents.
Have you made any other attempts to go see Sarah Boone anymore?
Objection, Proffer.
Sustained.
You agree that your opinions are subjective, not based on authority?
They're based on my education and training and years of experience.
And you would agree they're your subjective opinion?
Correct.
Would you agree that Sarah Boone suffers from battered spouse syndrome?
I do.
Would you agree that battered women's experiences affect their perception of imminent danger?
They can.
Would you agree that victims of repeat violence may fear death in a situation others would not?
They may.
Because someone suffers from battered spouse syndrome, they have a heightened sensitivity to danger.
They may.
He's going to allow her to say, but she doesn't. He's setting himself up here. He's trying to do a gotcha with her. And he's making it worse.
You agree that people suffering from depression and anxiety are predisposed to getting into a relationship with a partner who may be violent?
They may. Each individual is different.
Are they more susceptible to getting in a relationship if they suffer from depression and anxiety with a violent, intimate partner?
They may be.
Do you agree that the DSM, I think you have it there with you,
Yes, sir.
directs that the clinician should consider post-traumatic stress disorder if there was exposure to extreme stress? Do you agree with that?
Yes.
Did you do any testing to measure whether or not Sarah Boone had post-traumatic stress disorder?
No.
Is it your opinion that Sarah Boone suffers from post-traumatic stress disorder?
Again, she did not give me enough information to formulate an opinion with regards to that.
Asked and answered. This witness is not going to say what you want her to say. Keep twisting. You're allowing her to give the possibilities to the jury. You're allowing her to give the other side of the coin.
You agree that an intimate partner who commits acts of violence, physical violence against the victim,
he doesn't even know what he wants.
Extreme stress in that individual.
It may.
It may. It's possible. Doesn't mean it
agree if
happens.
That is the cause, the violence is the cause of extreme stress, that a diagnosis of post-traumatic stress disorder should be considered?
If they meet the criteria. They have to meet the diagnostic criteria.
Do you agree that there is a sense of learned helplessness when someone suffers from battered spouse syndrome?
Yes, that's part of the syndrome.
Do you agree that these women, these battered women, have learned the probability of receiving a beating, and they recognize specific predictive cues emitting from the batterers?
Yes, but it's not just women.
I understand, but you would agree the vast majority of intimate partner violence, battered spouse syndrome victims are women.
Yes, intimate partner violence, yes.
Excuse me?
Intimate partner violence, yes.
The vast majority, the lion's share, are women.
Yes.
And these battered women have learned the probability of receiving a beating by recognizing specific predictive cues emitted by the batterers.
Correct.
And many times, these predictive cues result in a high level of anxiety.
Yeah.
And in that situation, the battered women may attempt to reduce through several different means, one of which is to avoid delaying the beating.
Yes, we talked about that with the cycle.
What is a basal instinct?
A basal instinct? I have no idea.
Primal fear?
Primal fear is just being afraid.
Is that a natural instinct that animals have?
Yes.
Fight or flight instinct?
Yes.
You don't even think about it.
Correct.
Do you agree that victims of battered spouse or battered woman syndrome suffer from self-isolation, suicidal thoughts, and oftentimes substance abuse?
They may. Each individual is different, so they may.
And they may show signs of physical injury and illness, such as bruising and chronic fatigue.
Yes, those can be signs.
The syndrome, battered woman syndrome, is the psychological effects of living with an intimate partner violence. They may have intrusive memories,
They may.
where they re-experience past traumatic events in their mind.
Yes.
They have high levels of anxiety,
Yes. They may.
hypervigilant when something doesn't seem right.
They may.
It leads to this fight or flight response that we spoke about.
Yes.
They have problems with sleep.
They may.
They often go into denial,
They may.
minimizing what is happening to them,
They may.
numbing their emotions.
Some of them.
Disassociation. A battered woman may often develop a defense mechanism of being able to psychologically detach from their body during the traumatic experience.
Sustained.
Panic attacks, severe depression, very low self-esteem, poor body image, disassociation, learned helplessness. All these are symptoms of a battered woman syndrome.
Compound, some of that.
Sustained.
You agree panic attacks is one of the symptoms of battered woman syndrome.
Sustained.
What are the symptoms of a battered spouse syndrome?
They can be numerous symptoms, from anxiety symptoms, mood symptoms. They can have psychotic symptoms. It can be any vast majority of symptoms, substance abuse symptoms, any vast majority.
Do you agree fear is a symptom?
Yes,
Somebody in a constant state of fear.
maybe, yes.
In terms of the abusive partner, do you agree that they would hit the victim,
Some of them, yes.
kick the victim,
They may,
punch the victim,
they may.
choke,
These takes all different forms.
choke,
They may,
burn,
they may,
destroy their belongings,
they may,
use weapons to hurt them,
they may,
threaten to hurt them, their children, or their pets,
they may,
take their car keys,
they may,
take their debit card,
they may,
may,
take their vehicle,
they may,
control where they go and who they see,
They may.
force them to have sex when they don't want to.
yes, they may.
And that goes both ways. The list that he just read was the same one that the state read yesterday to his witness and made it quite evident it goes both ways. Both George and Sarah did the same to each other.
Dr. Warner.
There are two victims in this
I
case.
know you spent a short
However,
amount
only
of time
one of
with
them's
her,
dead.
and you're saying you didn't get some of the answers as to whether or not.
Objection sustained.
If you'd have spent more time with Sarah Boone, could you have uncovered as to whether or not she suffered from battered spouse syndrome?
Could have, should have, would have.
I agree that she met the criteria, or that she had battered spouse.
How about post-traumatic stress disorder?
It's possible.
Thank you.
Any redirect examination?
Yes.
You may proceed.
Absolutely. Popcorn.
In your decades of experience, have you ever treated patients that suffer from trauma disorders?
Yes,
Nice choice
How
of words
frequently would
there.
you say you do that?
I have patients on my unit right now that I'm treating on a regular daily basis who have.
How about patients that meet the criteria for battered spouse syndrome?
Yes,
How many would you say over the course of your career?
probably 5 to 6 a month on my inpatient unit.
And that's a lot of months.
Yes,
How long have you been doing this?
since 1998 when I began my career at the University of Florida on faculty.
Now, on cross-examination, you were asked about some diagnoses, correct?
Yes,
Any of these things that you talked about, narcissistic personality disorder, adjustment disorder, anxiety, battered spouse syndrome, any stress or trauma-related disorder. If the state wanted to ask you those opinions, would you have been receptive to more materials before making any opinions about those topics?
yes,
And is it your testimony today that you don't have enough information to necessarily make a complete and proper diagnosis on any of those things since you have not been provided those materials?
correct.
Now, you've testified that she does meet the criteria for battered spouse syndrome.
Yes,
But you would be receptive to any evidence that you were provided, right?
correct.
Going back to what you testified to on direct when the state asked you your opinion about this case, everything that you just talked about with Mr. Owens, does that change your opinion about whether or not battered spouse syndrome is applicable to the facts as Ms. Boone relayed them to you about this incident?
No, not at all.
And why is that?
Because again, she just.
Objection, Judge.
This is already what she testified to before, that it was Sarah's own explanation of what happened that leads her to believe that BSS was not an element of the situation at the time of the crime. She's allowed to have that opinion, but he doesn't want anyone to hear it. They've already heard it 10 times. That answer was to you, Juju S. Is Owens in a different courtroom?
Objections overruled.
Based on your conversation with Mr. Owens, you've indicated that your opinion did not change, and now would you answer why?
Yes, so based on my interview with her, the way that she described the incident to me, and that they were laughing and having a good time, it didn't play into relaying any kind of triggers or any kind of trauma.
And I'm showing you what has been marked for identification purposes by the defendant as I. Does this photograph inform you as to what happened?
No.
Does it inform you as to who was the aggressor?
No.
H for identification, same questions. Does it inform you as to what happened?
No.
Does it inform you as to who the aggressor was?
This is brilliant.
Same
This
question for G.
is brilliant.
F.
No.
E.
No.
D.
No.
And A.
No.
If those specifics as to what happened and who was the aggressor is dependent upon the credibility of somebody, would you want to take into account all the things that can make a person credible or less than credible?
Yes, you would want to take that into account.
And you talked about alcohol use disorder. Would you take that into account if somebody is under the influence of alcohol or had been consuming alcohol when they relay a history as to things that happened?
Tomorrow, kiddo, I'll expand a little more. What the state attorney just did was take away the sensationalism of pictures of injuries. There are some graphic pictures of injuries that the defense has made a big deal about, showing that Sarah has been hurt. But they allowed the point to the jury to consider that a photograph of an injury does not attest to the facts of how it happened or who did it. Because how those injuries happened, they only have Sarah's words to go by. There is nothing else. And there is actually contrary information to where she is the aggressor in many times. Could you get a black eye in an altercation with your intimate partner that you instigated by tossing him down the stairs or choking him and he threw you away or elbowed you? Yes, you could. It allows the
Would you
possibility
consider
that what she
somebody's
says is
alcohol
not true.
use and level of intoxication in evaluating the credibility of them as a historian? And you were asked about whether or not you did any testing for post-traumatic stress disorder.
Correct.
And you didn't.
Correct.
You already indicated, however, you believe that Ms. Boone meets the criteria for battered spouse syndrome.
That's correct.
Again, that doesn't change your opinion that you gave when talking with me on direct examination.
Object, asked and answered.
Overruled.
Specifically about this question about the testing that you did not perform. Did this lack of testing have any change or effect on your opinion as to whether or not battered spouse syndrome applied to the facts of this case?
No.
You were questioned about insanity on cross-examination. Do you recall that?
Yes.
Would you agree that simply because somebody is mentally ill and meets the criteria for diagnosis such as schizophrenia, bipolar, any of those psychotic or mood disorders, that doesn't necessarily make a person legally insane?
Correct. The two aren't equal.
Likewise, even if somebody meets the criteria for battered spouse syndrome, does that mean every action they take against their intimate partner is justified?
Correct. That's not that they wouldn't be equal.
So even if you do have battered spouse syndrome, even if you are in an intimately violent relationship, that doesn't necessarily mean any action you take against your partner is justified.
That's correct.
No other questions?
State, can this witness be released?
Yes.
Defense.
Just if we got a phone number, we can reach out to them.
Okay. All right, ma'am, you're released, potentially subject to recall. Thank you.
Yeah, she looks really anxious to pick up that call. Exactly, Liam. Point
State,
made.
call your next witness.
Judge, at this time, the state would move P for identification and evidence.
Is this a videotape or on video?
It was also very wonderful how she got to say what Brian Boone was not able to say on the stand because Sarah had not testified to the overt act yet for BSS. It is now in evidence. She said Brian Boone has accused her of being the aggressor in their relationship.
State moves P for identification and evidence.
That also is Mr. Owens' fault.
It's 18.
Got it. Okay. Any objection to what was pre-marked as P? Counsel, any objection to what was pre-marked as P?
Commissioner Love,
No, he's offering it in evidence. Any objection?
no objection.
All right, what was pre-marked as P will be received into
What is
evidence
wrong
without
with him
objection to
today?
states 21.
Something's going on. Seriously, people. Something's going on with Mr. Owens. There's something else behind like a lot of this. You crack me up. Yeah. They really were, Mandy. It was brilliant. Oh, did you hear? Did you see what happened, Grady? You gotta watch. The state was rather brilliant in a while, but we heard a tone from the judge we've never heard before. Oh my God. He's still at it. He is still at it.
State moves V for identification because of picture.
Any objections?
No objection.
What was pre-marked as V will be received into evidence without objection to states 22.
May we approach?
Yes.
Wow. Wow. I'd say go back about an hour. Right after lunch. Well, it's not timestamp left, but when they come back from lunch, he starts all over again after the judge ordered and settled everything. He starts all over again with new things that he wants to add to it. And it gets rather tenacious. He's very tenacious. And the judge, actually, I've heard a tone come out of him that in all this time since January, we have never heard. Through all the frustrations, all the refilings.
Members
all
of the jury, it
delays.
is 2:52 in the afternoon. The next part of the state's presentation are going to be some videos and other things that we read to you that may take a little bit of time based on the length of them. So we're going to go ahead and take our afternoon break at this point in time. Similar instruction I've given to you over the last couple of days. Please do not conduct any independent investigation or research into the person, places, things, or charge involved, and do not have any discussions with anyone or amongst yourselves about those things. And we'll bring in 5 after. Thank you.
Okay, so like a 15-minute break, like, you know, you're welcome if you wish, if you wish. But oh wow, you're welcome to come up if you'd like, Granny. Yes, I know, Mandy. Mandy, are you caught up? My goodness, do you want a link? I know you're at work though.
Y'all
Like,
may be seated.
it's
Thank you.
okay. Like,
State, anything we need to talk about? Defense? All right, we'll be in recess till 5 after. Thank you.
I know. Listen, I'm going to be time stamping the video if you want to wait to catch up later. But man, I know, Mandy, believe me, but we got to talk. You need to call me. Like, I apologize, everyone. I'm a little bit animated right now. I get that. but I have never seen anything like this. The fact that that man actually was on the borderline of sanctions, arguing with a judge like that in public, I just beyond. And then does exactly what the judge like already instructed not to do. He was very clear about what he was allowed to do, and not like I'm beyond. But also the turnaround by the state. And I know often in this case I have been very pro-state with some of the things that they've done. But I have to say that was brilliant, because when Mr. Owens presented all of those photos to the expert witness as if she didn't do her job because she didn't know about all these interviews. Well, she does, because she did have the medical records and she did have police records that talk about those interviews. She didn't see the photos. So he's trying to get those photos in front of the jury again and make the point that this woman is not being sensitive to a victim. And then the state shows the same photos and asks her, does this tell you how it happened? Does this tell you who did it? Flipping the switch, okay, again, for the jury to say that this was a contentious relationship. They both abused each other. They did. And that it's quite possible, it is quite possible, we may never know, because Sarah is unable to testify to what happened in those 9 minutes between video 1, where he's in the suitcase, in the picture in the video at the end where he's still in the suitcase. But she says that all of the violence that she did happened in the 9 minutes in between. We don't hear the trigger. We don't see what happened. We just know that she's the aggressor. She put him in the suitcase. She zipped it up. It's all fun and games. She sits on the couch and maliciously taunts him while he begs to be left out. We do not hear his aggression. We do not see anything. But in that 9 minutes, per her statements, she took a bat and started whacking at him, saying she was in fear that he was going to get out and hurt her or kill her. She then takes another video. He says her name. We know he's alive at that time. She then says she went upstairs and went to sleep. If she was in that much imminent threat, how did it resolve? Where did it go? How did it stop? Besides Sarah's words, where is the evidence of it? This expert witness is putting out the possibility that she was not in imminent threat. There was no imminent, and there was no reason for her to perceive it. And she doesn't believe she actually felt it. That's what she's saying. And that's what they're upset about. Because now that possibility is there. Yesterday's possibility with the expert witness floated through that George also is a victim of BSS. Based on the conditions that all apply to Sarah, they also apply to George. And unfortunately, Mr. Owens let it out today with this expert witness that Brian Boone has put on file in a police interview, that Sarah Boone, when she gets drunk, was the aggressor in his marriage. She was the aggressor and the abuser. She was violent. She said it. Well, she didn't say that abuse. He didn't say that. He said that she was aggressive and he had to restrain her often. That was from the interview that we all heard. The jury has not, I do not believe, has heard that. But now that the door is open, we're going to watch hours of video today. And I'll bet you Brian's interview with the attorney is there. I mean, with the police is there. The door is now open. And it's not going to be painted very well for Sarah this afternoon, the rest of the afternoon. I actually think he might be on cola. Some kind of job. I don't know what job might be, but at this point, any job he does will be better than whatever he's doing now. And you are absolutely talking about Owens, right? Yep. I can't even imagine. He's on cola. That's what's wrong with him. I mean, something's wrong something like there's something he's acting. I don't know. I understand like fighting, for what you think. He just didn't actually put it in terms that the judge. I mean, I think the judge pretty well understood the issue that he was fighting against. We're back already? But they're not. Oh, they're back, but they're not. He's sitting there, but they're not back yet. Okay. I don't know. I do not know. It just seems to me like he's just very, very. He wasn't thinking clearly. I don't think. Yeah, I just don't. I mean, they are sloppy, but I've never seen anything like this. That was way above. And to actually call gross misconduct on the state because he didn't ask questions, because he did not ask adequate questions in the deposition. I think some of his behavior may be sanctionable here, especially when he put that out to in front of the jury, to the expert witness. I don't know. I don't know, but I know they all got together and researched it because he looked very embarrassed and it was very embarrassing that he didn't have enough. And, he's just, I will admit, like some people just take longer to process stuff and to actually think of what cases they want to use. And he could be the type of lawyer that needs to review and and that's all perfectly fine. Everybody, like not everybody's like snap, quick on their feet like Judge Kraynick, or have a whole team behind them that is able to understand his needs, where he wants to go. And when he says this, like what you do, obviously Judge Kraynick has a wonderful team behind him that he has been able to express like how he likes things done, and they do it, and they know what he needs, and he's well versed in the law, and he knows exactly how to prove his points. And he expects lawyers to bring it that way also. Like, prove your point legally for me. You can't just opine out here and get my sympathy and think I'm going to do what you want. I have to back up my decisions by case law, legal issues, and statutes on file, current. Okay? That is the judge's responsibility. He's got to answer to it. And this man is not helping. He's not helping himself at all. I hope he took a breath, a little walk around the building, anything. You keep agreeing with me? Very funny. The jester says, let me put it up. In his defense, he's doing a great job for the prosecution. Unfortunately, he is leaving a lot of windows open for the prosecution. He is allowing some very good turnaround for the prosecution. And unfortunately, in his own questioning of this expert witness, he let out information that he probably didn't want the jury to hear in such a way. I think he thinks he was trying to intimidate, embarrass, and actually take the credit. His job is to make his expert witness more credible than this expert witness. It's his job to put doubt in the mind of the jury as to the credibility of what the state's expert witness is saying. This is rebuttal. This is them challenging what he has already put out there. It is his job and responsibility to negate that challenge, to make it weaker, to poke holes in it, to the essence of defense, install reasonable doubt in the jury. And he did do that. He also bolstered the state's case on several levels. He also allowed this witness to rebut by looking at him as if, what are you doing, dude? You're not going to impeach me because that's not what I'm doing. And this is the real. She was tolerant with the yes and no answers. She knew the state was going to come back. Well, she didn't allow her words to be twisted. And give her credit for that. And he was actually trying to force her to make a diagnosis that with her expertise, she's never going to make without real information. And he couldn't get her to say it. Yes, he was challenging her personality, not her credentials. I mean, yes, he was. He tried to say like, oh, she's not spending time on this. Like, but she is. She's very credentialed, and he actually let that come out. And then the state reiterated with how much expertise she does have with battered spouse syndrome. And if she's not saying that Sarah doesn't have it. She's saying it was not relevant at the time of the incident. She's saying based on Sarah's own statements, she does not feel that it was relevant at the time, which is a big deal.
Hey, everybody. Thank you so much for watching our Sarah Boone trial coverage.
Okay. Tell me you don't hear him now, because I don't hear him now. I muted him in both places. Like, right? Okay, we just see it. And I'll pull it over here for a minute. Okay. Why does Jesse always catch me off guard? Like, I know he's coming, and I forget. And then he just shows up and catches me every single time. Yeah, okay. I think I figured out which button to push first now. What is it, like 4 days in? And I finally figured it out. I still didn't catch him before he got me, though. Yeah. Yeah. I do like Jesse Weber, though. You guys should check out his sidebar stuff. He's doing stuff on P. Diddy and the Boone trial. Really good. Like, he's doing it on several. I do like his takes. Yeah. Yeah, Mandy. I need help today. I see. Oh, they're back. I think they're back. Hold on. Oh, I hear noise. Here we go. Yes, we're waiting for the jury. Whew. We are going to enter in more rebuttal information. I did say that, Mandy. Don't turn it that way. Oh my God, the unintentional innuendo. Yeah, I'm guilty, Mandy. That's exactly what I said. Not a bad thing.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury.
Yes.
Thank you. You all may be seated. Madam Jury, again, do you comply with the court's instructions during our break? Reflect all hands have been raised. Thank you very much. State, you may proceed with the balance of your evidence presentation.
Permission to publish what has been entered into evidence as 22, previously V as in Victor for identification.
You may proceed.
This exhibit 22 has 5 folders on it. It is a DVD. Going into the first folder, OCSO 18-067501.
Counselor, are these audio or video files?
This first one, Your Honor, is going to be a video file.
Okay, let's go ahead and dim the lights, please. Thank you.
And for record purposes, its file name ends with 0154-2.
You may proceed, sir.
Oh, this is one of the police body cam videos of one of the incidents. She's outside of her apartment.
And he told you a whole bunch of shit. Pardon me for saying that.
No.
Pardon me for saying that. But like, oh man, he let loose on my ass tonight, and I'm not having it.
Okay.
I got kicked in the face.
Okay.
Kicked in the face.
That you know if there's no guns, anything?
No. I know, baby. You guys are doing your job.
All right, Sarah here?
Yeah, right here. Go get him. But I swear to God, there's nothing you guys can do.
What's his name?
George.
George, all right.
There's nothing you guys can do right now. I swear to God, I'm so sad too. I'm beat the fuck out of me. And I'm filming. I have to work tomorrow.
What's up, George? You want to talk to us? What's up? Talk to you inside.
For the record, this is redacted.
Are the videos in States 22 redacted videos?
Some.
Okay.
See my eye.
I do see your eye. Okay, tell me how it all went down from beginning to.
Yes, my love.
Okay.
Okay, so we were having a really good day, and we went across the street from Muldoon's, and everything was really fine and dandy, and this guy talked to another guy because he left, came in there, and I got so mad, because I asked for a cigarette from another guy because he took my license, my debit card, and everything, cigarettes, everything, took everything.
Okay.
So I asked someone for a cigarette, and it happened to be a guy. So he walked in and got super pissed because I asked for a cigarette from another guy. I came home. Mind you, my car is across the street still.
Okay. So you get home, you go inside.
And let loose.
Okay, elaborate. So you open the door. What happens from there?
I'm a whore.
He starts calling your name? Okay.
When I say rag doll, you know what that is?
I know what a rag doll is.
Oh man, I was rag doll.
Okay, but I need you. Okay, I need you to elaborate. Like, you walk into the house. Did you start arguing? He started calling you names. He said he was.
No, I walked out. I walked in and I walked to the back. I just wanted to smoke a cigarette and just go to sleep. I just literally wanted to smoke a cigarette. I'm gonna go to sleep.
And then as you're making your way to the back, what happened?
I got caught on the stairwell.
You got caught on the stairwell. So he caught you on the stairwell. And what did he get in front of you? Started confronting you, telling you anything? What happened?
It was bad.
Okay. Elaborate, Miss Sarah. I need you to tell me exactly what happened so I can help you.
My heart is like, I don't want him to get in trouble, but fucking tired of being beaten up.
I understand, I'm trying to help you out, but
I know you are, I know you are.
I need you to elaborate a little bit, so, in the stairwell,
Dragged me downstairs.
driving,
I went upstairs, tried to get in the bed. I just want to go to sleep. I just want to go to sleep. I just want to go to sleep. I didn't make the bed. I didn't make the bed. He caught me in the upstairs.
like in the hallway?
Beating the fuck up. That's all I can say.
Okay, what do you mean? Like, I see your eye, what, you said you kicked you in the eye.
That's when I see it. That's when it's
Were you on the floor when he kicked you?
Yes, ma'am.
Okay, how did you get to the floor? Did he push you? Did he pull you? How?
Normally what I do is, because he does it so often, I just go to the floor. I just go to the floor. So I'm pretty sure I don't really recollect. I went to the ground. I went to the ground.
Okay. And then that's when
I'm
he
so sorry. I'm so
No,
sorry.
no, that's fine. I don't mind. So you went down to the ground.
Yes, that's what I do.
Did he kicked you with what? Do you recall which foot?
Right.
Right foot, okay.
Heel.
His heel. Okay. And you say you've been together for...
Because I asked for a cigarette. Because he left my ass in my car across the street.
Okay. You said you've been together for about a year?
And
A year and a half.
yes.
Live together, obviously.
Yes.
Okay.
I just recently went for a divorce. He's been there with me. He knows all those stories, blah, blah, blah. But
I know. I'm just trying to...
this stop. And I could have worked tomorrow.
Do you want the fire department to come out and check your
No,
eye?
baby.
No? Okay. Okay. Do you want to press charges? You can smoke a cigarette if you want.
Can I talk to you though?
You're talking to me by myself.
I don't want to be. Please put the finger up the police.
So you don't want to press charges? Okay. Do you want to fill out any paperwork? Do a statement? No? Okay. Smoke a cigarette, sit down, smoke a cigarette.
I don't want to be in trouble.
I know.
You guys have actually been out of your life now. Look at this shit. Look at my shit outside.
Did this happen today?
Yes.
Okay. All right. Yeah, I see it. It's ripped and I'm done a little bit.
I just bought this yesterday.
Go get it. Sit down. Smoke a cigarette. Do you think? No, it's fine. Do you have an ID with you? Is it in the house? Okay, we'll go find out.
I know my number if you want it.
Oh, that's perfect. Go for it.
B 500-791-77870-0.
870-0. Okay. First name is spelled S-A-R-A. Do you have a middle name?
Catherine. K-A-T-H-R-Y-N.
K-A-T-H-R-Y-N. What's your last name?
Boone. B-O-O-N-E.
Date of birth?
10-10-7-7.
I get it. So you can't have to pay my arm anymore. Do you have a telephone number?
407.
407?
716.
716?
8684.
8684? Email address?
SKP.
SKP underscore
100.
1-800.
@yahoo.com.
Yeah.
Sorry.
No, that's cool. I get it. Sit down, smoke a cigarette, try to relax a little bit. I'm gonna take pictures of you in a little bit. All right? No problem.
Turning now to folder OCSO 19-054.
Can the parties approach just for a moment?
I don't know what this is about. Okay. Yes. I understand that it does sound like a little bit like the questions that they're asking, but like they're going to a DV call and they've got somebody in the house or somebody outside saying, what the person outside saying is no, they need particulars from them to know what to do and how far to go. They got one officer in the house to talk to him, and this is the body cam.
All right, sir, you may continue.
Out there.
Within this folder, the first thing that will be published is a file that's an audio file, 911 call _R1.
911, what is the location of your emergency? 4748 Transcript, apartment 3. 4748, what was the street name? I didn't hear you. 4748 Transcript, apartment 3. Okay. Ain't nothing that I would call, but I did. You can beat the fuck out of me. You said Frank Lane? That's what it comes up as always. Okay, and then what was the apartment? 3. Okay, and what happened then? He just beat the fuck out of me. Who is he? Jorge Torres. Is he still there? Yes. Okay, where's he at? I'm in the bed. I'm outside. Okay. I did not fight back or anything. Do you need any medical attention? No. I just have a lump on my head and I just got these fuck up, that's all. Okay, what's your name? Sarah. With an H. Okay, and George, you black understand? He's Hispanic. What is he wearing today? Oh gosh. Just color shirt today, that's all it means. I don't even recognize because he just showed up. Okay. Do you have his date of birth? February 13th, 78. 2/13/78. And I swear, I'm just going inside because he's not on the lead and he's not supposed to be here. But he's here. How long ago did this happen? About how many minutes ago? Okay. I'm done. Yes, ma'am. I can't do this anymore. Okay. And I just need a description of you so that I can identify you when they get there. I'm white. I have 30 blonde hair and blue eyes. What color shirt pants you wearing? Am I? Yes. Black. Black shirt, black pants? Pink shorts. Pink shorts? And you're outside? Please don't get me in trouble. There's no way that I can get in trouble for this. No, just say where you're safe. You said you're outside, right? Yes. Okay, does he have any weapons that you know of? No. Okay. And did he hurt you with anything, or was it only his hand? Fist. Just his fist? Okay. And you don't need any medical attention? No, I always get over it, but this time I'm not getting over it. Understood. Okay. Okay, we're gonna go ahead and help you, okay? Anything, just give us a call back, okay? Wait, can I sit out front though? Yes, definitely sit out front. Stay out front. I'm gonna walk around the house. Okay. Okay, thank you. Yes, bye-bye. Goodbye.
Now publishing a video labeled 19-054917_BAT_DV.
Call? What's going on? What's going on?
Really, Marco?
Hey, get out of here. What's going on? You called?
I did.
Okay. Do you want to tell me what's going on? Who beat up? She's still in there?
He's awfully honest about offering things because I don't want him here. And he shows this, over the wall all the time, and comes over and looks for me.
Do you want to press charges?
What charges are you today?
Well, what's your relationship, man?
I guess boyfriend and girlfriend.
Okay, how long have you guys been dating for?
2.5 years.
Okay. And that's a current relationship?
No, it's on
I
I can't deal with this shit.
Okay.
I'm tired of it.
When's the last time he stayed the night at your house?
2 weeks ago.
2 weeks ago?
And he figured it out.
Okay, so why is he over here today?
Can't deal with just one or the other. That's what he told me.
Okay, so
I'm not allowed to leave it.
you're not.
Tell me about him.
Okay.
He's mad because I went out with my girlfriend. And she introduced me to another gentleman.
Mm-hmm.
He's not a gentleman. He's not a gentleman. And he got his.
Okay, so you came over today, you let him in because you're going to talk, right?
Yes.
Okay, then what happened?
Well, I'm really pissed.
Okay, so you guys start arguing and then
No,
what?
I can't argue. I can't argue. I was just taking down his speaker.
Okay, so when you say taking down the meeting, you're just trying to know. What did he do to you? Did he push you? Was he slapping you? Was he punching you?
All I can about.
Okay, you have to kind of explain to me what happened. Like, tell me what step by step. Okay, so he threw you into the closet doors? Okay, you're upstairs, he threw you into the closet doors. Did anything break when he threw you in there?
My head? No.
Okay, but you said you don't need the fire department?
No. I just have really bad lung. It'll go away because I'm used to it. It'll go away.
Okay, let me see. Where is it?
Right here.
Can you just put your head back a little bit?
There's a lump. Right here. Like you can feel it.
Yep, I see it. Do you have any other injuries?
No. Because he's not on the lease anymore, I know that he can't, I got him off the lease to not come on here anymore. And I'm trying to get him out of here. And he comes over here every day. And I have guys
Okay, so there's another exit to this apartment, so he could be gone?
There's the spot in my store, and I'm doing that. He's been a please, which I had done 4 times, you're the 4th one.
Okay.
He's gonna hop along, but I have to go and he's upstairs, so. Go get him.
Well, I'm going to, but I'm going to try to get somebody else here. What's his name?
George.
George?
I'm sitting here.
Okay. And I have to ask this too, when's the last time you guys slept together?
Had sex?
Mm-hmm.
3 weeks ago.
Okay. So, but you guys are kind of on and getting off again. And you're saying as of right now, you're off. But
I've been off.
okay, but within like the last 2 or 3 weeks, you guys were dating.
Honestly, no.
Okay. But at least There was some
I knew who he
expectation,
was.
there's an expectation of intimacy when he came over.
Oh, no.
But you guys, you said
Oh,
you
no. We were gonna try and figure it out. Oh,
But you want to press charges on us?
what charges can I pass?
Right now, what did he say? Just hit you with hands and feet and pushed you?
I got a heel on my face.
Okay. You keep getting upset with me, but you're not really giving me the information I need. I'm asking you to kind of walk me through what happened, okay? Because I don't know, I wasn't there. Okay? So all you said, you guys were upstairs. Okay. But that means lots of different things. So that's why I need to know what
This
you
is
did.
why I have all of this over here, is because he continuously talks to me, and he strangled me multiple times.
Today?
Yes.
Okay. Did you start to lose consciousness or anything while you were strangling him?
I couldn't breathe.
Did you feel yourself losing consciousness?
No, I didn't lose. I just couldn't breathe.
But how long was you strangling for?
Till I got him off of me.
Okay.
Look, can I tell you something before you call and whatever?
Mm-hmm.
I've been arrested before because I fought back. Look, I did my guy. I did my guy. So whatever he has or whatever it is, it's not me.
Did he hit you with any, like an object or anything?
No. He threatens me with a bat.
Today? I'm talking about today. Did he pick up a baseball bat and threaten you? Okay. Tell me about that. How far away were you when he had the bat?
I was in the bedroom.
And where was he?
In the bedroom.
Okay. Was there anything in between you guys at the time?
My dog.
Just a dog, and how close was it to you? Couple feet, 3 feet?
3 feet.
Okay. And how was he holding the
Threatening.
bat? Like, what do you mean? Was it down by his side? Was it up like this? Like, how was it?
He's gonna swing.
So he had it up?
Yes.
Yes. Okay. Did he say anything to you while you were holding the bat?
I barely know.
And what do you mean by that?
Because I technically left him 2 weeks ago, which is why he's not here now, and it's not because I have friends. I have friends, and my friends want me to get out of my loony dingy bullshit. So they try to introduce me to nice gentlemen, whom he is not.
Okay. So he's holding the baseball bat, and 3 feet, you guys are up in the bedroom, and he says, I dare you. Okay. And you were scared. Correct?
I'm so scared, so why am I crying?
Okay. I'm gonna go see if I can get him to come out. Alright, if not, this is your place, right?
He's not on the leash.
Okay. And we
We're
have,
talking about party members. I had taken off the leash.
okay. Alright, hold on.
Sir, what is your name now?
O'Neill.
What?
Can I throw it down? If there's anybody know, can I get 44?
Don't get me started.
Hey, George? Hey, George, transpire, can you come on out? Just hold on. Hey, George, I can hear you. Come on up. George, there's come on out. What's going on, man? Come on here, talk. What's going on? Talk to me. What's going on today? Do you speak English? Yes. Okay, so tell me what's going on. Why are you here right now? Because she called me. So tell me, you want to tell me what's going on? Did she really call me? Where are these cuts on your neck? That's neither there. She over there. All right. We got it. Did you want to talk to me about the cuts on your neck? Yeah, not really. Okay, do me a favor, turn around. Put your hands on your head. What? Why am I getting cuffed up? Hold on a second. Why am I getting cuffed up, sir? Contact 24, one diagnostic. Why am I getting cuffed? Come on in. Yeah, why am I getting cuffed up? We'll talk to you about it in a sec. Okay? Any weapons on you? No. Not at all. Okay, have a seat, my friend. Have you been drinking today? Yeah. Okay. A lot or a little bit? Like, do you understand what's going on right now? Yeah. Okay. So I'm gonna hammer easy, okay? I'm just gonna need you to answer yes or no after each time I say ask you a question, okay? You have the right to remain silent, do you understand that? Anything you say will be used in court as evidence against you, do you understand that? You are entitled to talk to an attorney now and have him present now and at any time during the questioning, do you understand that? Yes. If you cannot afford an attorney, won't be appointed to you without cost, do you understand that? Yes. Okay. Do you desire to consult with an attorney first or have one during this interview? Yes or no? No. Okay. If at any time hereafter you wish to remain silent and have an attorney present, all questioning will be stopped. Do you understand? Yes. Okay. Has anyone at any time threatened, coerced, promised you anything in order to induce you to make a statement? No. Okay. Do you understand these rights as I read them to you? Yes. Okay. Do you wish to talk to me this time? Yes. Okay. So, tell me what happened today. What is going on? She said that you hit her and you choked her. What? No, sir. No, sir. Okay, she's got a lump on her head. How did she get the lump on her head? I don't know. She just take me in. I don't know. Officer, I don't know. Did you push her, hit her, anything like that? No, not at all. Okay, how did she get the lump on her head? I don't know. Okay, what brought you over here today? I was trying to get my ID and my social and my birth certificate. And she's not trying to give me that. Okay, but obviously you've been here for a little bit. I mean, your shirt's off, you've been drinking, so you didn't want to just come over here to get something. So, like, how long have you been here? For a while. Okay. So, what says a while, like an hour or 2 hours? Okay. How long have you guys been dating?
We've been together for 2 years.
For 2 years? Okay. Are you guys still dating right now, or are you broken up? Okay.
And I work right there at this.
Okay, so you came over here today, so for about a while ago, an hour or two. What have you been doing since you've been here? Okay, so just spending time with her, and then all of a sudden she decides to run outside and call it out. Why would she do that? You don't know?
She's nice, dude. She's nice.
Okay, that's fine. But
I can hear her.
But what you gotta understand, what you're telling me isn't really adding up. Because she gave me her side story.
What she said?
And she's saying that you had it. That's all I need, man. It's ma'am, I'm doing my job, okay? You just sit there and be quiet. I'll be over to talk to you when I can. Every time you start yelling, you're interfering.
She's the one that she just snapped out of nowhere. She's mad because she took me out of the lease. She took me out of the lease. And I told these guys of the lease, like, look, I can't cash my check. What about her? So please talk to her.
Okay, so you can order and talk to her about cashing your check?
Yes.
Okay, yeah, you've been here for a couple hours. Okay, so what happened to make her run outside and call police? Because I'm seeing cuts on you and I'm seeing bruises at her. But you're not telling me what happened. And you're the one sitting in the back of a cop car right now.
I don't even know what happened.
Did she hit you?
All the time.
Whoa!
Who hit who first?
She does.
So she hit you first?
All the time.
Today. I'm talking about today. You don't know if she hit you today? Huh? Do you have an ID on her?
She has it.
She has it?
Yeah.
Okay. Can you grab his ID for me?
No, I don't have it.
He said it's in the house.
No, I threw it in the bushes.
Where in the bushes? Because I need it.
Frank, look, however, oh my gosh, the front door is open and I don't even know where my dogs are. Oh, here, find the desk. I don't have his ID.
You said you threw in the bushes. Where in the bushes did you throw it? Could you please go look over there?
So what's happening?
It's in the back of the cop car. You said he hit you, he beat you, you have a bump. Okay?
I don't have it. You can look up here.
Publishing portions of 19-054, or pardon, 0545-BAT_DV-2. For the record, it is about 47 minutes, 20 seconds long. State will publish 000 to 2 minutes and 19 minutes to 22 minutes, and all evidence will go back to the jury with a scrub computer.
ranting mother came over here, so it should be somewhere in here if they didn't find it. I don't have it.
No, I mean, it makes getting his information a lot easier if I don't have to keep asking him questions, so that can just get it out there.
I'm not making what is good that I could, friends, I'm not. I already looked through here.
Okay.
Majority get your stuff done over there, I'll get her start on the list. You want to sit down?
She also has my birth certificate. Listen, she said that she's doing the bushes, I'm trying to find it. If you're looking here, you will be needing it.
You told me I'm not going to get one. I love you. I don't know what it is when you're asking me for it.
Okay, maybe he didn't get to it yet. That's why I'm looking to see it. Oh, yeah. It was the backside of this. If you get any more bruises that show up that you didn't see while we were here.
Can I show you all the other pictures that I have that I have documented?
He's going to jail for this, so the rest of that can't leave anything up. But if anything else shows up, you can go take that paper down to headquarters.
It's not going to be anything else because you're taking him down.
I
Put
mean,
him under the jail.
He's going.
Under the jail.
Okay. We're all set then.
What else do you, I could show you bloody fingers and bloody faces and black eyes and.
I know, it sounds like you guys need to probably not hang out with each other anymore.
Hello.
I know.
That's
I know,
why I
but
left him 3 weeks ago.
But this also isn't the first time, so, with both you guys, with the cops out here.
No.
Okay?
I've had to lie to you guys 3 times.
And you shouldn't have to do that, so let's make this maybe the last time.
Now I'm not lying.
Okay. I appreciate that, okay? And keep going, okay?
They're gonna come and tell me.
Who's that?
Just like I told the other sheriff, they're gonna come and tell me.
If you,
I want you to know that. Look.
if you're, are you talking about the
Yes.
family?
Yes.
Okay.
I want you to know I am full blown. They're gonna come and tell me.
Go down to the courthouse, okay, and get an injunction against them. Did you get the pamphlet for the victim's rights pamphlet? Okay, so you know that there's a place for you to
They're
go tonight?
going to come and tell me.
All right, so you got the victim's rights pamphlet, you know there's a place you can go tonight then? It's in the
It's
bed?
domestic. I'm gonna go sleep over her house.
Perfect.
Neighbors.
Okay. Do you have any more questions?
Can I get on?
This one. I didn't tell you that. Okay, have a good day. Okay, that's good enough. I know. Thank you. Okay.
I love it.
Okay. Have a good day, man.
Look, and whatever the fuck he says,
Okay.
tell him to be a dick. Hey.
What?
Okay, have a good night. See you later. Thank you. Have a good day.
Tell him to thank you.
Publishing video file axon _flex_2_video.
Wow.
It's the only one that starts with that name in this folder.
I only wish I could see her face while this is going on. Let me see if I can get the date on this one. Oh, this is still June 15th, 2019. Or is it the 15th? Oh, what does it say? Yeah, June 15th, 2019. It's a continuation. Or it's the other officers. I'm not sure. I think it's the one with like they had two camps going, two officers. This is still June 15th, 2019.
So, come over and give me a written statement about what happened. I have it over here by my car. Sure, just stay right there. Now go, you can get your stuff done over there, and I'll get her started on all this. You want to sit down in here? So you can write? Okay.
Love! Don't leave!
Come on, let me call you, and let's get this done.
I'm not getting arrested.
No, I'm getting a statement from you. You're not being arrested. So,
Okay, look, I'll come over and see you in like 5.
come on.
Thanks, buddies. They know.
Let's get this done.
They know.
Okay. Now, would you come in here so we can do your statement, please? And stop this. Sit down at the table and let's get your statement filled out.
You didn't believe I would ever do it. How much took for it, okay?
Sure.
You never thought I would do it.
Did you have?
I'm not getting arrested.
No, you're not getting arrested. I've already told you that.
Yeah. It's on the couch. It's on the couch.
Need your ID, please.
It's on the couch.
No, ma'am. I just need your ID.
Okay, look, I can write right on the couch.
I will give you the statement to write. I need your ID, please. I don't need to sit on the couch to fill this out. You can. I sit down all day, and I appreciate the offer.
Yes, it's comfy. I just come down, right? Thank you, God, he's gone. Oh, man. Oh, man, they're gonna come over here and try and tell me. I don't want you to know that. They're gonna come over here and try and tell me.
Who's that?
His brothers and his mother and his father. They're gonna come over here and try and tell me.
Don't open the door for
It doesn't matter. They don't go out there and it's rant and bullshit and everything, and then they cause a commotion, and then I get complaints against me. Anyway, my name is Sarah.
Mm-hmm. Hi, Sarah. I'm showing this out in a minute.
What's your name?
Jeff, Deputy Brown.
Jeff. Okay. Well, I'm gonna be my name. Did he get caught up?
He will be. Do you have a phone number, ma'am?
407-716-8684. I'm not getting arrested.
Nope, you're not. Did you do something you should be arrested for?
No.
Okay.
For the last time I fought back. 420 years.
Do you have an email address, ma'am?
Sam, Kate and Kate, P as in Paul, _1800 @yahoo.com. You can totally come sit down up here.
I sit down all day. I appreciate the offer, but I want to get this done for you. Just a little more comfortable for me to stand and do this.
I can't tell you how amazing it is. Oh, wait, I didn't even say that. Sorry.
Okay.
I'm sorry. Oh, crap, the card is still there.
Okay, come on in and sit down so you can get this filled out. Okay, what I need you to do is you'll just print your name right where that X is, and then I need you to just write the story about what happened today.
Correct.
Yep, please.
I don't even know what's really.
So is this a husband, boyfriend? Are you guys married?
No.
How long have you been together?
2.5 years.
Was he drinking or anything today?
Yeah.
Both of you?
I had.
Okay.
Bless you.
Nothing wrong with that.
Here's my artwork thing, but because I do artwork, but
Okay, I need you to show us it. It's very
I
nice.
do artwork.
Very nice.
I have a drink, 17 years ago, and I do artwork.
No, nothing wrong with that. And who called the police? Did you call the police? Okay. Call 911?
Yes.
Very good. Has this happened before?
3 times. The last one that came up, and they're like, oh yeah, we read your statement, so we know kind of who you are and what's going on.
So 3 times the police abandoned? Was there ever, was sheriff, were there reports written when they were here?
I'm not really sure about that. I didn't have to sign anything.
Okay.
Not worth it. Okay. I'm not really sure about what you're saying. I'm much too late.
What does it say? Can you read it to me?
Throwing me off the bed and beating in the head and stuff. Am I supposed to write all that?
Yep, everything that happened.
I'm supposed to write all that?
Yep, everything that happened.
All that?
Yeah.
Yeah.
You see my neighbors out there, because they know their children are going to come at the house and they know who it is.
So what was your phone number again? 407?
716. 407 716. I'm not getting arrested.
Nope.
Out in the car still.
County charge $25.
Okay.
Could you give me 424 case number, please?
Stopping publishing at 10 minutes, 0 seconds on that file. Proceeding to third folder, OCSO 19-055572. Publishing audio file 911 call, -first.
911, what is the location of the emergency? Well, I didn't have an emergency here at my place, but my boyfriend was arrested, I think, last Thursday, and he has a no contact form, and he took it upon himself to come over to my house yesterday and took the bike that I bought for him, which is technically mine, and also my debit card. So, and okay, if he bought it, then it's like he didn't. Okay, that's fine. I need my debit card though. Like I have my 8-year-old son coming over here. I can't even buy groceries for him. Okay, then what's your address card? My address is 4748 Branch, FRANTV. Okay, Ward. So what's your apartment number? 3. Your apartment number? 3. Okay, just to make sure I heard you right. Sure. Okay. Have you used anything else with that credit card? Yeah, he bought beer and cigarettes. Yeah. Alright. Tanya, what's your name? Sarah, S-A-R-A-H. Okay, Sarah, call back is 477-716-8684. Yes, okay. And he's at his parents' house right now, so if you need the actual address over there or whatever, she's done. I'm sorry, Sarah, what did you say? He's actually at his parents' house right now, so I don't know. Okay, well, we're coming to you first to make a report, okay? Gotcha. All right, I'm gonna get all this information in here, but consider it done to you. I need to send it up to you, okay? All right, so when did this happen? Yesterday. So, your ex-boyfriend? Yeah, I mean, technically he's my boyfriend, but yeah, at this point he's my ex. Alright, what's his name? George, J-O-R-G-E. Proffer. Torres, C-O-R-R-E-S. Okay, by chance do you know how old he is? He's 41. 2/13/78. Okay. So guys, please can recognize you, or you guys my first minute. I'm white. So what color shirt pants are you wearing? Right now I'm wearing a blue shirt with white sweatpants. And there's a green pineapple on my door, because it covers up the 3. Okay. Do you have any weapons on you or in your home? No. I mean, I have a baseball bat, but that's just only when I'm here by myself, or me and my little 8-year-old. And you said the pineapple covering the 3? Yeah, the green pineapple covering the 3. It says welcome. And I have a little bird flag out front. Okay. All right, Sarah, we're going to the detective over the WT, okay? No worries. All right. Thank you very much for the help. You're very welcome. Bye-bye. Okay, bye.
Publishing audio file 911 call, -2nd.
911, what is the location of your emergency? I don't necessarily have an emergency. It's 4748 Branch Court.
4748, what's the street name?
I'm sorry, what?
4748 and the name of the street.
Branch Court.
And what's going on there?
It's no contact thing.
Okay.
He's over here again.
Okay, is it Branch?
Stop me, penetrate me.
Okay, is it Branch Court or French Court?
FRANTV.
What's the appointment number?
3.
And what's going on there? Okay. What's going on?
Oh my God, I don't want my dog. She's deaf. Hold on a second, please. I'm sorry, hold on. Come on. No, I gotta go on the side. I'm sorry, hold on one second. I'm so sorry to take your butt. Go, get out. Oh. Ma'am, what's your name? Sarah. Okay. Get out of here. You take my pantry. Hello. Hello, ma'am. Do you need a deputy? No. Excuse me? I'm sorry, what you asking? Do you need a deputy? No, not necessarily. I'm trying to get my dog. I have a blind dog and a deaf dog. I'm trying to get them in. Okay, you're dialing 911. Yes. Okay, and you don't need a deputy? He's here again. Take it. That's mine in full voucher. You're eating in my pantry. And who's this person to you? Oh, ma'am? Yes. Well, the first always you're gonna send somebody. So, I'm okay. Regardless. I know how it works. I'm okay. That's not yours. Hello? I'm still here. Yes, ma'am. Thank you. Oh, thanks. Okay. Yeah, so. What do you want me to do? Put it back. Thanks, okay. Okay, you're just somebody regardless, so like, do what you gotta do.
All right, have a good day.
Publishing the one video in this file that starts with file name Axon.
What's up, bro? It is. So what happened? What's going on now? Did this just happen?
What? No.
I said earlier.
Oh, no, when I moved in, we dropped it.
So who called? So what's happening?
They're asking you, not me.
Yeah, you speak to them, I'll speak to you later. Come here. So I'm guessing it's all for a reason, right?
Only 24 hours. Okay.
Yeah, but you realize it's here though, right? Have you been drinking?
I had a drink.
Okay.
It was raining.
I did drink.
store manager.
No, don't go door. Like, you know, I went. Oh my God.
Okay, well, this is here to demonstrate the area to one of the Hispanic males. And tattoos all over, no shirt, no pants.
Yeah, after he's here.
Other one, tattoos.
Yeah, you can stay right here. You can stay right here. He doesn't know. He doesn't allow me.
Another black male, no restrictions, foreign US, white male, an area check.
We left it earlier. We were starting to do your wish earlier. Yeah, we were supposed to do your wish earlier, okay? But he's here. Okay.
24 hours.
That's the only reason. Yeah, I have to be able to go.
President, 35
Stay right here. You don't have to go. You don't have to go. You don't have to go.
Transfer flow is referred last night.
Oh, you can sit back. It's not raining. It's just sprinkling. It's okay.
Whatever you want to.
What's that?
Hey, but I'm literally making you know.
Yeah, but you know he's gonna have to. Stay.
Last week, we got into I guess a physical or whatever, I don't know. I got taken out of here without no shirt, no shoes or whatever.
And then you went and saw the judge, right?
Yes.
And what did he say?
13 on count 30.
The judge was like,
Was it a female or male?
Female.
Female? Okay. What, you know what she said?
he was bad.
Yes. My head hurts. So yeah, but no, bad. That's a I know. No, this is a thin blue line, but. Stop.
I did not get it.
We're not gonna do it yet.
Did you get any form of paperwork?
I got paperwork, but I didn't get.
What was that paperwork for?
Paperwork was,
What does it say?
No.
With who? With who?
With her, but she never said anything like that. It was just the judge that put it.
The judge is the one that matters, right?
Is it?
Is she? I believe so. She's above us.
Is she above her?
She's the judge. She's the law. Okay.
You guys don't want to take me in.
Is my other guy here? Okay. So here's the deal, man. Your paperwork says that you can't have any contact whatsoever with her. Okay. And if you do, it's a new charge. Okay. So. Have you been? Has she been drinking today? Have you been drinking? Okay. How long have you been here since?
I'm gonna be honest. You guys came here. She called me.
We know, because we went to your work of employment. And they told, and they told us that you just left. Yep. And we knew that. She called you. We knew that. We knew she called.
Oh, it's just she called me and said,
Yep.
where's she coming?
You're correct. Okay, so you know what's gonna happen, right?
Yes.
Okay. Stand up, Mark. You can take one last puff.
Please?
Yeah, one last, go ahead. Okay, just put it out real quick. Alright, wait, one more.
Wait, no,
Never make sure.
Relax. Okay. I want you to talk to her. I want you to know around that.
Right, you promised.
I don't think they promised you that.
I think it was earlier.
Well, that was earlier. This was in Trinidad. Right?
I didn't call.
You didn't say you called.
Sarah told you.
But did you call him earlier?
They told you.
Because he just told us. And we know the store told us.
I told you. Wait, is there anything that I can do?
You're good. You stay right there.
No, is there anything that I cannot?
No, man, you know he has no contact order by the judge. He can't be here.
Okay.
All right, but.
You need help for anything?
No, we don't. We have our information already. So here's what's gonna happen, bud. You're gonna take the ride back down, and because it's almost 2 o'clock in the afternoon, you're gonna see a judge tomorrow morning. We'll see you today. Okay, like the same judge that gave you no contact order. Okay? That's it. From here on out, but until that case is resolved, you cannot come here. Okay? Or have contact with her, even if she invites you. Okay? She called us earlier, told us that you guys had a no contact order, okay? She don't want anything. Charge nothing. So we told her because it's domestic, send it over to has to. Okay? So, alright, but just make sure he's got nothing on him. Hey, you have anything on you, right, bud? We'll make that cordial as can be. Okay? We promise it, alright? Lisa?
I love you, babe. Don't take it easy. You hear me? I love you. Call Prophet Mom. Hello, Kayla. Sarah, call Prophet Mom.
No.
It's all right, babe.
George, give me your mom to your father.
This is Sarah.
I don't know it. I don't know. Sarah?
What's the charge?
So the domestic battery charge that he got hit with last week or whatever it was, he was given a no contact order by the judge. Okay, whether she invites him or not, I know. He knows he can't be here. So he was here this morning, and she called us this morning. Okay, he's now back, and he knows by the he can't be No, he gets a phone call. Yeah, he gets when he gets in. Well, if you got a piece of paper real quick, you can get it for me and we'll give it to him.
You don't know your mother's phone? She had.
If you can get it real quick, we'll give it to him.
You're not getting mother's somebody.
And make sure that.
Publishing from folder OCSO 19-078009. First item is a PDF of photographs. Second item is the single video starting with Axon.
has been here.
Yeah, I thought you looked familiar.
Because the last time I was here, you guys had a fight at the bar. And you
No,
home with that.
No, we
Or
haven't.
he came home from a bar. Someone came home from a bar. Hey, who's that? Jorge, George?
Yeah, what's up with the blind one? Is she there? She's dead. Can you just pick it up? No problem.
What's going on, Ty?
You didn't think I'd call. You can go sit.
Okay, come on, George. Off couch.
Go up there. No, they're not staying on there.
Okay. I know you think this is playtime.
No.
No, baby.
Sarah, are you serious?
Yeah, I don't want to be punched in the neck. Told you I will not hesitate.
Alright, come on in. Because we're going to talk about what?
Oh, he's nice enough to actually give you your shoes from last time.
Ma'am, you want the dry for me?
Did you have a wallet you want to bring with you or a cell phone? Alright.
Sarah, are you serious? Sarah, are you kidding?
Punch me in the neck again.
Sarah, are you serious?
Am I allowed to do something to about?
Yeah, you can. I'll be right back with you.
George, we're going to go talk down here. Can you grab the paperwork?
Yeah. You sure you don't want me to watch him?
Yeah, come on. That'll work too.
She's the one that hit me, and I'm the one that just liked her.
Well, let's just get down to the bottom of it, okay?
George, I want to talk to you. I want to ask some questions. I have you in handcuffs, so I've got to read you something real quick, okay? Do you understand?
Yes.
Alright. You have the right to remain silent. Anything you say will be used in a court as evidence against you. You are entitled to talk to an attorney now, have him present now, or at any time during questioning. If you cannot afford an attorney, will be appointed for you without cost. Do you understand these rights as I've read them to you? Okay. At any point hereafter you wish to remain silent, have an attorney present, all questioning will stop. Do you understand that? So even if you want to talk to me at first and you change your mind, just let me know. Okay? Alright. Has anyone at any time threatened, coerced, or promised you anything in order to induce you to make a statement? Have I promised you anything? Have I bribed you? Have I said, hey, if you tell me, give me a statement? Has any of that happened? No. Okay. Do you understand these rights as I've read them to you? Alright. So, what were you two fighting about tonight?
We weren't fighting at all.
Okay. What are you fighting? I'm going to take that in there for that. Huh? Okay. I'll take the statement and get the statement done.
Oh, with him?
Huh?
From him?
No, for her. That way you can fill this out while you're 10-12 with him.
Sarah.
I'll get her information from her.
Yeah.
Okay. Listen. So why is this so ugly? What up? Okay, can you explain the bruises she has? Those don't come from nowhere. So what's your version of what happened? Are you you did it all the time, but how did you do something to her? Because you did, you know, you're going to defense, tell me. You just said it wasn't the defense, so if you get hurt, you never do it, set up, and figure you can set up. Huh? Sarah? No, you say that.
Sitting on 20 million, no means an hour ago. 76 complainant, 3028 Riverdale, 302 Riverdale, an hour ago, via text message to 323.
Sorry about that. Sarah, stop calling for it. Not welcome down there. I know, but I'm not going to change things. I know. Why? Because you have a phone. Without a battery. And when I try to get the straight story, you don't want to give it to me. I'm sitting this straight with you. You got what you can. All right. I've tried. All right. And now that you're going in the back of the car, you want to give me a story. It doesn't work that way. I do nothing but play to you, trying to talk to you, trying to get straight answers, and you're beating around the bush. I'm not. Yes, ma'am. Do not start kicking and banging on things, okay?
Sarah, what's your phone number? What? What's your phone number? I don't know your phone number. Sarah, what's your phone number?
It's not him asking, it's us.
You said, hey, what? Thank you.
Outlets of verbal 711 and 10601 R2C at Long Farm, complainant versus new business, reference to refund out of this 2017. Complainant female, pretty sure with me, and very non CRB.
Can you guys not put on mute, please?
Okay.
Please.
Fifth folder, OCSO 19-079759.
And there's more.
First file is a PDF starting 48-2019.
Injuries to George. Oh no, this is Sarah's ear. Sorry.
Second file is an audio file, 911 call, publishing.
It's not technically an emergency, just, you guys have been there so many times before. I'm not there, but I'm just trying to go home.
What is the address?
4748 Brant Court.
What was the street name? Brant Court?
Brant. F as in Frank, R-A-N-T-Z as in zebra.
Oh, is it France?
I don't know if it's there or not. I'm sorry?
Ma'am, is it France Lane?
I'm guessing so. It's Springs Court, but it's because of the France Lane.
Okay, what exactly is going on?
I would like to go home, but I can't go home because he's there.
Okay, do you have some sort of restraining order against him, or?
He has a no contact.
Is there an apartment number?
3.
1 second.
I'm at my former husband's house right now because I can't go home. I don't even know if he's there or not. He was there earlier, but I can't go home.
Okay, so do you want us to do a standby with you?
What do you mean?
Like escort you to the residence, or that I'm not understanding what you would like.
If I could, please, can you guys go over there and just see if he's there? Pretty sure he locked me out earlier, so I think he's probably there still. I'm not going over there with him then. I'm not.
Okay, does he live there?
No.
Okay, so how is he inside the residence then?
He has a key that he took.
Okay, so is he breaking into the apartment?
He's not breaking, he's already in the apartment. As far as I know, I don't know if he's there or not. He knows where I had my key.
Okay, what we can do is we can meet you a block away from the residence and go with you to the residence.
I don't know. I tried calling him to ask him to leave if he's not already. So I have my 8-year-old that I'm trying to watch out for right now. So I'm not really sure what I'm supposed to be doing. I just want to go home.
Okay, if you want to go home and you're not sure if he's there or not, we can meet you when you're about 5 minutes to a block away and go with you to make sure he's not there.
Okay, well, okay. I'm about to get, to be honest with you, kicked out of my apartment because you guys get called so often, and the brigade comes and this, that, and everything, and the neighbors complain about everything. I'm trying to avoid that. I just want to go home.
Okay, regardless, the deputies are going to go to the apartment, whether it's with you, what I'm suggesting you do, or it's what you want to do. Just have them go to the apartment. So regardless, people are going to see that there's deputies going to that address.
Okay, so when I called you guys a couple of days ago, and they didn't make not a ruckus, but they made it incognito, which is what I need, because I'm going to get kicked out of my place.
Okay, when we do a standby, ma'am, all we're going to do is accompany you to the address, and the deputy can make sure that he is not there, and then they will leave. If that's all that's going on in this situation right now that you're calling for, it's not going to be like a big deal.
And what happens when he is there?
If he is there and you don't want him there, you can have him trespass. They're going to make sure he can leave. I mean, if he does not live there, like you're saying, and he should not be in there, you can trespass him. You already have a no contact order with him. They will remove him.
Okay, well, there was an altercation earlier, and I'll be honest with you, there was an altercation earlier. So that's when he came in, the altercation happened. So that's when I left. I fled, barefoot. And now I'm at my former husband's house.
Okay, would you like the officers to meet you where you're at right now? And
I don't want to get arrested. I don't, because I fought for myself, and I have my 8-year-old, and I just want to go home and sleep in my own bed right now. But I did fight back. I'm not gonna lie. So.
okay, well, I mean, if you're wanting us to meet with you or go to your house, I mean, I don't know what they're going to do. If they're either going to arrest anyone, arrest you, arrest him. That's all up to the deputy and what he concludes from the situation that's going on. So it's right now it's just up to what you want to do right now. If you want to do a standby, we'll accompany you to the residence. I mean,
yeah.
It's really just what you want to do.
I know. I have to take my time to school tomorrow.
Or what I could do is I can have the deputy call you about the matter. If you want to speak to a deputy directly, and if you want to do that first before having us respond out there.
Yes, please.
Okay. What's your name?
Sarah.
Hold on a second, Sarah.
Thank you for your help. Actually, more ways than one.
And is a good phone number for you 407-716-8684?
Yes, ma'am.
Okay. I'm going to set up a call for a deputy to call you over the phone, so you can talk to them directly and see what they say about the situation. And when they call you, it'll be from a blocked or restricted number. So if you get a call like that, just make sure you answer. It's going to be the deputy, okay?
Yes, ma'am.
All right. If anything changes or you decide you just want us to come out and give us a call back, okay?
Yes. What was your name?
My name's Rachel.
Rachel, thank you so much for your help, and I've got the phone right here on the line.
Okay, perfect. Bye-bye.
Thank you. Bye.
Publishing the one video in the folder, starting with 1924, from 0 minutes to 20 minutes, and 41:30 to the end.
20-minute long video. September 5th, 2019. 1 a.m.
Yeah, both, please. Tony already.
Is there a back door or a sliding door?
Yes.
No.
If you go to 10-12, just let us know.
Well, thought that was open for a second. Locked. That's open. Yeah, the back's locked.
Anyway, you want to call your ex-husband? You have a phone?
There's a charger in that.
It's not in the house. That's not to say that it's not in there, just because the doors are locked.
I don't understand. He's saying that he's inside?
Yes.
Okay, well, we need a key so we can get inside, so he's inside. That's what
And if your phone's gonna die, there's a charger in back on the back side of the porch.
Oh, yeah. The keys in the house is not coming at the door, but I have my spare key. I can't get in. If you could, there's no other way of getting in the house. Unfortunately, can you please bring me my spare key? Yes, please. The front door and back door. I have no way of getting in.
Where's he live on then?
I'm sorry?
You said that's your ex?
Last night, right on the street. He'll be here in like 2 minutes.
Perfect, thank you so much.
No, thank you.
Is your, this your, who you think is your ex-boyfriend, is that correct?
My place.
Okay. The boyfriend or ex-boyfriend? Somebody you dated?
Yes.
Okay. Did he know how he was?
No.
Okay.
No.
He was arrested last week for bad.
You guys actually want to take a picture right here? You can see that. Not personal.
Saw he was arrested before, was that also like one thing? Last week.
Yeah, but. That's why I called you. And again, I was sleeping.
How much did you have to drink tonight?
I'm truly diagnosed.
How much did you have to drink tonight?
2 drinks, and that was what, 4 hours ago?
So what's the layout of the house? Is it both floors? Is this part here? Or is that so these two windows right here?
What kind of vehicle does he drive?
That's right. But I lost them.
See a little bit of movement on the drive.
If you got on my dog, she's had a divine dog and a dead dog.
Oh, gotcha.
So I have a feeling it's probably text. She's the best one.
Does she have anywhere else to go? Or is this the only place she has?
It's his parents' house.
Where's that at?
80, 30, 15, Valhalla Boulevard. It's on the street next to where the Street is. You know where that is.
Oh, gotcha.
can I say something now?
Sure.
If both doors are locked, he has to be in there.
Why is that? You can't lock it from the outside?
No,
Doesn't he have a key here for you though?
unless he took my spare key, which I'm pretty sure he probably did, because he has to be in there. Especially with the back door.
Is the spare key, was the spare key in that house?
No, I had it outside because he wants me out all the time. So I'm gonna say that then. If both doors are locked, we have to be in there. Y'all can have to see, y'all can open the door.
Hey, you're gonna stay outside till we make sure nobody's inside.
Okay, bye. Thank you so much.
Hanging out here.
I am not going in there. There's no weapon.
George?
There's no weapon.
Ask for a minute. Ask for a minute.
That's never said.
Reference building, sir.
I know.
County 124, Charlie.
Thanks, sir.
Can we get minimum traffic for a building session?
Everybody make an announcement?
Yep.
You guys don't have to do that.
Man, we have a way to do things. Just let's do our thing, okay? Make announcements.
Sheriff's office, you in there, come on out.
Pull ladder.
Sheriff's office, you in there, come on out. I got a dog.
George!
Yeah. I got a ton of plants on the right side.
Just when you get that stairwell, just fuck your toe right up, or don't go up, that's when you got George! Please! If you're up there, let us know, because we're coming up anyway. Go ahead. Run, whenever you're comfortable.
Yeah. Open door right there.
I think that's the kid's bedroom.
Okay. Just get that way for me.
I got it.
Someone come in and bring you going that way.
Boy! Show your hands. Come on, with your hands up. George, step out with your hands up.
Put your hands behind your head.
Hey, turn around, face away from me. Turn around. Walk back to me. Walk back, walk back. Just need to think right now. Why did you tell us? Interrupted. Huh? When I say you didn't hear it, there's a reason you're sitting in the bathroom. That's what. Alright.
And once like we're trying to go out, 10 minutes to go back normal.
Hey guys, can I?
Before you go, we're not doing anything right now. Alright, we're not taking out a room. I'm gonna sit down in the bed right here.
Okay.
Alright. Let me ask you a question.
Yeah.
What happened today? You got a light in here?
Yeah.
You just gotta pull the thing?
Yeah.
What happened?
I don't even know what the heck happened.
There's a reason you're hiding the bathroom, so don't act like we're not up here for no reason.
No, I know that.
Okay, so
I'm hiding in the bathroom because we had a discussion and as usual, and I am in the wrong.
Okay. Why?
I am with the what is it called? No. But we.
How long have you been here? How many days since you got released? When did you get released? Because you arrested last week, right? Yeah. All right, when did you get out?
Let's say 3 days ago or something like
It
that.
was on the weekend?
Yeah.
Today's Wednesday, or was it Monday? Or was it this weekend or was it Monday?
The weekend.
Okay. After that, did you guys talk, come back here, yeah, this weekend? And everything was fine between you two? Till tonight? What happened tonight?
I don't know what happened tonight.
George? So your cops stand in front of you, you're hiding in the bathroom.
Yeah, I know that.
Okay. Stop for no reason. Right?
Wifey is nuts, and she always freaking starts stuff, and she.
So that's what I'm asking, I'm telling you what happened.
She puts it on me.
Okay. She puts it on you.
All the time.
Well, none of that gives me any insight as to what happened tonight.
Nothing.
You both are very big. She's very big, you're very big. Any more than big.
What is she being big about?
I can't discuss what she's discussing until you discuss to me, right?
We just want to hear your side of things, but this
Everybody wants to hear my side.
Yeah.
All the time.
Georgia General, okay. Because this isn't the first incident between the two.
No, I know
She's
that.
been arrested as well, hasn't she?
Yes.
Okay. So tell me what happened. Y'all drinking?
Yes.
Both of you?
Yes.
Okay. I can smell alcohol on her, so I know I already knew that, obviously. But,
we've been going through a lot. Right now, I work at Ace right here, across the street. We're going through a lot, and they're about to shut down and whatnot.
the Ace?
Yes.
Okay. We just tell her not to come back.
Can I please have some water?
just wait. You can't drink that for right now? Oh, you can't come in here for right now. Okay, you're gonna have to wait. Give us a couple minutes.
Are you injured in any way?
No.
No. Shape back? No. Did she injure you today? Did she hurt you? Either manually, maybe emotionally, or whatever? Any physical injuries? No?
I'm the one. I'm always the one.
You're the only one saying that, you're not saying that.
I'm always the one.
But you're the only one saying that. Nobody here's saying that. But if you don't help me, how can I help you? If you don't tell me what happened, how can I help you?
That's my woman.
Okay. Sometimes that's what it is. Is that as much as you want to give me?
What's she saying?
George, I told you I can't say that. If you're not going to tell me what's happening, I'm not going to tell you what she told me to see. You know exactly what it is. I can't feed you information. Why don't you ever call us?
Why?
Why not?
Would you call you? Would you call?
Good. I've never been in that position, so I can't say.
That is your beefcake.
It ain't like that. My girlfriend's small, she's crazy, so.
I am. What am I gonna say? I'm actually wrong right now.
You're in the wrong right now?
Yes.
No matter what way you're saying you're in the wrong, no matter what way you cut it?
No way shape, or form, you know that I am.
I can respect responsibility, because most guys won't even take responsibility.
You're gonna take me in no matter what.
I think well, that's actually necessarily true. I take girls in jail all the time, but that battery all the time.
No, you're gonna take me in because I did the no contact.
You know what that no contact said?
Yeah, I'm fucked.
What is it?
I am fucked.
What are you not supposed to do?
Oh man, you're the one that took me to start.
I think it was better than all.
It wasn't me. I don't work this time.
They're not. They're a little similar. They look a little.
Our hairstyle's the same.
Yeah. Yeah. It's not the same guy. I promise.
No, I promise you, I would remember you. It's not me. But what did no contact order tell you? What did the judge tell you?
Was not certain. You know, you're in contact with her at all.
What about in relation to this place? Are you allowed to come back?
Oh yeah, no. Yeah.
Let me ask you this is you just have no place to go?
No, I've got a place to go. But
Your mom's place?
yeah.
They still over there about Twisty Street?
Yeah.
I do my homework.
Look, before you guys take me, can I get at least shoes?
What kind of shoes you want? You want some comfy ones, some fly ones?
Like those, get no fly ones.
These, I like these leather ones.
Get the blue ones, please.
This one right here?
Yes.
Which shirt you want?
And that black one right there.
This black shirt?
Yes.
You want socks?
Yes, they're right there.
You got a wallet? Phone?
My phone's downstairs.
Yes, sir. Have a wallet.
Oh, not that shirt.
There's another black shirt that's come. It's this one. Is that the other one? They're both inside out. I don't know.
The Ace? Yeah.
You like the Ace one?
Yes.
Alright, we'll do that one.
Can I, please, sir?
Please, what? What do you need?
So I can put them on?
Oh yeah, we'll handle that in a second. Let's get the shoes on.
Okay.
Where you say the socks were?
Okay. Yes.
Is black or white?
The white ones.
Okay. How many years have you got?
3 years.
3 years, really? Does it always behind us?
My phone's somewhere in the house. It don't really matter. I'll ask her.
Okay. Just step up right there for me, please. I just gotta get him to you. Are you okay? Oh, what? Oh, okay. Okay. Yeah, no, it's okay. Just a quick question. He's asking about his phone. Do you know where that be?
No, I don't know where it's from.
Okay. You don't have it in your vehicle or anything?
I do not.
Okay.
I have it in front of myself. Wait. I need my car keys.
Okay. They're not on here. They're inside the house somewhere.
You see them?
I haven't seen them, but they're in there somewhere. They're not on here because I had to search him before he got in the vehicle.
If it's supposed to ask, they ask him where the other keys.
Okay.
I only have one set.
Okay. You don't know where his phone is? Okay. She's asking about her car keys. She said we asked him, should we ask him right now?
He doesn't have that. All right, so.
Okay. Where is she? She's up behind your vehicle.
Yeah, do you want to take that or?
Okay, yeah. No, he didn't have anything to find. Can we take pictures real quick, if you don't mind? We're gonna take one overall?
No, they are.
Man, do you mind? Stay right there. Actually, a little more this way, but so we don't get the police car.
I heard his face to the line.
You said what?
You want me to shine a light on it? You close? No, actually. Okay. He didn't have anything in his pockets.
I'm gonna go this way one.
Yeah, no, absolutely. They're gonna be coming this way, so if you want. Okay. Yep. One dog's sleeping downstairs and one's in your bedroom.
Coming from the area, no one else seen or heard.
You have any other questions? I'm sure they're in there somewhere.
That's it for that exhibit. The state is at the pleasure of the court and the jury if we want to proceed.
Can the parties approach for a moment?
Wow. Because it's 5 o'clock and they did have a juror that couldn't stay past a certain time. I'm trying to get a good look at Sarah. This is not going, I guess, the way she thought. This afternoon, with sympathy for her, the way these are laid out, and they have not edited them. Well, based on everything, it does show in a different light that George also felt like he was abused. He also felt he was not being treated properly. Her girlfriend, he's been there every day as far as I know, Beck. He says, is her girlfriend there or did she? I don't think she ran. I mean, she was there yesterday and the day before, so. I don't know, but she does seem a little different. I mean, distracted.
All right, members of the jury, thank you so much for your attention this afternoon. The state still has some additional evidence to place into evidence. It's about an hour or so. Now, I know I got a note this morning, we can't stay past 5:30. So the question I have for y'all is, are you okay with staying until 5:30? Or do you want to go ahead and call it an evening at this point in time? I leave it to you.
Let's call it an evening, jury. You could do a whole hour tomorrow.
It's 5 o'clock. 5:03, exactly.
I say keep going. Does anyone reject?
If Laura can stay.
I think we can stay.
5:30, correct, though? That's my understanding. Okay, thank you, sir. All right, state, you may continue.
Commission published 21, which was P for identification.
You may proceed, sir. Are they audio or video?
It'll be video, thank you.
Are these redacted, counselor?
No.
Okay, thank you. All right, members of the jury, I have an instruction just to read to you with regard to states 21 that you just saw. I'm sorry, states 22, forgive me. Members of the jury, you have viewed and listened to video and audio recordings. The court instructs you that the recordings have been edited to eliminate irrelevant portions that would not add to your understanding of this case. The fact that the recordings have been edited should not concern you in any way and must not impact the way you viewed, listened to, and consider this evidence. Thank you. State, you may proceed.
States 21's DVD and its main folder is labeled a folder of attachments, and then there's a file labeled extraction going into folder attachments.
Welcome, buddy.
First file being published is img_0665.mov. Date modified metadata indicates 12/3/2019, 2:05 p.m.
Whenever you leave the house, just let me know where you're going.
And you're gonna let me leave?
Yes, just let me know where you're going.
And I get to leave the house?
Yes.
Exit?
Just let me know where you're going, so at least I know where you're at.
Anything else you'd like to add?
I love you.
So it's not yank me back in the house and sit the fuck down and shut the fuck up?
No.
Yank.
No. Just let me know where you're going so I know where you're at. So if you don't come back, there's no certain time. You don't have to come home at a certain time because I'm not. You're grown up. I just want to know that if it does surpass a certain time, that's like shit. Where's she at? I know where you told me you were going to be at. So that way I can go.
So I'm not allowed to have friends.
Yes, nobody said you can't have friends.
I need to go see Boo.
You can go see whoever. I just don't want you to go frolicking with male friends by yourself because you know what's happened already. You understand what I'm saying?
So I get to go see Boo.
Do you get what I'm saying?
I get to go see Boo.
I don't care about Boo. You can go to see Boo. Do you understand what I'm saying though?
Next video is a long file name that starts with 2A494, and it's the only one that will show up with that search. Date modified indicates 12/29/19, 12:26 p.m.
Hi. Fuck you.
I don't know what you're talking about.
Let's just tell everybody you got crumpled on the bed.
Crumpled? Crumpled. The word you're using is crumpled? Alright, so this is my jeez, you gotta put it all on my face, dude. I know you're filming me, but you gotta put it on. What the fuck is that? Stop.
Bum rush.
Yeah, you're bum.
I bum rushed you.
Yeah, whatever. Anyways.
What was the choice?
So the choice was to beat your ass or get my ass beat or whatever.
No.
Huh?
Twas.
Huh?
Twas.
Twat?
Twas.
I like twat. I've been trying to get twat from this woman. I've been trying. Hurting me. I've been trying to get some of that right there. She found some of the shit. What's going on?
So she's videoing this?
She's trying to film me, filming her, and blah, blah, blah.
I'm cooler than you.
Yeah, you are. You are cooler than me. You are cooler than me. She is cooler than me. She is beyond cooler than me.
Oh, I want to get this on film tape. Did I take you serious today?
No.
Did I take you serious at the beach?
No.
Then who was blaming on?
You.
This is giving me.
I blame it on you. Sorry. I apologize. Can I walk around this way and actually film it better? I I don't want darkness because you're not dark. Oh, there she goes. There she goes. What are you filming? You filming me filming you? You filming me filming you?
What's this thing you've done me wrong by?
Man, I watched porno. Wait. It stopped. What's up? I was watching porno. She don't like that. I'm not shrugging my shoulders or anything like that. Like it's not a big deal.
After you begged and pled and cried.
Yeah.
We trust you.
I know. I'm not shrugging my.
Say it. Begged.
Yes.
Cried.
Say it.
You begged.
I didn't. You did.
Well, whatever. I know. Okay. Yeah, I did.
Say it.
I begged and
Pled. And cried. For me to trust you.
For you to trust me. But again, I'm not
Did
sure.
you?
Did I watch porno again? Yes, I did. But
Man.
Good.
Wow.
Next is a video starting with 3BB0C. Metadata shows date modified 12/29, 12:36 p.m. of 2019.
Yeah. So you remember this?
Yeah.
So you remember this? Are you drunk right now?
No.
How much alcohol did you drink?
Enough to be drunk.
You're slurring your words. You're sleeping up against the door right now.
Yeah, because I want to be next to you.
Did I not tell you to not bother me?
Yes, ma'am.
So what is it you come up and do? What time is it right now?
Whoa.
It's 1:20 a.m.
Oh.
I haven't bothered you since then. I just go to sleep.
But didn't I tell you before at 9:30 to not bother me at all?
Yes.
Because why?
Yeah, so tomorrow.
Nope. Because I've been up since 4 a.m. since yesterday when you fucked with me.
Yes, ma'am.
I know how much vodka was in that bottle. And what's the bottle now?
Wow.
Kind of
I have never seen this before.
What does that mean?
One more drink.
Anyone else see these before?
The bottle's empty. I know how much vodka was in there.
Exactly.
And then for two people to have a really good time. And who drank it? I want it to be documented that I'm leaving you, which means that you're getting out. You're getting out. You're getting out.
Nobody's leaving nobody. Stop.
And the reason why you were even downstairs and weak enough to get drunk was because you don't give a shit about me. You don't listen to what I say. Special things that I keep on my front page of my phone so I remember to tell you about it because of how special and fun it is. I always bother you. I always bore you. You don't listen to me. Yesterday was my first day at work, remember? And I ended up 90% hearing about your day and 10% about mine.
You don't bother me or anything. So sometimes you just overwhelming. That's a problem. You overwhelm me.
By telling you about my first day at work.
No, dude, you just overwhelm me about every other thing too.
Listen to her tone.
So I'm overwhelming you by telling you about the fourth highest paid baseball player. That's a client of ours.
I'm not starstruck.
I don't even know who the guy is.
I don't need.
So the reason why, so you fully admit now that you didn't care and you did brush me off in the car, midway sentence, because you're not into baseball.
No, I didn't do that. I'm just saying.
I want to go to sleep. Go downstairs.
All right, yeah. I know.
I'm leaving you, and I'm going to try and cancel plane tickets.
No.
Because I don't do special things for people like you that are doing it. It's like, to me, after I asked you at 1:21 in the morning, I wanted to be asleep. I wanted to stay asleep, which is why I got into bed at 8:30.
She is totally gaslighting his
I told
ass.
you not to step foot in the bedroom.
I
So
told
what
you, you did.
Nonetheless, you're drunk. The amount of alcohol, I know how much was up. I know how much was in there. That's why I could smell you in the bed before you actually got me up. I can smell you from here. You're despicable.
I'm not despicable. I'm not even doing anything.
Leave me alone.
Okay.
You're not gonna remember shit. Okay.
Yeah, okay. Well, I'm not doing nothing right now.
Get away from me.
You got out of bed and went
Get
after
away
him.
from me.
What? What? What is he doing?
You do everything to me all the time. All the time. Heartache and pain is what you cause me. Heartache and pain.
Okay.
Keep going.
Please, George, just go
And I
downstairs
dare
and
you.
get away from her.
I dare you. I dare you.
This.
You get on your fucking little bike and go to fucking work tomorrow. Don't look at me. Don't come close to me. Don't touch me. Do you understand?
What do you mean?
As of this moment, and until I can get you out, get the fuck out of here. I dare you. Yep, look at it. Look, get away from me. Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder. I will scream bloody murder. Get away from me.
Nobody's doing anything.
I'm gonna fucking hurt you.
Nobody's doing anything. And you're filming it.
Let me go.
Nobody's doing anything.
I'm asking you, George, to get away from me. Please get away from me. Get away from me.
Yeah, I am. That was your function, dude. Malfunction. No, your malfunction is you, dude.
Okay, whatever you say.
Mm-hmm.
Whatever you say.
Please be smart, George, and go downstairs. Get away from her. She is totally gaslighting and antagonizing him.
Holy shit, the whole hallway just reeks like drugs.
Oh, and she follows after him.
First it's shit, now it's alcohol.
Oh my god.
Don't step foot in this bedroom. I can't even breathe. Like, it's disgusting. Like, it's disgusting.
Wow. Just stay down there. I'll bet you she goes after him. She can't let it go. There's something seriously wrong with her. She's gonna
I don't love you. I don't like you. I don't want to be with you.
Stop antagonizing. You know he's drunk. Let him go. Let him go downstairs. Just be smart, George. Go downstairs, please. Wow. Wow.
Next video starts 456. That's the only file that starts with that.
I have never seen these.
Date modified metadata, 12/29/2019, 4:04 p.m.
And I'm not gonna have no Hindenburg situation, no Titanic situation, okay? So it's gonna be a good day. Yes, I'm missing my mustache right now. And later on, everything's gonna go off. Truth, facts. Truth and facts. All of this is gonna be missing later on. We'll take another video again later on when it happens. Love y'all, whoever watches this video.
No, that's not approved.
The FDA says it's approved.
So it's gonna be a good day all day.
Yes, it is. Even when
All day.
I shave all of this
All
off.
day.
Yes, even when I shave all of this off.
All day.
It's gonna be an amazing day.
It's what time right now?
Shaboing boing.
It's at 9:30. 10 o'clock maybe.
Shaboing boing. That's what we're doing later on. Shaboing boing. You can stop filming now.
Not good enough.
It's gonna be a great day. Today's a great day to have a great day. Really.
I do think he already stands
Somebody come in
down
with a-
inebriated.
With the. Can somebody come in with
Two
the.
drunks.
Can you not?
Can you not? That's gonna stick with me.
Next file is image_093.mov. Metadata date modified 1/3/2020, 2:48 p.m.
It's 6:13 and I asked him not to play music. Because I told him that I'm just gonna go to shit.
Pretty probably.
What did she say? I didn't catch it, actually. Does anybody catch it in the chat?
Image img_0975.mov. Metadata shows date modified January 19th, 2020, 2:58 p.m.
The time.
Sirens. 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 Sirens and sirens and sirens. And this cop car.
How about you get an umbrella and call me Camille underneath it?
Yeah, how about we forget about that? No, we won't.
I'll never be.
No. How about we keep going on? Okay, how about this? When beautiful Lucas is here, we don't listen to none of that. I don't want to hear sirens. It's just beep, 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 all that, whatever. I don't want to listen to that. It's every single day. Beeping and we hear enough of it out here in reality.
Are you gonna be next tonight?
Yes. Yes. I promise you, I just
Go for a walk.
by myself.
Yes.
No.
Go for a walk.
No, I'm just gonna chill out. If that's the case, I'll just chill out. So much like this.
Don't ever be a woman.
How can I be a woman?
Don't ever.
I can't. But I can somewhat understand.
Don't ever.
I can somewhat understand. somewhat understand. I can somewhat understand, yes, where you're coming from. But when you have a child and it's like right now, this is too much. But we had a blast with him. Amazing.
Then you got out of sorts and pushed me, and you stole my phone and called Graham.
Why is it that I got out of sorts?
You pushed me.
I pushed you. I didn't push you. How do I get out of sorts all of a sudden? I don't want to hear it.
You drank too much, and you're upset.
Thanks so much.
Go get your fucktard shit.
What are you talking about?
Your retard paper.
What?
Don't hit women.
What?
Have I hit you? No. So where are you going with this?
I'm trying to resolve.
Tell me whatever else you have off. Okay. You can film me, take a picture of whatever you want.
You can tell you're on my
I'm not doing.
Do I ever get a blast? No, I don't.
I'm not doing anything to you.
No, I
Sarah.
never do.
I'm not doing anything to you, Sarah.
That's my name. Don't wear it out.
Sarita. I'm not doing anything to you.
Yet.
It's not yet. I will not.
Mr. J.
It is 5:28, and we have 3 minutes and 49 seconds of videos if the jury is capable of staying.
I got a thumbs up from the jury. You may proceed, sir.
Next image or movie is img_1011.move. Metadata shows date modified 2/2/2020, 11:42 p.m.
Hi, my fan. This is what happens when you're going upstairs to ask for where my car keys are. Because it takes you all the time. Where are my car keys? Where are my car keys? Where are my car keys?
Where are you at with that? What are you talking about?
No, they're not. You took them.
Sarah, I didn't see your car keys. Caleb,
Where are my car keys?
where they at? All the time. What in the world are you talking about? They're in the. They're there with it.
No, they're not.
Sarah. They're at the.
No, they're not. You took them. I watched you walk away with them.
Why would I take your freaking car keys?
Oh, you're not gonna curse now?
What are you talking about?
You took my car keys.
I didn't take your car keys.
You did.
Movie starting with file name B51, long file name. Metadata shows 12/29/2019, 4:04 p.m. modified.
You don't smoke in the
I'm
house.
gonna go to court and I'm gonna tell the judge, listen, my fiance has nothing to do with it. It's all my fault. We were both drinking and it got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. Never been in trouble in her life. She has a 7-year-old son. that she loves and cherishes.
A blind box interior.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She'll stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than where it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She especially
her. So please,
Wow.
if you can,
dismiss
this case,
Close.
drop it. She is not the type of person.
Good person.
Straight person.
Angel.
I know she'd be an angel. She's
Wow.
close to it.
Wow.
Best thing that has ever happened to you.
Yes, ma'am. I love you to death. And I hate that we're going through this.
Sonnet.
What?
And they did.
Good, I love you.
It does.
God will prevail, and He will take us out of this situation. Love you.
That'll be it for today, Judge.
All right.
Wow.
Members of the jury, it is 5:33 p.m. I thank you again for your time and your service in this matter. I'm going to give you another instruction before I discharge you for the evening. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, we'll see you again tomorrow morning here at 9 a.m. and 12 Alpha. Thank you so much.
Wow. Are you able to unmute, Mandy?
Kind of.
I wonder what the room's going to be like after the jury leaves. I can't even imagine how they're feeling right now, right?
Yeah, especially his family, seeing how like calm and agreeable he was with her.
Okay, take a seat. Thank you. State, how much additional presentation do we anticipate tomorrow, sir?
It's just reading from the 108-page PDF that was on that last exhibit. I haven't practiced reading it in front of the mirror, so I'm not too sure, but not too long.
Okay.
4 minutes.
40? Okay, all right. And then you'll be resting at that point in time, correct?
Yes, sure.
All right. Defense, what, if any, positions do you have at this point in time?
Judge, I don't think we're going to put on the silver bubble, but we'll think about it overnight.
Okay.
But I anticipate no.
Okay. I'll certainly let you stew on it this evening. I know it's been a long day for all of us. Where are we and how do we want to address the jury instructions? Because that is going to take some time.
I say, I was thinking we should have had the jury come at 10.
He's already told them 9.
Well, the other alternative that I can suggest is I can be here at 8. I can get here at 8 and we could start working on jury instructions at that point in time, at least so we can move forward through some of it. And then we can try to just move forward from there. I'm here for y'all. You tell me what you want.
Same time as starting charge conference at 8.
I mean, my worry is it's going to take us some time. And if we start at 9:40, and it's going to take some time to work our way through these jury instructions. I don't want them sitting back there for 2+ hours just hanging out. We can at least get ahead of that.
Could we let them know to come in later?
They're still here. I'm fine with that. State? They're gone. Okay.
What I'm hearing is maybe closing arguments start at 1.
Yeah, that's possible. That's possible if we can get through all the instructions. Mr. Henderson?
If I could compromise, how about 8:30, Judge?
I'm up at 5:30. It makes no difference to me. All right. 8:30 it is. We'll see you all at 8:30 tomorrow morning, and we'll start to go through the instructions. Anything else, State, we need to address? State or defense? All right. Thank you all very much. We'll see you tomorrow morning at 8:30. We're off the record.
Wow. Okay. Oh, Mandy, like, are you having flashbacks? Like, I'm having flashbacks? Like, that was rough.
I definitely am.
I can't, like, I didn't see any of those before. The one police video where she's yelling out to him and everything, and like, he's in the car just telling them, listen, she hits me all the time, and it always gets turned on me. I can't take it. I push her away, whatever. That's the one that turned me, that I started to notice like some of her behavior when I saw that video. And thought that perhaps there was some manipulation going on here, you know.
Well, we just watched how many hours of video?
I had no idea.
Yeah, and audio, and not once did we see him angry. Did we see him raise his voice? Did we see him upset? It was her.
Yeah. I don't doubt that she's been injured. I don't doubt that there's been some fight back. They are the same height. They're almost the same weight. I don't. Did you see how small he is?
Tiny, yeah.
And he is almost in every single one of them. He was inebriated, Mandy. If anyone has control in this relationship, it's her. I'm sorry. I just have to say it. It's exactly what I see. He does not have control of this situation. She has his birth certificate. She has his identification. He can't cash checks. She kick him out. She yank him. She pull him. She yank him. She pull him. Control. Puppet master. Like I mean, maybe I'm just, adding more to it now because I am having flashbacks. I mean, even from my own situations with male friends and my own brothers that have gone through similar situations, nobody believes it. Like, nobody wants to believe it. Did you hear him say, would you tell? Would you call? Like, would you call you guys? Like, you're only going to arrest me. Like, because the police is like, why don't you tell us? Like, call us. He goes, would you? I think it was a very volatile relationship. I do. I don't doubt that she's had injuries. I don't doubt. But I'm not going to anymore sit quiet when anybody says that Sarah Boone is a victim. She's a victim of a cycle, but she's not a victim of George. Nope. I don't believe it anymore. I just can't. Thank you. Record says I would be drinking too if I was with her, boo.
You're not wrong.
You're not wrong. I mean, I need a drink and I'm not even with her, okay? I just watched all of that and I need to be medicated. Like, that was rough, okay? and I'm like listening, and like and I'm going through the socials, Mandy, and I'm looking, and like the lawyering that happened today was epic. Like it was our legal system at its best. George Kraynick like really grabbed the reins and tried to solve the issue. I do actually see the point that Mr. Owens was trying to make, that he could not eloquently state or legally find an objection for. But I get what he was trying to lead to, but he just went about it all at the wrong way. And then when he was offered solutions, he just mucked it up. He totally mucked it up. He definitely. I just. Blah. I can't even talk. You see, I need medication. I don't know, Mandy. I also feel for everyone who's been in these situations, having to watch this. His family, people in the chat that have been in similar situations. I know you talk openly about the family situation that you're aware of. There was a man who had to go through this and would never say what was going on. I know with my brother, he would never say like what was going on until everything was all done and dusted. We're lucky that those people are still here. You know, we are, and that they got through. Hearing his words and knowing he's not here and seeing that, it just really hit me so hard. So hard.
Yeah.
Where do you think the jury's at with this?
Today wasn't good.
For Sarah or for
for Sarah.
Yeah, I think even Sarah realizes it. Man, Rocket Couch says early start tomorrow. I will be here since he said 8:30. I'm not sure it's going to be on camera, but I'll be here just in case it is, Couch, because I would like to hear the jury instructions back and forth. Sometimes they do, don't they, Mandy? But I don't think not that often. But he did allow them with Wardair. We did see all that. He did allow the camera. Yeah.
We've heard jury instructions in the Sarah Boone case, or not Sarah Boone, in the Karen Reed case.
We did.
In the Amber Johnny Depp case.
Mm-hmm.
Did we hear a jury instruction in the Letitia Stock case?
I'm not sure. We may. Yes, I think we did. I think we did, actually. I really think we did.
Yeah, so I think they tend to do that public so that
I think we may see it then, because he also let the camera stay on while they were picking the jury. Oh, just not on the jury. He let them like the questions so, and that was rare. You very rarely get to see that part. And so I'm thinking he'll tend to, if they're going to be in there, he's going to let it out. But we also have this other issue that I sent you the stuff on, I gave to the chat earlier, that the state has filed an inquiry. They want a private hearing with the judge and the defense team because of rumors about a media deal and about all this stuff about putting in extraordinary travel expenses to the state to get paid for, and this, that, and the other thing. She does deserve a good defense, but like they have a right to question, because if he filed officially papers as pro bono with the court, which he did, it's really against Florida State Bar rules to have any kind of deals with anybody on this case until after everything's over and done with. And then I don't even know how it goes. Like, you know what I mean? Like, I don't know in Florida if she can profit or not. We'll have to see. Well,
yep.
So, thanks for coming up. Yeah, I felt a little bit to hit somebody up here, but really, really tight. I wish Juju was in the chat, because I send her a link to tell her to come up here and talk to you. Although I don't think the way the three of us talk about this afterwards, I don't think we want it out here on YouTube actually after today, because I'm not feeling like politically correct right now with my language, to tell you the truth.
Yeah, and I'm in my office.
Yeah, I feel like I got the wind knocked out of me. I'm not involved in this case at all. I can just imagine what the jury feels like right now. Well,
Yeah, that was pretty heavy this afternoon. Any words or pictures and stuff of somebody that you know is gone is always, it's not fun.
No, it's not. And like, I don't think he was like the best guy in the world. I'm sure that things have happened. But you're right. I saw no aggression. You know, I I did see him like that one. He started to come towards her. You know, I think he was going to grab the camera or whatever. But like but then she would tell him, "Get away from me," and then she would follow him. And I'm like, this is. I realize it's a messed up relationship, but that was really looked like gaslighting to me. It really looked manipulative. It really looked pushy. Yeah. I can imagine if one of my brothers brought a woman like that into the house, man, I would be so like not the friendly one. I don't. There's no way he was ever going to be right about anything. That's the impression I get. Like no matter what.
Exactly.
I mean,
And
go ahead.
When she was
Sorry.
like, "Where's my keys? Where's my keys?" And he's like, "I don't know where your keys are. I don't have your keys." It just was so triggering, even for me, because drunk people misplace things. And then it's your fault. You know what I mean? So I don't know.
I did find it quite ironic that the person who drinks every day, who is a known alcoholic since the birth of her child, is actually getting on him for drinking. They both drink. I mean, they are alcoholics, absolutely. He definitely has an issue. Not once in any of those appearances was he sober. He seemed completely inebriated. No matter what time of day it was. But then again, so did she. Quite often. I don't think. I mean, there is some pushback that the defense can do, and I have to applaud like Mr. Owens for saying, "Let me think about it overnight," because I'm sure he's not prepared to do a serious rebuttal, but like I'm sure he wants to because he realizes how damaging this is. But he has to actually drill down and do the work. He has to attack certain issues of the video, certain testimony of the expert witness. He can't just come in there and do a narrative like he does. Rebuttal. You have to go to a point. You have to go to an issue. You have to go to some evidence or some statement that was made in testimony. You can't just come in there like swinging for nothing, you know?
Now all they can really rebut is the doctor that was on the stand today.
But what are they going to rebut?
Exactly.
You know, I don't really see what he can rebut. He was given the chance to do deposition. He actually had cross. He was even, rarely this happens, but even given the opportunity to recross after the state did a redirect. That, you know, that doesn't happen that often. They have to have an issue. But the judge, fully aware that the defense has an issue with the testimony in general, gave him that opportunity, which was declined. This judge is so smart, so smart. He's in the long game. He's looking ahead. Like he definitely is not leaving off anything for appeal. He is dotting his I's and crossing his T's. If they have to look at it for appeal, it's going to be pretty cut dry where he was coming from and what he used to make his decisions. He's being very clear about his interpretation of the law back and forth, you know, to his credit. But I really, what did you think about Owens? Like, did you hear the tone from Judge Kraynick at one point with Owen?
Like, yes.
I mean, he had pushed it. When they came back from lunch and he started all over again, I was like, dude, what are you doing? He's already decided. I mean, oh my God, he's already decided. He gave you the case law. You're coming back. You're arguing the same thing.
Yeah. Anywho, I should probably work. So
You go to work. I'm going to get out of here and go find me a soothing beverage of some sort. I don't know if it's going to be alcoholic, but it better be soothing, whatever it is. I need to be soothed. I'm going to, thank goodness I've got a box of chocolate. I really think I'm just going to put my feet up and eat a chocolate bar. Like, I'm done. I'm done for the day. I really am. Record said that any sympathy that the loony might have gotten has been completely destroyed. He has completely he was completely sloshed, and not once was he really violent with her. She was the aggressor the whole time. That's pretty much what we saw. And manipulative, if not being aggressive, definitely being taunting, manipulative, gaslighting. Yep. Good night, Mandy. Have a great afternoon, the rest of your afternoon at work. I hope it goes well.
Thank you.
I will see with you, me, and Juju got a hookup. She wants to talk. We'll figure something out. And you're welcome anytime. You want it, you just message me. I'll send you a link anytime. Tomorrow's going to be lit, man. Tomorrow's going to be.
Yep.
Closing statements are going to be like, I'm looking at shootout at the corral, man, for closing statements. Like, I don't even know. I might need an IV. I don't know. This is getting wild. All right. Good night, boo. Good night, you guys in chat. I will be here early in the morning. I will take a little bit of break, and then I'll timestamp for all of you that want to go back and find out who did what when. I'll do the best I can. I don't even know if I can untangle all of that happens, actually. But I'll do my best and get it on the video, and see you all in the morning.
Night.
Good night, everybody. Oh my goodness.